All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 7th. We have 11 bills on the docket and we are 4 hours behind schedule, so that's great. All right, we will start off with Senator Benson, who I see is here. Welcome, Senator Benson, with Senate Bill 603. We'll then go to 579, 532, 485, 593, 570, 464, 757, 762, 504, and we'll wrap up with Senate Bill 845. So without further delay, Senator Benson, you're up. Welcome.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. I want to thank you all for the opportunity to stand here to talk about Senate Bill 603 to solicit your support. I just had a wonderful conversation out in the hall with the Attorney General, Anthony Brown, and we're really trying very hard, wonderful friends, to work on a bill that is absolutely so important to the little people. You all know my reputation down here. I am very much committed to doing whatever I can for the little people. And this bill is basically the reason why I have requested your support on this bill. And that is the reason why this bill is before you. So good afternoon once again. I am here to present Senate Bill 603, Real Property Residential Leases, Fee in lieu of deposit. This legislation is for the purpose of helping stabilize the economic impact that occurs when tenants, when trying to move into a new property with a landlord. A security deposit is a sum of money that a new tenant gives to their landlord or property management company in addition to their advanced rent payment. As we all know, security deposits can be a sizable fee, which can prevent potential tenants from renting housing. Today, tenants in Maryland must pay up to 2 months' rent for a security deposit, in addition to the first month's rent. On average, Maryland rent is approaching $2,000 a month. Renters may need approximately $5,000 before moving into the establishment. Marylanders need a new policy that can help them get affordable access to housing, especially those without the financial means to afford hefty security deposits due to extreme living situations or financial strains. This bill's purpose is to allow property owners the option to offer the tenant to pay a monthly fee that would waive the security deposit. The tenant would have the option to accept that monthly fee or pay the traditional security deposit. Let me repeat that. The tenant would have the option to accept that monthly fee or pay the traditional security deposit. This alternative can help reduce barriers for renters who may have difficulty obtaining the funds for a traditional security deposit. This fee is particularly beneficial for low-income renters, young adults, and individuals who have experienced financial hardship. In addition, this legislation provides many tenant protection provisions, including disclosure of the cost of the fee. The security deposit ensures that the fee is always optional for tenants, permits a tenant to opt out during the lease by providing a security deposit, and offers the same inspection requirements required for security deposits and includes penalties for non-compliance. Additionally, tenants will be less likely to be behind on rent payments during their time at the residence due to the significant security deposit fees in place currently. that can cost up to 2 months' rent in addition to the first month's rent that a tenant must pay. This can set tenants back a total of 3 months on payments if they are in difficult financial situations. This optional security deposit alternative is permitted in 46 states, but not in Maryland, providing states with relief for their citizens. In reality, most people are living paycheck to paycheck, and a large security deposit is not helpful to those who are in dire situations, simply looking for a place to live. Therefore, I am respectfully urging this committee to give a favorable report to Senate Bill 603. Thank you very much.
Thank you very much, Senator. And Mr. Dews, if you'd come up to the podium, please. Thank you.
Thank you, Senator Benson, and Mr. Chair, members of the committee. Christopher Dews on the record for Cornerstone Government Affairs here in support of Senate Bill 603. I think the senator actually already summed up a lot of the talking points that I was going to use here. So I'll be very brief. As was already mentioned, the average rent right now in Maryland, and it is increasing, is about $1,700 a month. And the way security deposits currently operate is that you can double that when you're trying to set a security deposit for bringing people in. So that's about a $3,400 barrier that most an increasing amount of individuals cannot afford when trying to get access into housing. We know that right now the cost of housing is going up, not just for the rental market, but generally speaking with regards to houses. So we see this as a phenomenal option, an opportunity that individuals can take advantage of to get past the barrier of the security deposit. I want to be clear about those key words there, and our client here can speak more to the details of the bill, but it is totally optional. And at any time, an individual can opt out and just pay the regular security deposit to the landlord. So this is ideal for the individual who is maybe younger and doesn't have access to that level of income, maybe an individual who has suffered from a divorce and just has to move very quickly and just doesn't have a safety net financially that they can use to be able to get entrance to quick housing. And I just lastly want to say that a survey was done, and almost 70% of the individuals surveyed did say that this is a good idea to have, and only 41% said that they would actually use this option. So I just want to put that out there to just continuously highlight that this is not forcing individuals to take this on. It is an option just to make rental housing more affordable, and I urge a favorable report. Thank you for the time.
Mr. Chair, members of the committee, my name is Christopher Grimm, and I appreciate the opportunity to testify today on behalf of Lease Lock in support of Senate Bill 603. I got to stand on my tippy toes to see the time. Can everyone see me? I'm always worried behind the podium that you can't. I'll be brief. Lease Lock provides insurance for a landlord against a tenant's failure to pay for damage or lost rent. That's what a security deposit does. It's there to protect the landlord. It does not protect a tenant at all. It is protection for the landlord against a tenant's failure to pay for damage or lost rent. Lease Lock is an alternative to that security deposit to provide that same protection, or in some cases, greater protection for a landlord. There are several consumer protections that do not currently exist. Even though we're not operating in the state on this model of landlords offering a fee to waive a security deposit, landlords could buy insurance from Lease Lock today. They could increase the cost of rent to cover the cost of Lease Lock today. And none of the consumer protections that are in this bill would be covered under that arrangement at all. And the tenant would not have any choice between higher rent or security deposit. This bill gives the tenant that choice. It says your choice is a fee to waive the security deposit, knowing that you're responsible for paying for any damages or unpaid rent at the end of your tenancy, or you pay a security deposit with the understanding that a landlord can withhold that money for any damages. The benefits for the tenant are threefold. One, not having to pay that large upfront security deposit. That is a barrier to housing and is just not a good system for some tenants. Two, the tenant can opt out at any time. And third, Instead of a tenant having to prove that a landlord wrongfully withheld their security deposit, the onus is now on the landlord to prove that the tenant owed that money. Thank you, and I urge everyone to support the bill.
Thank you so much. Questions for this panel or the sponsor, Senator West?
Thank you, Mr. Chairman. So I've been trying to read the opposition as the testimonies come in, and I've heard the bill before, so I know what the bill is all about. It seems on surface to be a great idea, but the Public Justice Center has given us a litany of problems with the bill, and by my count, it's I think 6. And then Economic Action Maryland has given us 4 problems, and most importantly, the Consumer Protection Division of the Office of the Attorney General of Maryland has a long objection. And just let me read one sentence toward the start. It says Senate Bill 603 would permit the landlord to charge a fee in any amount payable at any interval that is wholly non-refundable, would permit a landlord to contract with an insurance provider that is not licensed by the Maryland Insurance Commission, and would encourage insurance providers to seek subrogation from tenants for claims paid to their former landlords. And it goes on from there. So I appreciate that the sponsor of the bill spoke to the Attorney General himself out in the hall, but it sounds like the Attorney General's Consumer Protection Division is very hostile to this bill. And finally, the Maryland Judiciary is in opposition. So I don't want to go through all these things today, but would it be possible for you all to take a look at these 4 oppositions and provide us with a written response? How would you respond to these objections so we can take a look at it when considering the bill?
Absolutely, Senator. We're happy to do that. Some of those concerns are addressed in the bill. For example, the first issue raised in the resident's office.
No one come to the podium.
Come up top.
Sorry about that. Happy to address the concern, Senator. Some of them are already addressed in the bill. For example, a landlord can only charge a fee that is essentially the cost of insurance plus any administrative costs or additional costs, right? If you're a landlord,
Is there any cap?
there is no cap. It's based on what his premium for his insurance would be. No one is allowed to sell insurance in the state of Maryland without the proper licensing or the proper structure. So that is already addressed. The bill does not create any new right of subrogation. Subrogation is a long-standing insurance practice where the damaging party is always responsible for the damages that they cause. If I dent someone's car in the grocery store parking lot and their insurance covers the cost to repair that car, I'm absolutely getting a bill from their insurance company because I caused the damage. So there are some things that are addressed in the bill. There are a number of things we're more than happy to try to find compromise on, and think we have some amendments that we could use to address from what I've seen, in the last couple of hours since I've seen the opposition testimony. And then other things that I'm not sure, for example, subrogation, right? That's an existing concept. Surety bonds, which are another security deposit alternative that is codified in statute, has the right of subrogation as well. And we are just sort of looking for equal footing as them.
Okay, well, I'd appreciate it if you could give us those written comments.
Absolutely, sure.
And be aware that we don't have an awful lot of time. It's like we got an hourglass. Remember the Wizard of Oz? And the sand in the hourglass is running out.
Yep.
So please get us those comments quickly.
Within the next 24 hours.
Thank you.
Thank you.
If I could just.
I think we try to do 1-to-1, but please quickly.
Okay. Yeah, no, I just, this was like literally 1 second. I just wanted to highlight for you, Senator West, we are operating, least like it's operating in 46 other states. Just wanted to continually highlight that this is something that already exists in other states and is operating just fine without any necessary issues and casualties. And conversations have been happening with every member of the opposition that you have already discussed. Those conversations have happened and are ongoing. And we will definitely, we would love a sit down with the opponents and just to sit down and hammer this out so we can keep this conversation moving and get this on where it needs to be. Thank you.
And I have one last question. I know we're running behind today, but it strikes me perhaps that there is a similar, although clearly not the same product on the purchase side of things. So if I want to put 5% down instead of 20% down? Is there a standardized product available here in Maryland that is analogous to what we're talking about here today?
So there are a number of security deposit alternatives that currently exist in the marketplace. I'd mentioned surety bonds as another that has a codified right of subrogation. There are guarantor services where essentially a company will act as a cosigner on a lease. And similar to if you had a parent or family member co-sign, if there was a failure to pay rent at the end of your tenancy, the co-signer would be responsible to pay. In all of those circumstances, all of those companies have the right to pursue the tenant for anything they pay to the landlord. And to my knowledge, they all do. LeaseLock as a company actually doesn't pursue the tenant because it doesn't make business sense.
I apologize. I didn't mean to be coy. I just wanted you to explain briefly how this is or is not like mortgage insurance for those of us who are, who have experience on the purchase side of things.
It's a great question. Wish I realized that was your question at first, because it functions very similar to PMI, right? A 20% down payment on a house is the biggest barrier to homeownership. And for folks who are looking to buy a home who don't have that amount of money, they have the option to essentially pay more with their mortgage every month. They're not insured. That's the bank's insurance because the bank is taking on greater risk by not requiring that 20% down payment. This functions exactly the same way. Instead of PMI, it's lease insurance for the landlord because they have greater risk because they don't require a security deposit.
Thank you so much. Any further questions for this panel or for the sponsor? Thank you, Senator Benson. We always enjoy having you here. We'll now move to the opposition. Matt Hill.
Thank you so much.
Marceline White, and then we'll have one virtual after those two. Thank you.
Oh, yeah, no, we both brought them up to the.
Good afternoon, Mr. Vice Chair, members of the committee. Matt Hill, I'm attorney at Public Justice Center. And I just want to first acknowledge and thank Senator Benson for her advocacy on behalf of tenants and consumers and safe, stable, affordable housing. And totally agree with her that security deposits are a huge barrier for people who need to move. And people do need to move. They need to move out of uninhabitable conditions. They need to move sometimes to get out of a situation involving domestic violence. And the security deposit is a major barrier. So we greatly appreciate the intent of this bill and thank her sincerely. Ultimately, though, in our judgment, there are better ways to address this issue. For instance, my understanding is, and I haven't done enough research on this, but some jurisdictions you can require the landlord to offer the tenant an installment plan. So they can pay the security deposit over 4 installment payments. That would address many of the same concerns without introducing what I think is a somewhat complex financial product that will be easy for tenants to get into and unclear exactly how they get out. So as Senator West said, there are a number of specific things addressed in my testimony. I'll just go over the first 3 on the list. Whether or not these payments are rent. So the fee in lieu payment, is that rent? If it is rent, then if the landlord believes it's rent, then they can try to evict the tenant if that fee in lieu payment is not made. The cost, this was also brought up earlier. I just disagree. The language of the bill as it exists, and we had the exact same debate last year, but it hasn't changed, is that it allows landlords to charge, in addition to the cost of the insurance, some additional sort of administrative expense. What does that mean? I don't know. And I don't want this to become another profit center for landlords in terms of fees. Last year, again, the bill was better last year in this way. It limited the landlord to charging only 1 month of rent for security deposit. That restriction's gone. I think landlords are going to take this bill and say, well, now I really want tenants to pay this LeaseLock product instead. And so now I'm gonna make it a 2-month security deposit, and that will incentivize them to take the LeaseLock product. Thank you for your time.
Good afternoon. Vice Chair and members of the committee. My name is Marceline White. I'm the Executive Director of Economic Action Maryland. Economic Action Maryland works on economic rights, equity, and housing justice through research, education, and advocacy. And we are also here in opposition to Senate Bill 603 and request an unfavorable report. We do appreciate all of the work and the ongoing championship Senator Benson has for low-income tenants and low-income Marylanders across the state. And we echo her concern about the cost of security deposits. But we believe this is the wrong approach for a number of reasons. You have my written testimony. I'm actually going to talk today a little bit about some of the business concerns as a business model. LeaseLock leverages AI and they use that to analyze historical financial data to customize by asset and continually monitor ongoing risk. That's from their work. Our concern with that is that this may mean that customized coverage may lead to different pricing and cost for different kinds of tenants by the use of these algorithms. Algorithms have been shown to produce and reproduce bias, and this may reinforce and exacerbate existing inequalities. We also know that LeaseLock embeds their software in property management systems. We believe this could reduce consumer choice in the long run and lead to market concentration. If it's embedded in the software, it may limit options for consumers to use a traditional security deposit. This is also funded by venture capitalists. The funding is risky, and it's clear that if the company went belly up, tenants would lose the fees they've paid and then be required to pay a new security deposit on top of that, which we think is a bad deal overall for tenants. And again, we know for these reasons, we think while we agree with the issue, we believe this is the wrong approach. We're happy to look at alternatives and talk to folks, but we urge an unfavorable report on Senate Bill 603. Thanks.
Thank you so much, Ms. White. We're going to take our virtual testimony and then we'll take questions for the opposition. Kira Wilpone-Wellborn, and I apologize if I mispronounce that, from the Attorney General's office.
Yes.
All right, we can see and hear you. Welcome.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chairman, and members of the committee. My name is Kira Wilpone-Wellborn. I'm an Assistant Attorney General with the Consumer Protection Division of the Office of the Attorney General of Maryland. As you've heard others report today, the Consumer Protection Division is in opposition to Senate Bill 603. We're in agreement that there needs to be alterations and alternatives to the current security deposit regime in Maryland to increase the accessibility of housing for renters. However, this fee in lieu of a security deposit is not the appropriate model. As you've seen in our written testimony, this fee has little, if anything, to do with a security deposit. Instead, it is insurance for the landlord that the tenant pays for. And it doesn't prevent a tenant from paying a security deposit. In many circumstances, as outlined in the bill, there is certain circumstances in which the tenant would ultimately have to pay a security deposit. So this isn't saving tenants any money. Instead, it's charging them a never-ending fee that will never go away and that does not provide the financial protections that tenants deserve. Additionally, there are several provisions within the proposed bill that deviate from protections found in 8203 with regards to security deposits and surety bonds. For example, this bill requires a pre-notice inspection of a 15-day certified mailing for tenants to be able to document damage that existed in their unit before move-in. This could result in tenants paying for damage at the end of their tenancy that was not caused by them. And the only way to challenge that pursuant to this bill is to have a debt collector come after them and challenge it in court. This does not save consumers money. This does not provide protections that tenants and consumers deserve when they're seeking housing in Maryland. And for those reasons, the Consumer Protection Division seeks an unfavorable report. Thank you.
Thank you, Madam Assistant Attorney General. Questions for the OAG or the opposition to the bill? All right, seeing no question, that concludes the hearing on Senate Bill 603. My thanks again to Senator Benson. We'll now move to Senator Hayes. Thank you for your patience, Senator Hayes. The bill is Senate Bill 579, and feel free to bring your panel up with you, Senator.
Good afternoon, Mr. Vice Chair and committee staff and two committee members. I'm Senator Antonio Hayes from the 40th Legislative District in Baltimore City. It's a pleasure to be here with you this afternoon. Senate Bill 579, predatory exclusive listing agreements are proliferating throughout Maryland. As Marylanders work to recover from the financial hardships of the pandemic, certain real estate brokers are taking advantage by offering relatively small amounts of cash for exclusive listing rights. Often homeowners receive only $400 to $600 in exchange for a 40-year exclusive listing agreement. Not only is this extremely unequal, but there are high costs in order to get out of the agreement. MV Realty, or brokerage involved in this practice, charges a termination fee equal to 3% of the home's value secured by a lien on the property. The Baltimore Banner reported in October 2022 that roughly 400 of these agreements have been recorded in the city and county land records across Maryland, and likely more have been signed but not yet recorded. Under Senate Bill 579, exclusive listing agreements entered into on or after June 1st, 2023 can only be effective for a period of 1 year by law. This will help protect Maryland homeowners from predatory schemes that take away their rights as homeowners for the disproportionate amount of compensation. We need legislation such as Senate Bill 579 to regulate these highly pervasive agreements that are exploiting homeowners and misleading them into decades-long commitments that could cost them a lot in the end. Mr. Vice Chair, there is some testimony in the bill file from the Maryland Attorney General. They believe the legislation, at least the definition far as residential property doesn't go far enough. They have some suggested amendments to make the category a lot broader. We have no objections to that. There's also testimony in your bill file from the Maryland Realtors Association, providing essentially some information as that relates to some of the things that they've seen in other states as it relates to whether these are homeowner benefits or actual license agreements. And so we will continue to work with them in short order, both the AG's office as well as the Maryland Realtors in this committee. But essentially, this is important legislation that protects homeowners here in Maryland that has a history of disproportionately affecting communities that already face enough challenges on their own. And so with that, Mr. Vice Chair, I urge a favorable report on Senate Bill 579 with possible amendments to be coming forward to you.
Thank you, Senator. Unless you need to get back right away, we'll take the panel and then
Yeah,
questions
I'm good.
afterwards. Please.
Great. Oh, one second.
This is great.
Yeah. Good afternoon, Vice Chair, members of this committee. And I'd first like to thank Senator Hayes for presenting this bill. For the record, my name is Greg Morgan. I'm the Commissioner of the Division of Occupational Professional Licensing for the Maryland Department of Labor. On behalf of the agency and the Maryland Real Estate Commission, we're here today to support Senate Bill 579. As Senator Hayes alluded to, currently it's legal for a licensed brokerage to provide a cash benefit to a property owner and to enter into a contract where the property owner agrees to sign a future listing agreement with the brokerage if the property is ever listed for sale, even many years in the future. It is also legal to have the contract that it runs with the property and can be recorded against the deed. While the homeowner, oftentimes a trusting senior citizen, enticed by immediate cash, enters into a contract that can have a duration, oftentimes up to 40 years. If the homeowner passes and the family's unaware of this agreement, lists the property for sale, begins the title work, and it's discovered in the title search that there's this lien on the property, the estate of the family or the homeowner is then responsible for not only the listing agreement that they entered into, but this lien, it could be anywhere from 3 to 7%, whatever is agreed upon at the time of the agreement. Licensing and boards and commissions, such as the Real Estate Commission, we're here for consumer protection. Right now, this loophole, this ability does not offer any consumer protection. This current process does not benefit the consumer at all. It benefits the brokerage. So we support this bill. We support the 1 year limit, and then whatever amendments you're talking about, we'll certainly take a look at. Again, thank you, Senator Hayes, for sponsoring the bill. And for these reasons, the department respectfully requests a favorable report for Senate Bill 579. And I'm certainly here to answer any questions.
Thank you, Mr. Morgan. Any questions? Are you Mr. Director Higgs?
I am.
Okay, why don't you come up and then we'll take questions afterwards if there are any.
Thank you very much, Mr. Vice Chair, members of the committee. My name is Michael Higgs, and I am the Director of the Maryland State Department of Assessments and Taxation. SDAT supports Senate Bill 579. This bill adds critical consumer protections by limiting exclusive listing agreements to 1 year. While the department recognizes the importance of reasonable exclusive listing agreements, the department is concerned with recent cases of excessively lengthy terms of such agreements. For these reasons, SDAT urges favorable vote on Senate Bill 579. Thank you.
Thank you. That is everyone signed up in favor of the bill. Any questions for the senator or the panel? All right, seeing no questions.
Information.
All right, seeing no questions for this panel, thank you very much. We'll now bring up Ms. May from the Maryland Realtors, not retailers, testifying for informational purposes.
Thank you, Mr. Chair, members of the committee, Lisa May with the Maryland Realtors. And these agreements are exactly as Senator Hayes and Commissioner Morgan explained. They are recorded in the land records as a lien against the property. And not only do those survive the individual who took them out, it can also impact a homeowner when they look to refinance, because oftentimes that lien would need to be settled before a refinancing could take place. What we have shared in our written testimony and then also with the sponsor is that these agreements are being investigated by the attorneys general in several other states. And in the responses to those investigations, the companies that provide these homeowner benefit agreements have expressly stated that these are not listing agreements at all. In fact, they are, whether you call them homeowner benefit agreements, whether you call them NTRAPs, as the American Land Title Association has called them, they are essentially an agreement to one day enter into a listing agreement. So if it is the will of this committee to get at this practice, we believe that the term exclusive listing agreement is not the proper one for this bill. We don't believe that it will get at these 40-year agreements. So we have suggested some national model language that the American Land Title Association has put together as perhaps an alternative. And with that, I'm happy to answer any questions you may have.
Thank you. Any questions for this witness? All right, seeing no questions, thank you so much for your testimony. That concludes the hearing on Senate Bill 579. Thank you again to Senator Hayes. We'll now move to Senate Bill 532. Senator Quarterman is here. Thank you for joining us, Senator Quarterman.
Good. All right. Thank you, Vice Chair Wallstreicher, members of the Judicial Proceedings Committee. For the record, Senator Paul Quarterman, District 2, representing Washington and Frederick counties. Thank you for the opportunity today to present Senate Bill 532, overdosing and public prohibition. Across our state, our communities continue to experience a high level of drug abuse. And while we've made a concentrated effort on substance abuse awareness and access to treatment, we continue to have individuals who have not connected with those resources that can lead to a path of greater success. These are the individuals that continue to overdose in our public places, our restaurants, in our libraries, et cetera. At our library alone, we've had 7 overdoses in just the last 12 months. And as in many communities, often these same individuals are visited by our first responders multiple times per day. And once assisted, the majority of them are simply released. This legislation will provide an additional tool for our state to utilize in providing the next steps for individuals, as this bill would add public overdosing to the disturbance of the peace ordinance. Currently, that ordinance carries a penalty not to exceed 60 days in jail or a fine not to exceed $500 or both. However, what this bill would do, first, it would require an individual to appear in court. And secondly, it would provide the option of the referral to drug court if your jurisdiction has one. If your jurisdiction does not have that, it would offer a path towards substance abuse treatment as opposed to jail or a fine. Those are familiar with drug courts that exist around the state. They're aware of their more structured environment and their paths of greater success. The goal of this bill is to connect substance abuse addicted individuals to the services that they need, while at the same time relieving some of the pressure that is placed on our first responders on a daily basis. We understand this is a complicated and complex situation, which also may need the additional collaboration with some other stakeholders. However, at the same time, it's important to note that this collaboration moves forward because what we are currently doing just simply is not working. We thank you again for your consideration, and I respectfully ask for a favorable report on Senate Bill 532.
Thank you, Senator Quarterman. Questions for the sponsor? All right, seeing no questions, thank you once more, Senator Quarterman. Appreciate your being here. We'll move to the opposition. Madam Secretary and CCOT Owen O'Keefe. Madam Secretary, the floor is yours.
Thank you. Thank you, Mr. Vice Chair, Committee. I'm Emily Keller. I am the Special Secretary of Opioid Response, and I'm here today to oppose Senate Bill 532. Fatal overdoses in Maryland are decreasing faster than the country as a whole and in many of our neighboring states. This is in part because of collaborative efforts within Maryland, as well as laws you've passed, like the Good Samaritan Law, that protects a person from experiencing an overdose from certain criminal charges. In studies, including many by the NIH, it has been proven that forced treatment does not work. In fact, it can increase the likelihood of overdose. Regarding criminal charges, a study from NIH found that individuals being released from incarceration were 12.7 times more likely than the general population to die in the 2 weeks following their release, with drug overdose being the leading cause of death. There is a perception that drug courts would be a choice to participate, but the threat of incarceration as an alternative means is truly not a free choice for most. Furthermore, when drug courts are not present or there is a wait list, referral to treatment is an alternate option under the bill, which we've already discussed doesn't work. The result is different legal process for people who have experienced an overdose based on their location. Maryland believes in helping every struggling person. I can promise you, no one woke up today and said, you know what I want to do? I want to overdose on a public sidewalk. And as far as we know, this person may need wraparound care, perhaps food assistance, mental health services, stable living conditions, access to quality health care, dignified employment, transportation access, affordable childcare, etc. These services are how we lift people up. Without the resources dedicated to these services, we cannot drag our fellow citizen from a hospital to a courtroom and force them or expect them to heal. We do not need to further stigmatize or criminalize substance use disorder. I urge you to provide an unfavorable report.
Thank you, Madam Secretary. Madam Secretary, is this your first time in front of us as Secretary?
It is.
Congratulations.
Thank you.
We're glad to have you. Whoever would like to go next.
Good afternoon, Mr. Chairman, members of the committee. I'm Ann Seacott, testifying on behalf of the National Council on Alcoholism and Drug Dependence, the Maryland chapter, in respectful opposition to the bill. We appreciate that, people are looking for additional ways to try to help, but we think that this bill on balance creates much more harm than good. We believe that this bill would take us backward in our recriminalizing this public health issue instead of continuing forward. We believe this would significantly undermine our Good Samaritan law, which really tries to encourage people to not be afraid to call for help when someone's life is at risk. We're going to be hearing more about that later this week. It assumes, as the special secretary said, that drug courts work for everybody, and that there's room for everybody who would even want it for drug court. We think that what's going to happen is people will just be driven to more secret places, more places indoors, and we're going to have more people die. And that's not anybody's intent, but we think that that's what the result of this bill will be. And we think that that's, all the things that the secretary mentioned are the good kinds of policies and programs we've developed over the years. are the things that we should be looking toward. And I think that that's partly why also the House cross file of the bill was withdrawn. So we continue to want to work with you all and the sponsor on finding those things that are public health interventions for this public health crisis.
Thank you.
Surprisingly, I'm not Owen O'Keefe, but I'm here on his behalf and on behalf of the Baltimore Harm Reduction Coalition. Good afternoon. My name is Harriet Smith. In 2021 alone, 2,824 Marylanders died of overdose. I get why everyone here wants to do something about that. I do too. We all do. And you and your colleagues have taken steps to slow the crisis by making naloxone more available, by making sure that people have access to evidence-based treatments, et cetera. But SB 532 is not one of those helpful steps. There are two facts that I would like you all to remember, if nothing else, from this. And I know these to be true from over 6 years experience training lay people on how to respond to a suspected opioid overdose. Right? Using naloxone. That's what I train people in doing. But it's not just me. Tons of research backs me up on this. Okay, the first thing is scared people don't get help. I'm not talking about urgency kind of scared. I'm talking about real deep fear, fear of punishment, fear of arrest, right? Those things do not lead to people getting assistance. They might be forced into assistance, which they begrudgingly sit through, but that's a really different experience and not one that actually helps. The second thing to know is that people overdosing in isolation without others around them are likely to die. A hugely important aspect of the training that I offer and that BHRC offers and so many others across the state offer is that after you revive someone with naloxone, it's important to figure out where are they going to be for the next few hours, right? If they're not going to go with EMS to be in the emergency department, can they be around someone they trust in case they have a secondary overdose, right? And if they can't be around someone they trust, can they at least be in public? Because there, at least they have the chance that someone could respond to their emergency. So in summary, people in isolation are more likely to die, and people do not get help because they're fearful. They get help because they want to. So I respectfully ask that you issue an unfavorable report. Thank you so much.
Thank you for being here. Senator West has a quick question.
Thank you, Mr. Chair. So, Madam Secretary, could you step back up to the podium so I could ask you a question? When I read this bill, I assumed that what was going on was an attempt to enable people to literally lay hands on someone who is experiencing a drug overdose to try to help them. And because, but for that, if I were there, I would be concerned if I were to so much as touch that person, I might get in trouble in some way without invitation. So are you saying that that's not why that's not the effect of this bill, and it's going to have a deleterious effect rather than encouraging people to render assistance?
Well, the Good Samaritan law does protect you for helping someone who is experiencing a drug overdose. So if you were to administer naloxone or try to help them, you are protected by the Good Samaritan.
So
law.
it'd already be protected.
Correct.
Okay.
Correct.
So that's not why this bill was adopted.
Yeah, I think the intent of this bill is to try to force people into treatment or to a drug court program to try and solve the substance use crisis we're facing. But unfortunately, forced treatment, it simply does not work.
Okay. Thank you so much for your answer. You've clarified my misapprehension. Appreciate it.
Thank you, Senator West. Thank you, Madam Secretary. Any questions further for the Secretary or the opposition? All right, that concludes the hearing for Senate Bill 532. I would just mention this is not directed at you, Ms. Smith, but in general, and this is an important issue. We are like the old American elite. We do not allow pinch hitters or designated hitters, I should say. And that's just a matter of protocol that's always been part of our committee here. So
my apologies.
no worries. We'll move to Senate Bill 485, Senator Lewis Young.
Thank you. I'd like to bring my panel up. I believe I have 2 in person and 2 virtually. There is, but at the end of my testimony.
Okay, I have to get there.
Oh.
So do you want to?
I'll just, do you want me to just move after I'm finished?
Yeah, what about the slide?
Don't worry about it.
Okay.
Yeah, I cut a lot of material out based on where you are today, so we're gonna do an abbreviated version. You're welcome. So this bill is about timely and very informative disclosures on a sales contract due to an environmental justice issue. The bill requires a contract of sale for a residential real property located within a half a mile of the National Priority Superfund site. It to include a notice at the time of down payment signed by the seller and initialed by the buyer, disclosing the proximity of the property to a National Priority Superfund site. This isn't unprecedented. There are statutory provisions for all kinds of statements and disclosures and notices for deferred sewer and water charges and a host of other things I'm not going to read off to you. But I do want to describe what a Superfund site is, because it's really important to understand the danger of a Superfund site proximity and why we're looking for more timely disclosures. The federal Superfund program was created as a result of the Comprehensive Environmental Response Compensation and Liability Act, which was enacted in 1980 and amended in 1986. The Superfund program is administered by the EPA, and they are charged with locating, investigating, and cleaning up the worst hazardous waste sites throughout the United States. These sites usually include abandoned warehouses, manufacturing facilities, processing plants, and landfills. Maryland has 26 Superfund sites. As you will learn, we have one in Frederick. And also there's one in the Senate President's home district, just as a by the way. You may have heard of Fort Detrick. That's located in the heart of Frederick County, in fact, in Frederick City. It was a top secret biological and chemical weapons research center from 1942 to 1972. The waste from the research was buried outside of the fort in unlined pits. The debris in these unlined pits is the source of contaminated groundwater. One of these pits is known as Area B, and that is a Superfund site. The area still houses source contamination in an unlined landfill that continues and will continue for decades to facilitate the groundwater plume. Many of us in the community are concerned that this could spread beyond the half-mile radius that's defined in this bill. There is a map. I'm not sure it made it in your backup, but I'm just going to explain what the map depicts. It, by the way, this site, 14 years after being declared a Superfund site, is still in the remedial investigation phase. So we have a map that shows TCE and PCE, and it's right on the border of the Superfund site, Area B, next to a community that's going through a lot of development. By the way, TCE and PCE both degrade after decades into vinyl chloride. This may sound familiar because it's the main contaminant of concern in the recent train derailment in Ohio. There are going to be townhouses built right on the border of Area B. In current law, there's no disclosure required for the proximity to the Superfund site, and new builds are excluded 100% under current law, which is why we are bringing a recommendation forward to inform potential home buyers that the property is within half a mile from the Superfund site. Include proximity information in the listing disclosures. Add a disclosure amendment that would be provided, signed, and dated before or within 5 days of the ratified contract. The bill also guarantees a right of rescission to the buyer within 5 days of receipt of the addendum. Finally, the bill guarantees an unconditional right of rescission if no disclosure was given. Before I close, I want to read something actually in the oppositional testimony. This bill is likely to deter people from purchasing these homes. This means that this would create a housing stigma on thousands of homes while Maryland is trying to supply a statewide 97,000 unit low-income housing and 85,000 rental units over the next 10 years. Now is not the time to needlessly deter people from buying homes. If ever I saw a case for environmental justice, this is it. I mean, basically what this is saying here is don't deter poor people from buying homes next to a Superfund site. If you all read it differently, I'm certainly interested in hearing it. So what we have today is a case study of what's happened in Frederick over the last several decades, because we think that the Frederick experience is a great lesson as to what can happen if you don't take these Superfund sites seriously and communicate in a transparent and timely manner. Thank you for your time and attention, and I pass on this bill hearing to some of my community advocates who've been fighting this fight for decades.
Thank you very much, and thank you for bringing this bill. I remember vividly the Fort Detrick, the study that was done. I was working on the cancer cluster, identification of cancer cluster sites, and that's when Randy White and the situation that occurred there when they brought me to Frederick to go from home to home, about a mile radius, and everybody had people in the house with cancer. If I'm mistaken, you got me. The pets were cancerous, and they brought them here to Annapolis. And so disclosure would be the least that someone can do. They're not building mansions; they're building places for poor people, and I guess they think that's okay to not disclose. But I thank you for bringing that bill. And should we not take the health of people over money when it comes to this, considering Fort Detrick and all the cancer clusters? Do you think that that's what we ought to be doing?
May I answer? Oh, go back here. Sure. Thank you. I wish you would have been on my panel, actually. This doesn't stop building. It doesn't stop selling homes. It just says be transparent,
Let them
let
know.
people know, make your own decision. But we're going to give you accurate information only for Superfund,
Correct.
proximity for Superfund sites, so that you can make your decision and truly understand the risks, but give it to you in a transparent manner and a timely manner so that you can make a good decision. Thank you.
Thank you very much. Thank you for this bill. Thank you, Mr. Chairman.
Thank you for letting me speak today. I'm going to talk about two state laws and activities concerning disclosure of property containing a national Superfund, priority Superfund site or toxic waste site. City of Scottsdale, Arizona, the North Indian Bend Wash Superfund site. This is the only requirement for full disclosure that I found anywhere in the country. Homeowners have disclosure responsibility. The National Priority List Superfund designation should be disclosed by either the seller or a real estate broker at first discussion about the property. Second, state of California. The governments initiate action to designate a hazardous waste property or a border zone property within 2,000 feet of a hazardous waste property. At designation, a land use restriction is recorded on the property, typically like something on the deed. This means no schools, hospitals, daycares, centers, or homes can be built on the property. And if a house exists on the property, you could add on to the house, but you can't do anything else. You can't build any other houses. This comes under the California Health and Safety sections. Okay, there is no disclosure on the residential sales for proximity to a Superfund site in California. However, some real estate agents, brokers, and lenders want to provide buyers with a residential disclosure report that can be provided by a number of private companies. The cost of this is anywhere from $50 to $150, depending upon where they are and how many pages it is. The report identifies the proximity of national priority list Superfund sites, nearby Superfund sites, and other environmental hazards, and some things about taxes or other things that they think are unusable. This is done to protect all parties, to include the seller and the broker, because California is a litigious state.
Okay, thank you. And I will be brief because I appreciate you must be exhausted by now. My name's Betty Law, and I have been a member of the Fort Detrick Restoration Advisory Board, which is a combination of the Army and citizens to review the remediation in Area B. I support HB 485 and the friendly amendments that will be submitted by Senator Karen Lewis Young. This bill will ensure fairness and transparency for the home buyer who may be choosing a home within 1/2 mile of a Superfund National Priority site. There are 26 Superfund National Priority NPL sites in Maryland, which can be found by simply typing search for Superfund sites where you live in a browser. And there is a list, the list of the 26 sites in Maryland is in your packet. And a number of you have those sites in your district. NPL sites contain toxic chemicals known to cause cancer and other fatal diseases when exposed to contaminated groundwater, vapor, soil, or air. NPL sites have this designation because they are most likely of all Superfund sites to have contamination that extends beyond the border. This is why it's important to note in writing the proximity of the home to the site. Because of Maryland's housing boom, developers are building ever closer to these sites. Newcomers to the area will have no common knowledge of the conditions under which they are making the most substantial purchases of their lives. At present, the buyer may only be informed of a possible hazard at the time of closing, a time when a flurry of papers is thrust upon the buyer in rapid succession to be signed. The buyer may exit the experience with no comprehension of the gravity of what they have signed and very little time to respond once they understand that they have purchased in a location they would not have otherwise chosen. This leaves the buyer in a dilemma of whether to sell out just at a time of being overwhelmed with moving in and starting a new career. And this is not fair, and this is not ethical. Thank you very much.
Panelists on your sponsor panel is participating virtually. So Mr. Ratchiff, you're up. Welcome.
Good afternoon, Mr. Chair, members of the committee. Thank you for allowing me to speak with you today in support of SB 485. My name is Jim Ratchiff. Just by the way of introduction, I'm a resident of Frederick County and City. I own commercial property here as well as residential property. I'm chair of the Zoning Board of Appeals. I have served for County Executive Jan Gardner on our Solid Waste Advisory Commission and a community advocate who has worked on public health and environmental issues. But I'm speaking for myself today. I would just like to take a couple brief moments to explain why I think with my past experience that I am in support and in favor of this bill. First, this bill basically creates awareness and transparency, much like disclosures for homes that are built in proximities to airports or even homes built near farming operations, as it is here in Frederick County. If we have disclosures for airport noise or farming smells, it seems more than reasonable to ensure disclosure for proximity to what the policy note in this bill describes as the worst hazardous waste sites located throughout the United States. This bill will make the specific disclosures universal across all residential sale and addresses current loopholes and shortcomings. To echo the senator's comments here earlier about low-income housing, already over 70% of Superfund sites are located near low-income housing. And suggesting that the answer to low-income housing is to build homes closer to environmental hazards to make them more affordable really raises some serious questions concerning equity for lower-income households. So I thank you for your time, and I respectfully ask for a favorable report on SB 485.
Excellent. Thank you very much, Mr. Ratchiff. We also have one last virtual participant, Ms. Hahn. Jen, you're up. Welcome.
I grew up near Fort Detrick. My elementary school was across the road from Area B. I grew up playing in the nearby seeps and springs, and Fort Detrick suspected contamination from Area B's unlined landfills had traveled offsite through the groundwater. And in the 90s, one of those springs I played in as a child was tested for contamination. They found large amounts of TCE, a known carcinogen. When I was 12, I was diagnosed with Hodgkin's disease. Decades later, I asked my friends on Facebook who went to elementary school in the 70s and had cancer before they were 25 or knew a classmate that had died young from cancer. I had 24 responses in 2 days. I decided instead of spending decades to prove a cluster, my efforts are better spent trying to help this not happen to anyone else. This is what has brought me here to you today. Without this bill, current and future homeowners are not entitled to adequate disclosure that may alert and educate them to potential vapor intrusion and other contamination risks from Superfund sites. TCE has a maximum contaminant level of 5 parts per billion. The Army found levels of TCE along their fence line at 15,000 parts per billion. 1 foot on the other side of this fence is owned by a developer who is approved to build townhomes. According to EPA guidelines, there is a vapor intrusion risk for some of these homes. What we do know is that these homes will be built. What we don't know is how this information is legally mandated with no loopholes to be disclosed and explained coherently to potential current and future home buyers. The Maryland Real Estate Disclosure Disclaimer Form exempts new builds and foreclosures and only requires disclosure for contaminants that are on site. That is that the seller is aware of. Contaminants and Superfund sites do not have to be on property to pose risk. Risk ends where the influence of contamination ends. I'm testifying today to implore you to use your duty of care and set uniform protocol across all residential sales. During the House bill hearing, Mr. Castelli was asked if a realtor were asked directly if a property was near a Superfund site, if he would have to answer that. He said yes, that realtors must disclose material facts. It would therefore seem to reason that not disclosing something like this preemptively could be considered concealment. Thank you.
Excellent. Thank you very much. We have a question from a member of the committee, Senator Folden.
Thank you, Mr. Chairman. Hey, Jennifer, how are you?
I'm shaking. I'm a little nervous. Thanks,
You did
Bill.
good. You did good. So for a backstory, Jennifer and I went to school together, known Jennifer a long time, and I just wanted to thank Senator Young, Lewis Young, for bringing this bill forward. Jennifer and I have had ongoing discussions about this bill over the past few weeks, have we not, Jen?
We have, thank you very much.
Yep, my pleasure. So, and I just wanted to be pointed out that she'd probably be upset with me for pointing this out, but the reason she's not here today isn't because she doesn't value this situation or the sincerity of this, of what we're talking about, but she has a immunocompromised system as a result of her being contaminated in adjacent springs that we were around young.
Boy, do I hate irony.
Right? So I just wanted to say thank you for bringing this forward. I wanted to say hello to you, Jen, and I wanted to also just be sure that that I haven't missed anything as far as, you know, I know the exact area we're talking about, and I don't know if you brought it up specifically, Senator, but you know, that joins up closely to even the District 4 and with the way that they've been allowed to just on one side of Fort Detrick's fence, which was under some really in-depth remediation for years with known leaching into the ground, and then to just then go and buy these adjacent properties and put, they're actually, because they're trying not to disrupt the soil, they're putting, we spoke about this, Jen, they're not digging into the ground, they're putting flat cement bottomed townhomes up from the ground surface with minimal disruption. So I don't know of many other places that are doing that in Frederick County. Usually they're more than happy to put a basement in, but I would say that that's an indicator as to why we need to really look at this. And I'm really thankful for you bringing this forward, Jen.
Can I say that
Yep.
that's an immediate issue because vapor intrusion works specifically through porous things exactly like concrete. So now there's no basement to hold it. It's going straight into your home.
Right.
And the off-site issue is because, so if you have 3 townhomes and there's 100 feet, 3 townhomes, they only put so many wells in. If they know that it fits under 1 townhome, they don't have a well 2 townhomes down. But the EPA rule of thumb is that if that contamination that's a volatile organic compound that can get into that porous concrete is here, 100 feet away still poses risk. Again,
Well, Jen, I really appreciate you reaching out to us. I'm sorry, I didn't mean to cut you off, but I just wanted to thank you, and it's good to see you getting along well. And thank you, Senator Young.
Thank you, Bill.
Yep.
Thank you, Senator Folden. Thank you, Jen, for stepping forward and being here and participating virtually. And I'll say that you have been elevated to secular sainthood for putting up with Senator Folden for all this time. So there you go. That's great. Thank you. Seriously, though, thank you both very much for your testimony.
If you all have technical questions, please reach out. The EPA representative for our region said she's available for technical questions, as is the MDE person. But don't be somebody said that MDE has groundwater use restrictions. That's a separate thing from what we're talking about. Just to clear that up.
No, excellent. Thank you for that clarification, and we'll definitely be in touch. Thank you all. All right, and with that, that'll conclude the test. I know we got Bill. The testimony for the sponsor panel will now bring up Mr. Castelli.
Hi, Mr. Chair, members of the committee, Bill Castelli on behalf of the Maryland Realtors. We are in support of the bill. We are proposing some amendments that would conform the disclosure requirements in the bill, similar to disclosures that you've made over the years here in the legislature. The way that we have typically dealt with disclosures to make sure it's within the contract itself, which is what we would propose in our amendments, making sure that that information is provided on or before entering into the contract. So that gives a buyer complete control over how long they want to review this information. What we would anticipate is disclosure language about the Superfund site, likely giving them an actual web address that they could explore it. And then also having a rescission right, so that if that information isn't provided on or before them entering into that contract, and they only get that information about a potential Superfund site later in the contract, they would then have 5 days to make a decision about whether they wanted to stay within that contract. The current language that in the bill right now, talking about making that disclosure at deposit would likely be interpreted as not getting the information before they enter into the contract, because deposits for many, many times will get deposited after people have already signed the contract. So just clearing up some of that language. And we've shared our amendments with bill sponsor as well.
Thank you, Mr. Chairman. Bill, always a pleasure to see you, sir.
Nice to see you.
Always good to see a good Prince Georgian. I wanted to ask a couple questions about this bill. I know Senator Foden's friend Jen mentioned your name. Do you want to respond to the comments she made first before I ask my question?
So I think what I said is that a real estate agent has a duty to disclose facts that they know or should have known. So an offsite condition may or may not be a fact that they would disclose. If any property has gotten notice that that property is specifically affected by like a Superfund site, the agent would certainly have to disclose that. Whether it's an offsite condition may or may not be a matter of disclosure. Typically, anything that would pose a risk to a person would be considered a material fact. And then so it just gets into the question of what are the facts that show that that's an actual risk that an agent would have to disclose?
And is it that they should disclose what they know or what they should have researched before around the property?
An owner only has the duty to disclose what they know. A real estate agent has a duty to disclose what they know or should know as a professional.
Got it. Thank you.
Yep.
Thank you, Mr. Chairman. Hey, Bill, how you doing? So I just want to be sure I'm understanding this part right. So under current law, the Maryland, the realtor's disclosure, that MD 10-702, it's form I'm talking about, the disclosure form. So under current Maryland law, if it's an adjoining, because the nice thing about when we use these maps for, plats, they're not showing the elevation terrain. They're not a whole lot. Like they're not showing the runoff areas or where leaching could happen in the ground. They're just showing lines. And one of the areas we're talking about is right up against Fort Detrick's fence line, and where they knew that they had buried chemicals during World War II for a long time, and those barrels ruptured.
Yeah.
So with that form in place now, there would be no requirement for the adjoining property owners to reveal that information, correct?
Correct. Unless they had specific information, like the EPA said to them, hey, your property is
Correct.
affected.
And then, and that information may have been done, say, to existing houses that are up along the roadway that kind of parallels the fence line. But this area that we're talking about that I know of is just inside that fence line, or inside those two adjoining roadways. It used to be an old farm that ran along the creek there.
Right. And
one of the concerns is that while that disclosure is necessary for existing properties, there is no such requirement for that form to be done on new builds. So you could buy right up against one of these sites, and there would be no requirement for the builder, even if they knew about it, to reveal that, correct?
Correct.
And then there's also, we're talking about the lower income homes, or people that are having, difficulty times. We went through a bit of a recession there. That form would also not be required to be used on a foreclosure sale if the home went into arrears, correct?
Correct.
So we're talking about this type of perfect storm, and we're trying to avoid that. And I'm glad to hear you guys are coming forward trying to figure this out. But I think that there definitely needs to be some transparency here.
And to be clear, we're not saying use 10-702. That's not the disclosure that we're suggesting, that it's a different disclosure than 10-702 for exactly the reasons that you.
Well, I'd rather put one up that it's the front page of every packet you do to make sure that is it there or isn't it there? It's like a big urgent sign. Hey, be aware.
I mean, there's lots of disclosures, the section in the real estate contract, and we've tried to organize our real estate contract, the realtors have, with a section specifically on these notice requirements, because there are things like lead paint, which I think are just as important as, the information that you'd be providing on Superfund too. So it's trying to focus people's attention. And that's a lot of times what buyers agents do. They'll give folks the contract before take a look at it. If there are items that you see in there, you've got time to explore it, go up to.
And then the other part about this is that when this was known to be an area that needed to be treated by the federal government, they went in and they basically dug up an area where the known toxins were, and they kind of expanded maybe a little bit outside that. But the reality is the amount of time that's been in there with the disruption to the barrels, there was a lot of leaching that was potentially has gone outside that, because I believe we were talking about, I guess HUD says 0.68 miles, but there's others that have seen it as far as 1.8 miles away from these sites. So that should be something that's concerning. You know, I mean, I grew up on the other side of Fort Detrick, so I'm very familiar with this area, but it should be concerning a lot of people. And then the one thing that I don't want to have happen is that while we're in the middle of all this remediation, if we're going to move forward with something like this, I want to make sure that if we're going to do this as the front bill or the lead bill of any of this type of transactions that are happening, that it's still required to be disclosed during, even if there's the remediation times, or because these things get held up in courts for years, decades, trying to argue isn't like, if it's being held in court and it's being discussed, then people need to be aware of that. Would you agree with that?
Yeah, and I would say the Superfund site that is the website, it will actually put on that Superfund site. It's not just the actual Superfund sites that have been identified. It's those that have been reported to EPA. So there's about 600 different sites on that web address that you would go to. Some are in the process of being investigated. Some have been identified as Superfund. Some have also been designated as not a Superfund site, but they're still up there in case someone wanted to explore it further.
So a separate signed and dated addendum would probably meet both of our concerns.
So, well, what we're saying is if it's in the contract and you have the actual web address to the Superfund website, that will give you, so whether it's a half mile away, a mile away, you can look at all 600 sites if you wanted to. If there's mapping that we wanted to, official mapping, like, for example, real estate agent contracts, we want to be the source of the sources. We don't necessarily want to be the source of information because the experts, EPA, the folks who are putting the maps together, those are the experts. Those are the people who are going to keep that information up to date and accurate. So we want to be the source of the sources of the information.
So again, I mean, we're in agreement that a separate signed dated addendum would be an appropriate way then.
I think we would prefer it being in the contract. So
no, but it shouldn't be something that's in a litany of lines that I've bought a couple homes and I'm hoping I bought my last one, because it's miserable because I hate seeing all the interest I'm gonna pay first of all, but then everything else that's in there, it's just like, if you don't sign it, what's there, you're not going to move forward. Why wouldn't this just be something that would be on the cover sheet or something that would be a front facing? Because if we're talking about transparency, we should be talking about forward face.
Well, I would say any of the addendums that you have, it's going to be a packet of the base contract with all of the addendums. So there's no way, I mean, whether it's within, we often recommend the base part of the contract because that's like the first 10 pages, first 11 pages of the contract that most people read. But then you have addendums that are,
we're only talking about a certain select area of homes that would be even affected by this. So wouldn't you figure it'd be critically important to have some? I don't care if you put it on periwinkle paper, Bill, as long as it's something that's noticeable that people say, well, that's odd, I should look at that.
Yeah, I think that's why we think, putting it in that base first part of the contract, which from our experience, that is the section of the contract that people really
I mean,
pay
I just
attention
think
to.
that it kind of gets lost in there. So we can agree to disagree, but thank you. I appreciate it.
Sure.
Right. Well, I'm glad he let you off easy. All right. All right. With that, that'll end the hearing. Thank you very much, Mr. Caselli. With that, that'll end the hearing and the testimony for Senate Bill 485. We'll now move on to Senate Bill 593. If I could ask Senator Sidnor to take a moment real quick. This will be quick. Hey, how are you all? Yeah. All right, Mr. Chairman, members of the committee, Senator Smith here to present Senate Bill 593, which will address a key barrier for delivering solar panel and renewable energy technology to condominiums. Now, the bill that you have before you has been amended in the House. And so I don't have those amendments before you, but I can describe them. They're fairly straightforward and easy to understand. And I'll make sure that the committee has them before we consider this for a vote in the coming weeks. But essentially, this bill would make it easier for condominiums to make agreements to install solar and clean energy equipment in common areas owned by the condominium association. We've had bills like this before. So the House amendments essentially, I'll mention that the House bill, I think we're actually in receipt of that bill. I think it passed off the House floor last week. But the amendment restricts the board's ability to grant only a lease, not a right of way or an easement. And the amendment restricts the type of clean technology to EV chargers, solar panels, and energy storage systems. So right now, under the real property title or article, the Maryland Condominium Act, as it's colloquially known, it takes about 66 and 2/3% to make these types of changes. This bill drops that threshold to 51% of unit owners that needed to grant that lease, the limited lease. It's only limited to a lease, not an easement or a right of way, for the purposes of installing three major items. One, the electric vehicle recharging equipment, two, solar energy equipment, and three, energy storage systems. So the process that is in the statute, unit owners are given 30 days notice of a meeting of the board to consider that when this item is going to come up on the agenda. After 30 days, the lease may be granted if 51% of those unit owners approve. And with that, with the amendments incorporated as it passed out of the House, the Maryland Energy Administration, the Sierra Club, the Maryland Building Industry Association, and the Maryland Bankers support this bill as amended. I also say that, some questions came up in the hearing in the House with regard to how these boards would have the kind of expertise to help approve such a change. The contract, once it's developed, it has to be approved by the local permitting office, and those offices obviously have the expertise to make the engineering decisions to install such a equipment. So with that, members of the committee, I'll ask the committee for a favorable vote, and I'll bring up my panel and stand for questions when they're done. All right, awesome.
I appreciate the opportunity to testify for the committee in regard to Senate Bill 0593. My name is Brian Hauser, and I am president of the board of directors for the Glen Manor Condominium and have been a member of that board for 14 years. I began my research on leasing solar panels over 2 years ago, and the biggest obstacle we faced was complying with the current section of the Maryland Condominium Act 11-125, dealing with easements and encroachments. It provides an arduous process for common ownership communities to enter into leases. We hired an attorney, and he interpreted this section as follows. We could obtain the approval of the 66 2/3% of the owners and their mortgagees. Have the board make the decision as long as we give notice to the owners and the mortgagees. And we could enter into 1-year leases and just renew them every year for 20 years, which is the life of solar panels usually. Our attorney was concerned that this section is not clear on how to deal with entering into a lease for clean energy equipment, since there are a few legal precedents regarding this section and lease clean energy equipment. The Glen Manor board chose to make the decision as a board with notice to the owners and mortgagees. The board chose this option because it's very difficult to get 66 2/3% of anybody to agree to any topic. Also, the possibility that the mortgagees or the lenders can overrule an owner's vote in favor of this. It took the boards months to identify the mortgagees. We spent 2 months doing that. We sent out our notices. Not one lender got back to us. Not one lender attended our video meeting. To me, it was an exercise in futility on our part. The proposed changes to section 11-125 will greatly streamline the approval process and clarify the procedures to follow for leasing clean energy equipment.
In addition, remove obstacles from common ownership communities to attain local and state government goals to reduce their carbon footprint and provide a way for these communities to reduce their operating costs. Thank you very much.
Dear members of the Judicial Proceedings Committee, thank you very much for having me. My name is Seth Yezel, and I'm an electric regulatory attorney at Federal Energy Regulatory Commission. All of these views here are my own and not that of the federal government. I'm speaking to you as a resident of Chevy Chase Crest, a condominium community located in Montgomery County at DC's North Boundary Stone, and as a supporter of Senate Bill 593. Our community has been working for over 2 years to install what will eventually become an approximately 1 megawatt rooftop solar facility, set to provide income for our community account and utility bill relief for our fellow neighbors. This journey has lasted 2 years thus far, primarily because at the 11th hour, our condominium attorney informed us that in order to enter into a solar leasing arrangement with any of the local developers, the Maryland Condominium Act requires us to gain 66 2/3 approval from all condominium co-owners and each of their mortgagees. This is a problem for 2 reasons. First, because we only have about a 50% owner occupancy rate for our 80 homes and see single-digit turnout for our board meetings every month. And second, because we do not have the resources to reach out to or convince upwards of 80 different banks not to oppose our project. We're more concerned with cleaning gutters, landscaping contracts, small things like that. We're coming before you to seek that this law be amended because we have seen tremendous support from the community members who have weighed in on this issue, and so that other communities can avoid this red tape. As we push to achieve our state's clean energy future, it's paramount that we stamp out any and all unnecessary barriers to block citizens from participating. Amending the Maryland Condominium Act in accordance with Senate Bill 593 represents a meaningful step toward that goal, so I urge this body to issue a favorable report on Senate Bill 593. Thank you very much for your time, and I stand ready to address any questions or concerns.
Yeah, okay. Thank you, Mr. Chair. I am Tom Deo, CEO of the Montgomery County Green Bank. I'm here to request your favorable support for SB 593. The Montgomery County Green Bank is a county chartered entity that operates as an independent nonprofit using capital provided by the county and other partners with private sector to create more financing for clean energy projects. We've supported over 30 million in clean energy projects, including over 3.8 megawatts of rooftop solar. However, no solar has been on condominiums, though we have tried. We've engaged 10 condos, including the 2 you heard from here, in the last 3 years to support a no out-of-pocket, low energy cost solar installations as third-party owned solar under a leasehold arrangement with the condos. We've worked with professional solar developers to develop designs that meet local code permitting requirements. These projects have been reviewed by the condo boards and reached the point of board approval at a community meeting. However, these leasehold projects have stalled because the boards face the current law's approval requirements of more than 60% approval by owners and mortgage holders. Such approval requirements are not feasible for these volunteer boards who must find the names and addresses of all, that could be 30, it could be over 100 of the mortgage holders, and then send a certified notice to each and await responses. This is beyond their capacity, and no board wants to move ahead and take the risk if they do not perform this approval. This bill addresses this key obstacle to delivering solar on condos across the state by changing these approval requirements for specific owner and mortgage holder approvals, including lifting the financial and logistical burden of the boards to reach all those mortgage holders. With this bill, condo boards can proceed to approve leases for clean energy equipment using the same structured, efficient, and cost-effective board process that these boards use to approve other leasehold equity leases. We believe this bill will make solar a much more feasible activity for condos throughout the state, generating savings to homeowners, creating jobs, and reducing energy consumption. In Montgomery County alone, there are over 200 condominiums with more than 42,000 homeowner units that could benefit from this change. The Montgomery County Green Bank urges favorable support report on SB 593. Thank you.
Thank you very much. Are there any questions for the sponsor or his panel? If not, thank you very much. Next, we'll have Mr. Enton.
Senator, I just have to say thank you to my delegate, Laura Charcudian, who brought this bill to me and has done a fantastic job. It's been a great steward. You know, I'd get in trouble if I didn't say that, so. Gotta, keep the home front.
Thank you, Mr. Chairman, members of the committee, Robert Enton on behalf of both the Maryland Building Industry Association and the Maryland Bankers Association. We worked with the House sponsor and we've consulted with the chairman on the bill. With the amendments to the House bill, both the builders and the bankers are fine with the bill. Thank you.
Any questions? Thank you very much. Next, we'll go online to Ms. Joelle Novi.
Yeah, it's conflicts with three other things we had to do, whatever.
It's like not that important stuff. I don't know.
What's the precedent?
In order to do those, stay harder and personal.
All right. Ms. Novi? Hello?
You calling me?
Yes, Ms. Novi, is that you?
Oh, sorry. Yes, my
All right,
live stream was a little bit behind.
No worries, you're up.
Thank you. I live in the Chair's District at Eastern Village Co-Housing in Silver Spring, where we're in the process of getting 216 solar panels on the east side of our roof, but it almost wasn't so. Tom Deo just talked about how he sees countywide how many solar projects are getting delayed or killed by the Maryland Condo Act. I'm here to share what it was like to have my community's solar project almost derailed by the current law. Our volunteer solar committee secured proposals through which developers would put up solar panels at no cost to us and sell us power at a discount. To move forward in co-housing, which operates by consensus decision-making, we then undertook 5 months of conversations with every neighbor in 55 households to explain solar financing and address every concern. Last May, the membership circle came to consensus and a task force selected a proposal to send to our board. That's when we encountered the Maryland Condo Act. Perhaps our board wouldn't have the authority to sign the power purchase agreement after all. We might need every residential owner and every mortgage holder of every unit in our building to be notified, and then 2/3 would have to affirmatively approve it. We were motivated volunteers, but my heart sank. Notifying every residential owner was more doable for us than many others. But figuring out who held every mortgage of every unit, figuring out how to notify those mortgage holders in writing, and then securing 2/3 affirmative approval was going to be a bear. I can see why this requirement kills projects in other condos. Eventually, we were able to move forward and we're on our way to powering our building with sun. But senators, you should be making clean energy easier and not harder for Marylanders who live in condos. Without this bill, condo solar projects will continue to be scuttled by the Condo Act by provisions that were never intended to interfere with solar leasing. I request a favorable report for SB 593.
Thank you very much. Any questions? If not, we will move to Dana Schultz, who has an unfavorable position.
Hello, my name's Dana Schultz. I'm a combat veteran and I hold a BS and a master's degree. I just want to take this opportunity to share that Marylanders want balanced energy policies to provide multiple, reliable, and affordable energy choices. Sunlight, water, and wind are not the best options for Marylanders. Intermittent forms of energy such as wind and solar are a greater threat to people due to the difficulty producing and transporting energy during extreme heat and cold, causing more death than any recorded difficulties from fossil fuels. Other countries are producing the dirtiest energy with more pollutants than the United States. Who produces the solar panels? We are the cleanest energy producers in the world. Maryland is a breadbasket of food and fuel which can provide bountifully for all Marylanders without the government deciding for us. The verbiage in SB 593 sounds like the Sustainable Development Goals of Agenda 2030 when the government decides based upon a false climate crisis. Sustainable sources, by definition, meet our needs today without compromising our future needs. Sun and wind do not meet our current needs. The climate crisis alarmists such as Al Gore predicted that we would be in the Arctic would be ice-free by 2013. Then he changed it to 2014, then 2015. The World Economic Forum creates these climate crises to control the populace and rule the world under a few select nations. The tactics of the World Economic Forum is to create a crisis and then provide a solution which controls the masses. Agenda 2030 and the Bali Declaration of G20 are examples of these strategies. The climate crisis alarmists have said that we would have no oil by 1976, then by 1996, then by 2000, then by 2010, then by 2020. We still have bountiful amount of oil and fuel for our nation and the world. So the problem has been created, and the problem is the war on energy and supply chain issues. So I thank you for your time.
Any questions? Thank you very much. If we have no questions, this concludes the bill hearing on Senate Bill 593.
Excellent. We'll now move on to Senator Folden with Senate Bill 570. Senator Folden, you're up.
Mr. Chairman, esteemed colleagues, for the record, Senator William Folden, District 4, Frederick County. Before you today is presenting SB 570. This deals with the methamphetamine penalties. This is not a penalty bill, but a parity bill. It elevates the crime of manufacture or distribution of methamphetamines to that of singular CDS crimes like cocaine and heroin, 5 years to 20 years. According to the DEA, methamphetamine distribution and usage has been steadily increasing, with a 23% increase in deaths resulting since 2017. Domestic production of methamphetamine involves the reduction of a multitude of hazardous chemicals, often resulting in fires, serious injuries, and death. Common household items such as pseudoephedrine, lithium batteries, camp fuel, starting fluid, and cold packs are used as ingredients. Sentencing Guideline Commission recently adjusted the sentencing matrices for drug and property offenses, which had the effect of reducing these guidelines. It makes no sense that a distribution of either heroin or fentanyl as individual drugs have a max of 20-year sentence, but methamphetamine production, which is incredibly dangerous and distributed, which is increasing every year, is only a 5-year max penalty. If sentences are decreasing, thanks to the Sentencing Commission, then the cost of doing business for meth dealers is minimal, which keeps them in business longer. I would urge a favorable report with this very reasonable codification. Thank you.
Mr. Chairman, members of the committee, my name is Gavin Potashnik. Currently, I'm working for the State's Attorney's Office of Cecil County, but also I'm here on behalf of the MSAA. This is not my normal gig. Usually I'm here in juvenile crimes and sex crimes. However, this is one of these crimes which we have brought before the committee many times in the past, and I thank Senator Folden for his leadership in doing so. The methamphetamine problem, and I'll start with a saying that we have out there, that the Maryland General Assembly is typically allergic to penalty bills. This is not a penalty bill. It is a parity bill, because the methamphetamine problem is growing in Maryland. It has increased exponentially. The DEA has indicated, as Senator Folden indicated, that there's been a 23% increase in deaths in 2017. There's been a 75% increase in the amount of reported types of methamphetamine occurring nationally. And we're seeing more and more of it in the rural counties of Maryland. We're seeing more and more of it on the Eastern Shore, in Cecil County, in Southern Maryland, and in Western Maryland. This is according to the Maryland Criminal Information Network, GOCAT. This is not the methamphetamine of Breaking Bad. It's not manufactured by Walter White. It is a lot more potency to it. and it is now mostly manufactured, the chemical components in Mexico, it's transported over, and then we have redistribution labs in Maryland, which are just as dangerous as those manufactured labs that then put it into pill form. It is rivaling that type of drug as fentanyl and also heroin. It is cheaper to manufacture, cheaper to produce. As a result, the operation of the distribution of methamphetamine is much more sophisticated than everybody thought. Yet we still are reduced to a 5-year max crime. It's time. It's time we made the distribution and possession with intent to distribute methamphetamine parity with the other more serious drugs like fentanyl, like heroin, like cocaine. It's time. And I thank you. Ask for a favorable report.
Good afternoon. Thank you for bringing the bill forward and thank you for discussing it. I just want a clarification on the section that we're looking at 5-609. Instead of listing the bills like heroin or cocaine, they get very technical with, I think, their chemical compounds. And so can you explain why? I'm sure it's because, or I'm sure it has something to do a little bit with what you just explained about all these awful other components that end up in it that we can't list all of them. That may be the problem. But is there no essential components of methamphetamine that would have fit here? Or just explain to me why you did what you did.
So if you think of it like a car, right? You take a steering wheel, you take tires, you take an engine, you put it together, you create a car, right? If the car itself was illegal, but the component parts were not illegal, that's the problem you have with methamphetamine. So, 3,4 methyl dioxymethamphetamine by itself, MDMA, is illegal. It's its own chemical component. But methamphetamine is usually created by cooking down different substances like Sudafed and dioxin and lithium. And you put that together in a way which, I could disclose publicly, but I won't. And that you cook it into different powdered form or crystalline form, at which point then it becomes very dangerous and very toxic. So it is. You wouldn't want to make the component parts illegal. You'd want to make the sum illegal, which is called methamphetamine.
But when you go to court, would anybody argue that because you didn't create a description, a chemical description of this drug?
When the labs do an analysis of the drug itself, so they do a breakdown of the chemical components, they identified it as methamphetamine, period.
By looking for what? Just tell me again what that would be. What's the essential thing that a lab would say, okay, we've had methamphetamine. You just
I'm
said
not a lab person, but the ultimate conclusion from the lab would be methamphetamine. So when you look at the chemical components of heroin per se, right? There's a lot of different chemicals involved in heroin, but the ultimate conclusion of the lab is that it is heroin. It's the same thing with methamphetamine. So if you take the chemical components of methamphetamine, which we're describing here in detail as dangerous, it's not plant-based, it's chemical-based. When you put it together, you create methamphetamine. So the lab ultimate conclusion would be meth.
So when a defendant's pushing back for whatever reason, the argument they never make is, I wasn't making methamphetamine. If a lab says it, a defense attorney doesn't come in and quibble with that.
No.
All right, thank you, Mr. Chairman.
I mean, they could, but they quibble anything, but they don't.
All right, thank you, Mr. Chairman.
All right, seeing no more. Thank you very much, Senator Folden. Thank you, Mr. Potashnik. All right, that'll end the hearing for Senate Bill 570. We'll now move on to Senate Bill 464. Senator Folden, you're up.
Yep. Bring my panel up. Mr. Chair, come on. Mr. Chairman, members of the committee. Again, for the record, Senator William Folden, District 4, Frederick County. For you today, Senate Bill 464. Senate Bill 464 deals with fentanyl and fentanyl analogs and the penalties associated with them. So again, this is about a parity issue. This would basically elevate the crime and manufacture of distribution of fentanyl and fentanyl analog mixtures to that of a singular fentanyl distribution from 10 to 20 years. CR 5-6, I'm not taking your points, Emma. Skip that one. All right. Sentencing Guideline Commission recently adjusted the sentencing matrices for drug and property offenses, which has had an effect on reducing these guidelines. Fentanyl mixtures are still pervasive and serious. Recently, there has been a trend of mixture cases involving fentanyl and xylazine. Xylazine is a non-opiate sedative authorized for veterinary use. It has also been detected in the growing number of overdose deaths. The mixture of fentanyl and xylazine is Narcan resistant. It makes no sense that a distribution for either heroin or fentanyl as individual drugs have a max of 20 years, but putting both together will get you a 10-year discount. And I can tell you, as a police officer that's been practicing in law enforcement for over 28 years and still does it, and having administered Narcan, the ongoing opioid epidemic is frightening. And I've notified one too many parents that their loved one will not be coming home as a result. And the fentanyl issues and the components thereof are very dangerous. And I want you to imagine, if you will, because carfentanil has been something that's been coming out on pretty hard into the market. Carfentanil, imagine, if you will, a grain of salt from your table salt shaker. 1/10 the grain of that salt is all the amount of carfentanil necessary to kill a human being. 1/10 the size of 1 grain of salt from your dinner table is enough to kill a human being. Remember that. This is what they're using to cut these drugs, to make them more potent and very, very dangerous, resulting in far too many deaths. So with that, I'd like to turn it over and ask for your favorable report on SB 464. Thank you.
Good afternoon, evening, Mr. Chairman, members of the committee. Gavin Potashnik from the Cecil County State's Attorney's Office, also from the Maryland State's Attorney's Association, asking for a favorable report with respect to Senate Bill 464. Again, this is a parity bill, not a penalty bill. It's an open question as to whether or not criminal law article 5-608.1 was designed originally to be a sentencing enhancement or to be a standalone crime. But a recent decision in White v. State kind of put that to rest and kind of said, yes, it's a standalone crime. The problem is that when I put these two crimes before a jury and I have a fentanyl xylazine mixture, the jury will pick the mixture crime every time, which unfortunately then creates that 10-year disparity in sentences. Xylazine, which is a new product which is coming on the market, which is being cut with fentanyl, is very, very dangerous. Xylazine by itself is not illegal. It is approved of veterinary use. Again, according to the Maryland Criminal Information Network, which Cecil County and Harford County, which I before was a part of, are showing massive amounts of xylazine being imported and cut with fentanyl because the high from the combination of those drugs is intense. And that's what the consumers of these mixtures want. Unfortunately, xylazine and fentanyl put together is Narcan resistant. I'll say it again, Narcan resistant. The DEA has reported there's something insane, like 1,000% increase in deaths over the course of the past 2 years as a result of the fentanyl and xylazine mixtures. And I have the report in front of me. It is 8,000%. So this is nothing that to really sneeze at. I'm pretty sure down the line will be other types of chemical compounds that will make it just as dangerous as fentanyl. All we're asking for is to increase the penalty to 20 years for this mixture. That, according to us, would at this point would at least stem the problem before other solutions can be had for the opioid epidemic. With that, we ask for a favorable report with respect to Senate Bill 464, and I thank you for your time.
Thank you, Mr. Potashnik. Before the next witness gets up, we have our state's attorney from Montgomery County who is here joining us virtually. I'd like to give him an opportunity to testify, and then we'll move on to the rest of the panel. Here you go. Welcome.
Senator Smith, it's always great to be with you. Look, on behalf of the citizens of Montgomery County and on behalf of my office, I join with my fellow prosecutors from the Maryland State's Attorneys Association urging a favorable vote on 464. If you look back and you look at the trend of what's happening in the state of Maryland, fentanyl almost didn't exist as a cause of death in 2010. Now, where we had over 3,000 deaths in Maryland last year, medical examiner's office says of the opiate-related deaths, 90% of the deaths in Maryland are caused by fentanyl. We also had a very sad number that the country here in the United States experienced with fentanyl, and that is that 100 1,000 Americans lost their lives to this opiate epidemic, or this in the opiate epidemic in the United States, and the vast majority of them are were fentanyl. And then maybe sadly, particularly for Senator Smith and the other individuals that are listening to me from Montgomery County, I've joined with the superintendent of schools here in Montgomery County because 11 of our students from Montgomery County Public Schools, 11 have overdosed in this school year alone. This is an enormous problem. That's why I visit every high school. I talked to 1,600 high school students today at Damascus. I've been in 20 different high schools. It is literally, this drug is being mixed with everything. Initially, it was cutting heroin, but there are vape pens that have been seized in New York State. There are counterfeit pills that are being put out into the black market, where a DEA estimates that 40% of the black market pills in the United States that are being sold as pharmaceutically produced drugs have enough fentanyl in it, and it's already been addressed how little it takes. It really is a couple of grains of salt in your hand, enough in one of these pills that they manufacture in a sprinkle method is enough to kill you. I would tell you that I could not voice a stronger support for any bill because the people who are selling this drug are literally killing our children. They're literally killing our children. And I could not feel more strongly about any bill or any penalty. And I appeared today at the Damascus High School with a mother who lost her son and a recovered addict who runs the Recovery High School that's out of Frederick County. I know there's some people from Frederick County. I think the senator sponsors bill from Frederick County. The woman who runs that school was with me today in Montgomery County, urging kids to be on guard against this. So I close by urging a favorable report on Senate Bill 464. Thank you.
So thank you very much, Mr. State's Attorney. Good to see you, as always. We have one question from Senator West.
Mr. Chairman, a question I've always wondered. I've never, never asked the question of someone who's as experienced as you with fighting crime in the drug area. Why in the world would a drug dealer put fentanyl into his drugs if it kills people? He's killing his own clients. Why would they do that?
So, Senator, it's a good question, but it's about, you have to understand the consumer, right? So if I am a drug dealer and I have a certain product that has fentanyl in it and it causes a certain type of high, if I'm another dealer and I have the same product, but I make it more potent and that high is a lot better, then the customers are going to flock to the higher high per se, because it's a better product for them, because it satisfies the fentanyl heroin receptors because you add things to it.
It sounds awful, but at least it makes sense.
Right. So it's the same as if I made a hamburger that I used brisket in, and I use a hamburger which is regular, bottom roast. People will come to the burger with the better stuff in it because it's better. They like it more.
Even if it might kill them.
Even if it might kill them.
Thank you.
Thank you for having me here today. My name is April Babcock. I am in support of this bill, Senate Bill 464. My son, Austin Connor Babcock, was poisoned by fentanyl. This is not an overdose crisis. This is a poisoning of American crisis. When anybody disguises a harmful substance in anything for another person to consume without their knowledge, that is the very definition of a poisoning. When people are going out and getting cocaine and dropping dead from fentanyl, that's a poisoning. When young kids are buying these pills, they think they're getting an Adderall, a Percocet, a Xanax, but then they're dropping dead from fentanyl. That's the very definition of a poisoning. Americans are literally under attack. We're being deceived. We're being poisoned to death. And the DEA, it's 6 out of every 10 pills now. I work with the DEA. I work with the National Sheriff's Association. I'm a grassroots nonprofit here out of Maryland, but I've fallen on deaf ears in my state. So I went national. I rally in front of the White House. I'll be going back again this September 23rd. But this issue, it's synthetic, it's man-made, like you're saying. Not everybody knows they're getting fentanyl. And why are drug dealers doing it? Because for every person that's snorting coke with a little fentanyl in it, for every person that's not dropping dead, like my son, within 3 hours, they're feeling the withdrawal effects. So that's more customers, more customers. When you got 1 brick of fentanyl equals 50 bricks of heroin, bye-bye, Poppy. That's the drug of the past. This is going synthetic. You're saying about the xylazine. Yeah. So how are we going to, we're not even going to, we can't harm reduction our way out of this crisis. We have to do something different. We have to treat it as something different. This is not heroin. It's not cocaine. It's not crack. This causes instant death. Take a sweet and low packet. Empty 1 sweet and low packet out in your hand. That, if it was fentanyl, that has a potential to kill 500 people. Put carfentanil in there or acetafentanil in there. It's going to kill way more than 500. So thank you for letting me speak.
Good afternoon, good evening. Thank you for having me. I'm Debbie Santini. I'm in favor of the Senate Bill 464. My son, Jesse Bird, died February 16th, 2022 of fentanyl poisoning in Stella Recovery House on Marta Lane right here in Annapolis. He died less than 5 days before he entered Stella House and about 3 weeks before his 27th birthday. Instead of celebrating my son's 27th birthday last year, I had his funeral. There was 10 people in that house when my son died, 10 people. His alarm went off at 4:30 in the morning and the call to 911 wasn't received until 7:01, 2 hours and 31 minutes later. These are not your stereotypical drug users that we're talking about here. We are all vulnerable to this drug. Babies are dying from this. Illicit fentanyl is in every drug out there. This is murder, plain and simple. I believe fentanyl deaths need to be handled as a crime scene and prosecuted when they can as drug-induced homicides. Fentanyl is a weapon of mass destruction, and it should be declared as such. And with our open borders, we will continue to bury more children, and we will leave countless families like mine devastated. My child didn't want to die. He was happy. He was looking forward to his life, and he even made a list of priorities that he wanted to work on. He wasn't given the opportunity to accomplish those priorities because of fentanyl. Jesse was a loving, precious young man. He had a beautiful smile, and he is missed every single day by those that love him. He saved the lives of 4 people that I'm aware of, including his brother, but no one saved him. I now devote all my time to honoring my son's memory, to helping to promote awareness, not only on the dangers of fentanyl, but to advocate on much needed changes in how recovery houses are run and operate in the state of Maryland and letting families know they have a voice. I believe fentanyl traffickers need to be put away for a lot longer, but 20 years is a start. It won't bring my child back, but it just may save one of yours. Thank you.
Had good afternoon, but it's good evening. Mr. Chair, Mr. Vice Chair, and members of this committee, Judicial Proceedings. My name is Tammy Ruff, and I reside in District 35. I'm here today to respectfully urge a favorable report of SB 464. My son, Matthew Shade Buchanan, is a Marine Corps veteran. He served for 4 years and was deployed twice to Iraq. His first job was as a civilian was working for an environmental abatement company. Matthew was suffering in silence with PTSD. He began with opioids and then heroin. 10 years of addiction, Matthew attended many rehabs and many programs through the VA and also private. His struggle was 24/7, 365. I would do anything to have saved him. I never gave up hope. And I really pray that Matthew's death will bring about change. Matthew was my firstborn, and it's never the natural cause to bury your child. The anger comes from the stigma that still exists about addiction. The dealers kept Matthew's phone and ATM card where he had passed from the fentanyl. Then they cash apped themselves 1 hour after his death and stole hundreds of dollars with his ATM. This went on 26 days until I could close Matthew's account. The cause of death was fentanyl overdose poisoning. The ME's report The only drug in Matthew's blood heart was fentanyl. There was 143 mcg of fentanyl remained in his blood at the time of his autopsy. Fentanyl is the consistency of and packaging of heroin. Matthew was lied to and used by the dealers for money. Matthew did not want to die. He wanted the demons from war to stop living in his memories. Most drugs nowadays are being laced with fentanyl. I speak with other grieving parents from all over the United States and abroad. The path of death and destruction fentanyl leaves and dealers pursue for money. Fentanyl does not discriminate. It kills regardless of gender, economic status, education, religion, or age. I pray Matthew's death was not in vain. I'm sorry, my time is up. I do have some statistics. Is that okay? Okay. According to the CDC, in 2020, more than 56,000 deaths involving synthetic opioids other than methadone occurred in the United States, which is more deaths than from any other type of opioid. Synthetic opioid involved death rates increased by over 56% from 2019 to 2020 and accounted for over 82% of all opioid involved deaths in 2020. The rate of overdose deaths involving synthetic opioids was more than 18 times higher in 2020 than in 2013. I pray that there is a favorable report for SB 464. Thank you for your time. I appreciate it.
Senator Folden, State's Attorney McCarthy, Mr. Potashnik, thank you very much. But more importantly, more importantly, just thank you to the family members that took the time to hang in there with us and to share your stories. It's hard to come before this committee, but also just, to share your stories out in the public. So really appreciate you taking the time to be here with us. And thank you for your willingness to step up. We've got Senator Sidnor has a question.
Thank you. This is for Mr. Potashnik, if you wouldn't mind. Just so that I could have some context. This bill is for distribution and possession. I'm curious, because just from what I'm hearing, fentanyl is synthetic, so I'm assuming it's manufactured. Do you know what the penalty is for that?
The penalty for the manufacture of fentanyl, well, it's still under 5-602, so it's 20 years.
So that's 20 years.
Yes.
Okay. All right. Thank you.
But if you mix it with something, and that's all you charge, it's 10
and
years.
And just out of curiosity, do you know where the fentanyl is generally manufactured that's coming here in Maryland?
From multiple sources, comes from China, domestic labs, Mexico, overseas, and numerous locations, and comes into the market. I'm sure Senator Folden, as a police officer, has better intelligence than that, but according to the DEA, it's just flooding the market.
Thank you.
All right. Seeing no further questions, thank you very much. We have a couple more people that would like to participate in the panel. We have Ms. Dana Schultz is gonna for the proponents, and then we'll have I think we have one person signed up in opposition. Welcome.
Hello, I'm Dana Schultz. I live in Anne Arundel County. I hold a bachelor's degree and master's degree. I've worked with families and children and incarcerated juveniles who are re-entering society. Fentanyl is the #1 cause of death in the Americans ages 18 to 45, according to Families Against Fentanyl. This is a crisis. Marylanders can make a difference at the state level to stop this crisis. From an article I researched, the internal U.S. distribution networks for fentanyl are the most essential component of the foreign cartels operations, because without them, there are no sales and no profits. So this is internal U.S. fentanyl networks. So we can put a stop to that in Maryland. Recent research, Black Americans are more likely to die from fentanyl poisoning than any other racial demographic. Haven't enough Black babies died? Fentanyl fatalities more than doubled in just 2 years and more than tripled among Indigenous and multiracial Americans. Since 2015, fentanyl deaths among Black and Indigenous communities increased by 13 times. Teen fentanyl deaths more than tripled since 2019 and increased more than 5-fold among Black teens. Fentanyl is the #1 cause of death among multiracial and white Americans ages 18 to 45, and is the #2 cause of death among Black and Indigenous Americans ages 18 to 45. In terms of the loss of life and damage to the economy, illicit synthetic opioids have the effect of a slow motion weapon of mass destruction in pill form, according to the Commission on Combating Synthetic Opioid Traffic. This weapon of mass destruction is increasing this penalty is commensurate with the devastation that it's causing Marylanders. So, thank you.
Thank you very much. Questions from the committee? Seeing none. That'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition. Is Rajani Gudlavaletti here? Welcome. How are you? Good to see you.
Hello, good evening. I am Rajani. I'm with Baltimore Harm Reduction Coalition. First and foremost, I want to deeply, honestly, and sincerely thank everyone who has shared the story of their loved ones. It is so brave and it is so important to tell these stories. We at Baltimore Harm Reduction Coalition and all harm reduction workers also want to end the overdose crisis. We have experienced immense loss. We have saved numerous lives with Narcan at the best that we can. And BHRC opposes Senate Bill 464. If Maryland doubles the potential sentence length for charges related to fentanyl possession, this will further marginalize communities who have been targeted by drug-related policing for entirely too long, for decades. SB 464 would perpetuate the drug war that has devastated our state. Committing more of our resources to longer sentences for people charged with selling drugs does not reduce the supply or demand for fentanyl or any future drugs that we will see. The drug war, in fact, incentivizes more potent drugs like fentanyl, carfentanil, and further drugs. It is compact, it is easier to carry. If we further criminalize this, it will not end the overdose crisis. It does not work. The federal government already convicts people of certain possession charges related to fentanyl for up to 40 years. These laws are upheld often violently under the false pretense that such severe penalties would reduce the increasing overdose crisis. This strategy obviously has not worked. My fellow harm reduction workers tirelessly push against the deadly overdose crisis, as do so many people who are here today. Naloxone distribution, syringe services, everything we can, with the support of the Maryland General Assembly, which we have much gratitude for. SB 464 would be a drastic step back for our state. Naloxone works. It is not fentanyl, and even mixed with xylazine is not Narcan resistant. That is false. That is dangerously false to say. We hope to have more conversation and dialogue with everyone about this issue because we all care. We all have lost people, and I really appreciate you listening to me and others today. Thank you so much. We urge an unfavorable vote on this bill.
So thank you very much. Always good to see you, and thank you for the work you do every day.
Thank you.
Questions from the committee? Seeing none, thank you very much.
Thank you so much.
All right. And with that, that'll end the hearing for Senate Bill 466. We'll now move on to Senator Carter with Senate Bill 757.
Hi there. My panel, my whole panel, so it's all on you. Good afternoon, good long afternoon, getting longer, members of the committee and Mr. Chair. So last year, we passed a bill where we ensured that pets were protected from being outside too long if the temperatures were too cold or too warm. And I remember saying during that discussion that I had some concerns because there actually might be some households that didn't have air conditioning. And so it could be a situation where in a hot temperature, it could be a cooler, a dog or cat might catch a breeze outside as opposed to being stuck in a hot box where there's no air. And I remember certain members, the more affluent members of this committee, looking at me as if I had three heads, like, of what do you speak, Senator? There could be a household where someone doesn't have air conditioning. Well, yes, sir, there could be a household where somebody doesn't have air conditioning. And what this bill seeks to do is ensure that there are no residential rental properties where tenants are subjected to oppressive temperatures very much as we insured for pets last year. Senate Bill 757 requires landlords of residential units in Baltimore City, it's a Baltimore City bill. It's before the delegation, should be voted on Friday. Provide air conditioning between June 1 and September 30th if at least one resident in the unit is age 3 or younger or 65 or older. We thought that limiting this bill to age limits might eliminate some of the objection because we're talking about the very young, the babies, and the elderly, who are often vulnerable. Some of the opposition says this is discriminatory, and so my suggestion to this committee is if you agree that it's discriminatory, then I'm more than happy to open it up to every age of a renter. But I think that limiting it to children and babies and elderly is probably prudent, at least for a first step. Montgomery County and Prince George's counties already have similar laws, but they're much more far-reaching than this bill. Their laws require air conditioning for all renters. The bill is limited to a small group of individuals. This bill, as I said, 3 years or younger or 65 or older. In the past 5 years, there have been 36 deaths and 5,400 emergency medical calls in Baltimore City due to heat-related illness. 800 calls last year. In 2021, Baltimore City experienced above normal temperatures with 19 code red extreme heat days and 3 heat-related deaths. In summer months, urban air temperatures can be up to 10 degrees higher than the air of the surrounding suburban or rural areas, a phenomenon known as the urban heat island, UHI effect. Extreme heat events are getting worse with climate change. The urban heat island effect is anticipated to intensify as extreme heat events increase with climate change. Heat events will increase the severity and intensity, leading to a rise in daily temperatures. Estimates are that in 50 years, Baltimore weather will be similar to what Mississippi is experiencing today. Approximately 51% of Baltimore's households are renters, many of whom are young children and elderly. For these two groups, air conditioning is essential, and that's what this bill seeks to do, is mandate air conditioning as essential for these rental units for these tenants. Baltimore City, 20% of children, about 24,000 have an asthma diagnosis, which is more than double the national prevalence of 9%. Pediatric asthma-related emergency department visits occur in Baltimore at more than double the statewide rate. According to the Maryland Health Services Cost Review Commission, in 2019, children in Baltimore City were hospitalized 389 times with asthma as the primary reason for admission. Children in Baltimore went to the emergency 3,457 times with asthma as the primary reason for the visit. Air-conditioned systems filter out airborne allergens. Examples include dust mites, animal dander, pollen, mold spores. They also work great for filtering non-allergic asthma triggers such as smoke from wood fires, smoke from cigarettes, and various forms of air pollutants. Air conditioning also reduces humidity in the home, which can trigger an asthma attack, and lower humidity reduces mold, pollen, dust mites from growing rapidly because they thrive in hot and humid conditions. Extreme heat also poses the potential for increased mortality from cardiovascular disease, respiratory illness, and stroke, which heavily impacts the elderly. The extreme summer heat also disproportionately impacts poor Black households, in Baltimore City, women-led households, and lower income households. They make up the majority of renters in Baltimore City. For these reasons, I respectfully request a favorable report. I would just reiterate that there are bills that are more stringent in Prince George's and Montgomery County, and also the fact that last year we passed a bill to protect pets from extreme temperatures. It would seem to me that at least we would put children, babies, and elderly in parity with animals, pets that people keep. Thank you very much.
All right, good evening, members of the committee. My name is Michael Donnelly and I'm from Economic Action Maryland. We are a nonprofit organization and we work to advance economic justice and equity statewide through direct service, research, education, and through advocacy. And I'm here today in support of Senate Bill 757 because in my day-to-day work, I spend most of my time speaking with renters and property owners about issues with the landlord-tenant relationship. And every single summer, I start getting tons of calls about a lack of AC in a rental unit, whether it was never there at all or whether it went out. And very frequently, the people that call me are shocked that even though in the winter, heat's required for habitability, air conditioning is not under the same requirements in the summer. Instead, the rent escrow statute in Maryland lists lack of air conditioning as sort of like a presumption against a serious threat to life, health, and safety. And, you know, this is awful for people that have underlying health conditions, for children who are vulnerable to these extreme heat events, and older adults as well. So at a core level, this is a public health measure because extreme heat is really, really dangerous with these particular effects that have been described already. And requiring air conditioning in rental units for older adults and very young children is both going to protect some of the most vulnerable people from extreme heat, but it also helps sort of resolve some of this inconsistency in Maryland law, where rent escrow is available for a lack of heat in the winter because extreme cold is dangerous, but air conditioning, climate control in the summer does not, you know, receive the same sort of standard. But I believe, and public health officials believe, it can be very, very dangerous. And so this is measured legislation. It's limited to specific groups, and it's based on pre-existing laws in Maryland. So for these reasons, I respectfully request a favorable report. Thank you.
Thank you. Are there any questions? Right. Ask one for the sponsor.
Yes, Mr. Chair, would you like to make this an emergency bill?
No, but just out of curiosity, residential rental units, that encompasses more than multifamily.
Yes.
Thank you. All right, seeing there are no questions, thank you all. We're gonna call up Wesley Shrum.
Mr. Chairman, members of the committee, my name is Wesley Shrum, and I'm a law student at the University of Maryland School of Law's Public Health Clinic, testifying in favor of Senate Bill 757 with amendments. I'll be discussing three topics today. First, the rising temperatures in Baltimore City. Second, Maryland's warranty of habitability. And finally, I'll be proposing an amendment to broaden the scope of this bill. First, the rising temperatures in Baltimore City are creating a dangerous heat island. This has a substantial effect on members of our society. And living in this environment is not easy for the very young and older adults who are more susceptible to heat-related illnesses, such as heat stroke, which, if left untreated, can cause death. We also see that living in this environment can affect any individual, regardless of age, such as those who have pre-existing conditions such as heart disease and asthma, to name a few. Second, despite the dangers of living in this environment, Maryland law restricts a tenant's ability to obtain air conditioning. Now, under Maryland law, the warranty of habitability requires a landlord to remedy any defects which create a serious and substantial threat to health, life, or safety. However, there is a rebuttable presumption that lack of air conditioning does not meet this standard. And when bringing a case, this presumption makes it almost impossible for tenants to obtain relief. Now, with the warranty of habitability being essentially an unavailable mechanism, tenants need legislation that offers protections. Finally, we are requesting that this committee amend this bill to apply to all individuals, regardless of the age of the tenant, so that everyone has access to a safe and healthy home. Additionally, by amending this bill and broadening its scope, it will eliminate the possibility of landlords discriminating against tenants, such as those who have a child 3 years of age or younger, or are themselves 65 years of age or older. With that, Mr. Chairman, we respectfully urge this committee to amend this bill and issue a favorable report. Thank you.
What year are you in law school?
Third year, sir.
Awesome. Thank you. Any questions? All right, thank you very much.
Thank you.
Next, we're gonna go virtual to Crystal Hypolite. We're gonna come back to Ms. Hypolite and welcome Catherine Howard and Lauren Graziano.
Good evening, Mr. Chair, and all of the committee members who are still here awake and listening to people. We appreciate it. I am Kathy Howard. I'm the General Counsel for Regional Management, Inc., and who is a member of the Maryland Multi-Housing Association. We're here to do a little bit of explanation. You've heard a little bit about rent escrow and the warranty of habitability in in the current code. I think that frankly, that this bill, although it is very well intentioned, there is some room in the rent escrow statute where we could either tweak the rent escrow statute or essentially use the rent escrow statute the way it was intended to bring persons who are in situations where air conditioning is an absolute must for their health, that the escrow statute as it is currently written would support a case to get that air conditioning amenity into those units. I can tell you that regional management has essentially in its apartments window air conditioners, and I am very concerned about the part of the bill that talks about how the amount of airspace that is in that has to be cooled by the window air conditioner. I don't know that that is really realistic, and we are concerned that although they work very well in the apartments, the garden apartment setting, that this bill would then require some other kind of situation that is much more expensive and making that kind of apartment home much less affordable. So those are our comments, and we are willing to take any questions.
We'll hear from Ms. Graziano, then we'll come back to questions.
Thank you. Good evening, Lauren Graziano with the Maryland Multi-Housing Association. Ms. Howard took a lot of my talking points, and so I will simply expand on them a little bit. We agree with the points made about rent escrow. We believe that is a sufficient mechanism to compel landlords to provide air conditioning in cases where there's truly a health and safety concern. I agree with Ms. Howard. There's maybe some room to tweak the statute to make that more easy. But as far as window units, I want to address that as well. And the potential costs, not only to housing providers, but to ultimately residents. I would not at this point advise any of our members to comply with the terms of the bill by trying to use window units. If you've ever owned one, they only are capable of cooling a very small space. The bill provides very prescriptive requirements around what spaces must be cooled, to what temperature they must be cooled. And I'm not particularly confident that window units would meet those requirements. And so as a practical matter, I would advise our clients to probably outfit all the units with air conditioning just to be safe. And this is potentially very costly to do these kind of capital improvements to properties, which ultimately is a cost that the residents bear to some degree. And I know we're having a lot of conversations right now about affordable housing and the larger landscape and how we create more affordable housing and make it more affordable for our community members. And so I just want to be sensitive to any policy that could ultimately increase costs for people. And with that, I will conclude and happy to take any questions.
Senator Carter.
Thanks, Mr. Chair. Ms. Graziano, Ms. Howard, I think regional management, I know you're located in Baltimore, but do you have properties in other places or just Baltimore?
Baltimore City and Baltimore County.
Okay, so you don't have Montgomery County or Prince George's, and you, Ms. Graziano, are you affiliated with any properties in those other counties?
MMHA does not have properties in those counties, no.
Okay, that was my question, because Montgomery County and Prince George's County property owners seem to have survived, and this is the law there, so I was
Yeah.
thinking that it wasn't doomsday for property owners there. They were able to navigate through it, so hopefully we can figure out a way. I do think that it should pass, but even if it doesn't this year, I think that inevitably in the future, this is going to continue to be an issue that has to be addressed. Thank you.
Any other questions?
Senator McKay.
For you too, wouldn't you say that while you're not in Montgomery County or Prince George's County, would you make the assumption of either fitting everybody with air conditioning added to the overall costs of renting a unit, which therefore is talked about the overall cost of the rental, which is always an issue that we're talking about of having affordable housing and a housing shortage. So why would we be pushing this now when we have a shortage? Isn't that so?
No, I think that's exactly right. And the other point I wanted to make as well, Senator Carter, I would distinguish perhaps Baltimore City from Montgomery County and Prince George's just because of the age of the housing stock we're potentially talking about. I think Baltimore City has potentially a lot more historic and older buildings that could require more significant, excuse me, my voice is given out on me, more significant upgrades, specifically with things like the electrical infrastructure. And I think those would be components that we would want to consider and potentially what make it different than Montgomery and Prince George's County.
Well aware of that position, having been here for decades and hearing that justification for the slowness of lead abatement in Baltimore City. The housing stock is old, but I do think if you're going to rent property to people, you've got to make it so that they can safely live in there with the air temperature. So anyway, I'm not going to belabor this. We can have a conversation offline and see if there's any working room. I don't know if there will be though. Thank you.
Happy to try and find it.
Okay. Thank you.
All right, thank you all. We're gonna go to virtual to Crystal Hypolite.
Thank you, Mr. Chair and members of the committee. My name is Crystal Hypolite and I'm representing the Housing Authority of Baltimore City. HABC serves approximately 42,000 individuals in Baltimore City through its public housing and housing choice voucher programs and is the largest provider of affordable rental housing in Baltimore City. HABC is funded and regulated by the U.S. Department of Housing and Urban Development. Our public housing inventory consists of just under 6,000 units at 10 developments and scattered sites. The average age of our buildings is approximately 80 years, and they do not currently have central air conditioning. HABC respectfully requests an exemption for public housing authorities on Senate Bill 757 due to fair housing issues that may arise, as well as significant capital expense that meeting the requirements of the bill would impose, among other concerns. In its current form, the bill requires a landlord to provide air conditioning units for households with children aged 3 and under, and/or adults aged 65 and older. HABC believes that limiting the requirements to these age groups would have discriminatory impact under the Fair Housing Act on the protected classes of families with children and persons with disabilities. Fair housing laws would not permit HABC to selectively install air conditioning based on the criteria in the bill, since such actions would discriminate against families with children older than 3 years old. Additionally, including the elderly in this bill, but not non-elderly persons with disabilities, would discriminate against non-elderly persons with disabilities, which is also a protected class. SB 757 would result in substantial cost burden, in addition to the cost of purchasing, installing, and maintaining air conditioning units for potentially up to 6,000 public housing units, which already have considerable immediate capital needs. There would also be significant impact on the increased electrical load to our aged electrical infrastructure, leading to mass blackouts and brownouts. HABC would have to overhaul entire electrical systems, which would take well over 2 years from concept design to completion. The estimate to install basic air conditioning in one of our larger public housing developments, such as Latrobe Homes, consists about approximately 670 units, would approximately be $800 per equipment installation. To maintain the cooling levels specified in the bill, a one-bedroom unit would have to have at least 2 installations. The number of installations would increase with the bedroom size of each unit. In addition, the electrical infrastructure would have to be assessed and likely upgraded to be able to handle the increased electrical demand for each apartment building. For example, for a development like the Trove Homes built in 1941, the electrical upgrade to the side building and units, as well as the installation of window air conditioning, would be approximately $9.5 million. This would cause HABC to divert its already limited federal funding to meet the requirements of the bill and impact our ability to provide housing to those in need. HABC's public housing residents can purchase and install window air conditioner units within their dwelling units when central air conditioning is not provided. However, if an air conditioning unit is installed in a residence with only one emergency exit, it would be considered a blocked egress and would violate HUD's regulations. This would result in a finding on our yearly HUD inspections, which would impact our funding. Further, HUD does not consider air conditioning a covered utility for public housing, except in certain circumstances. This means that residents, I'm sorry, is my time up?
Yes, ma'am. Thank you very much.
Okay, thank
Do we
you.
have any questions? All right, thank you very much.
Thank
That's
you.
going to conclude the hearing on Senate Bill 757. We are going to move on to Senate Bill 762. Senator Carter.
The hour's growing late. This is my last bill of the day. So let's hope to get through this. This should be not too complicated. It's a bill we've passed before. I want to bring up my panel. Owen O'Keefe, Christine Dufour, Ron Phillips, Stacy Jefferson, and I'm going to assume Neil Franklin is virtual, because if you all got Neil Franklin here, I'd be very impressed. Oh, okay, he's not even here. Okay, well, you're happy, one less witness. Oh, Christine Dufour is virtual. Okay, so we've passed this bill before, so I'm just going to move favorable. It's literally the same bill we've passed before. It was vetoed. We didn't override the veto. The House version of this bill has already passed the House and been sent over here. This is a paraphernalia bill. This is a bill about decriminalizing paraphernalia. I guess I should go through it for the new people because you haven't heard it the last 3 times or so that we brought it here and it did pass. The bill would do a number of things. It would decriminalize paraphernalia used to administer drugs that's ingest, inhale, or otherwise introduced into the body, reduce the criminalization of people that use drugs, which we know does not help engage them in supportive services such as harm reduction programs or drug treatment. It would streamline the confusing and unjust patchwork of exemptions in current law for paraphernalia that confuse the police and result too often in program participants who are authorized to carry paraphernalia still being stopped, harassed, and even potentially arrested by police. It would reduce the risk of police being stuck by used needles because there is no longer a reason to lie about possessing them. If you're following me here. It would encourage people to use clean supplies every time to prevent transfer of bacteria, and infectious diseases. It would also encourage people to dispose of used supplies in a proper location instead of trying to get rid of them as soon as possible to avoid catching a charge. So I will not belabor my testimony, but I want to be clear, this is paraphernalia, not drugs. And as we move toward understanding that we need to treat this as a health issue, I think this is a common sense bill. Maryland's actually behind many other states in even addressing the issue. I would ask you to listen to the testimony of the people with the lived experience in particular, as well as the harm reduction advocates who have had firsthand experience of the harms that continue to criminalize paraphernalia have created. Thank you.
Just come up to we'll come on up to the podium. Thank you.
I apologize. I'm used to the house. Thank you. Good evening, Chairman and members of the Judicial Proceedings Committee. My name is Owen O'Keefe, and I'm the policy manager of Baltimore Harm Reduction Coalition, and our organization is in strong support of Senate Bill 762. I'm also a lifelong resident of Maryland, from Frederick County to Prince George's County, and now Baltimore City, where I call home. As Senator Carter described, this bill will decriminalize paraphernalia used to ingest, inhale, or otherwise introduce drugs into the body. This bill will not decriminalize the drugs inside of the paraphernalia or decriminalize paraphernalia that's used to sell or manufacture drugs. In 2015, Maryland decriminalized paraphernalia for cannabis use, but left out paraphernalia used to administer other drugs such as heroin and cocaine. While this includes items such as syringes and cookers, items that are given out for free by the 22 authorized syringe service programs in the state of Maryland, including ours. While current law carves out an exemption for participants of syringe service programs, proving your participant is confusing and applied differently when left up to the discretion of individual officers. My colleague will speak more to what this identification process looks like, but the amount of time we must spend coaching participants on how they can protect themselves from arrest in the event that they are stopped cannot be understated. We could be using this time to educate about safer drug use practices that reduce the spread of bloodborne diseases such as HIV and hepatitis, and provide support such as referrals to housing, drug treatment, and other services they may need. I'd also like to take a moment to address the opposition we sometimes receive. First, that if paraphernalia is decriminalized, there will be little to no opportunity to enter treatment through a diversion program. This is not true. Most of the successes of LEAD programs come from social contact referrals, which empower officers to assist those in need without making an arrest. The idea that people whose lives involve drugs need to be arrested in order to begin treatment is incredibly misguided and results in disproportionately negative outcomes for Black people and poor people. Second, that this will encourage drug use and escalate overdose rates. Over 30 years of research shows that increasing access to sterile paraphernalia through syringe service programs does not increase drug use or overdose. For these reasons and more, I urge a favorable report on Senate Bill 762.
Good evening, Mr. Chair, and members of the committee. My name is Stacy Jefferson, and I am the Director of Policy and Stakeholder Engagement with Behavioral Health System Baltimore. We're the local nonprofit organization that oversees mental health and substance use disorder services for Baltimore City. As mentioned, this legislation will actually eliminate barriers that prevent people from seeking treatment and supportive services. As referenced in my written testimony, I just want to point out that there is evidence that shows when there is less fear of arrest, individuals feel safer accessing services, and they're less likely to discard syringes quickly in parks, playgrounds, and other public spaces, therefore making our communities much safer. And I just want to quickly just leave you with a story. And so as a young girl growing up in Baltimore City in the late 80s and early 90s, I was no stranger to syringe litter. One of my first memories is of my mom teaching me to be careful of needles on the playground in my school because I could get really sick. And I knew what a needle looked like because my uncle was a type 1 diabetic. And so here I am many years later, and I hear the same concerns expressed by community members for their young children and the children in their communities. And so I asked this committee for a favorable report on Senate Bill 762 so that the current generation of young children won't grow up and have to have the same concerns and same fears for their children. This legislation will make our communities safer. And so I ask again for a favorable report on Senate Bill 762.
Good afternoon, Senate members. Chairman, my name is Ronald Phillips, and I'm here to tell you a story. I'm here to tell you a story about one of my clients. We'll call him Petey. He was really, really sick. He tried to hold his job. So he was in between doses of heroin. He would stash his works, which are tools, syringes for y'all who don't know. And he was so sick that he went to his spot where he put his tools and couldn't find them. So he went into an area that's commonly known for people that use drugs, and he just found any old syringe and he used it. He contracted hepatitis C. And the reason why I told that story, because he was so afraid to get arrested for a syringe. You know, and that's why I'm here today to move you to just decriminalize this paraphernalia. I mean, the marijuana laws are relaxed, but people who smoke marijuana can't walk around with the pipes because it's illegal. So yes, please just decriminalize paraphernalia. It makes sense. Thank you for letting me testify.
Any questions? No questions. Thank you all very much. Going to move to Catherine Billop, Jessica Emerson, Elizabeth Hilliard. Let's see. Kristen DeFore, you called her earlier. Oh, okay. Thank you.
Thank you, Chairman Smith and members of the Judicial Proceedings Committee for the opportunity to speak this evening. My name is Catherine Billop. I'm a family nurse practitioner in healthcare for the homeless in Baltimore City. Every day, my work brings me face to face with the failures of decades-long policy that we know simply does not work. The war on drugs socially stigmatizes drug users, promotes incarceration over rehabilitation, and disproportionately affects people of color. This system is failing my patients, and it is failing me as a clinician who understands substance use disorder in terms of chronic disease and as a public health issue, not a criminal one. The role of safe use supplies, such as sterile syringes and smoke kits, have been consistently demonstrated. They are evidence-based solutions to overdose deaths and the transmission of infectious diseases like HIV. The COVID-19 pandemic has made it abundantly clear that access to healthcare, including safe use supplies, is not equitable. Fear of punishment from police remains a significant barrier to accessing life-sustaining resources in the community. I'd like to share with you two patient stories that highlight the need for reform. I met Sam in my office, a 23-year-old originally from Western Maryland. He lost his job as an electrician during COVID, became depressed, and soon relapsed using heroin for several months. Access to services were decreased in the pandemic, especially in rural areas. When available, he attended a mobile syringe service program, an SSP, but frequently noticed police parked in the same area. Sometimes his friends were followed and questioned by them. He became reluctant to venture out at the risk of being arrested holding tools. Supplies ran low. Feeling helpless, Sam reused needles from other injection drug users. Fast forward a few months later, he is 3 weeks sober, enrolled in a drug treatment program, and presents to me, his new PCP, for a physical and baseline blood work. Results from our initial test revealed a novel HIV infection. He was devastated, as was I, knowing this could have been prevented with safe, legal, judgment-free access to sterile equipment. I met Cindy during my weekly rounds at an outdoor encampment. At 34, she is likely to lose a leg due to wounds associated with injection drug use. She admitted that she recently went to a hospital but left after her syringes were confiscated while she was having an MRI, imaging that showed the infection had spread from the skin to the bone. She left against medical advice. Folks like Cindy who suffer from acute and chronic illness rely on others to retrieve harm reduction supplies on their behalf. Community members are less likely to venture to this assistance if they know that they cannot receive these things. I urge the committee to join me in providing compassionate, evidence-based care to people using drugs to promote every chance for recovery among those hardest hit by the pandemic. I ask for favorable support with amendment of Senate Bill 762, prevention of needless incarceration, death, and illness transmission through the decriminalization of drug paraphernalia. Thank you.
Good evening, Acting Chair, remaining members of the committee, Elizabeth Hilliard, here on behalf of the Maryland Office of the Public Defender. As you heard from Senator Carter, you've already passed this bill, so I see no reason not to do it again. I will, however, reiterate, drug use, addiction, and drug abuse are public health issues. You have heard horrendous stories today about overdose, the misuse, the mistreatment of addicts when they seek help. We cannot penalize nor criminalize our way out of addiction and out of the public health crisis that surrounds opioid use. Decriminalizing paraphernalia is a simple and easy step forward to destigmatize drug use, the mental health issues associated with drug use and addiction. And it is an easy way to ensure that our communities, our community members, and our Marylanders are safer. We urge a favorable report on Senate Bill 762, and we appreciate Senator Carter's continued efforts to pass this bill. Thank you.
Thank you. Any questions from the panel? All right, thank you very much. We're going to call Harriet Smith, Jesse Dunleavy.
Good evening. My name is Harriet Smith. I'm the Director of Services and Education at Baltimore Harm Reduction Coalition, where I'm a syringe service provider. We're a part of a network of 22 similar programs across the state. Research consistently shows that encouraging people and protecting them in participating in programs like ours means that they're more likely to take up safety measures, including not sharing syringes, using a new syringe for each injection, more likely to utilize healthcare system before concerns become severe, even deadly. The converse is also true, that when we, make accessing our services harder, right? When we criminalize their behavior, they're more likely to use syringes more than once, share syringes, and this all places people at grave risk, particularly around the contraction of HIV, but also injection-related wounds and other concerns. Currently, participants and staff are exempt from criminalization of paraphernalia, but only if we can show police proof that we're a registered participant or staff member. This is proof, right? This is a tiny business card. I have to dig into my backpack, find it, probably wrinkled, if I have it. And I have to convince the officer that the unique code on the back is me and not somebody else. That is completely up to the discretion of the officer. And that is more likely to be confusing to officers who are in counties where these services are newer, not Baltimore City, like where I'm from. So I don't know about y'all, but I lose business cards constantly. I'm sure you get lots of them. Lose them constantly. Having to produce this and advocate for myself in a really tense interaction with law enforcement is not the way we want to go. It's going to catch up way too many people in criminalization that could have been avoided. And honestly, criminalization that makes things more unsafe for them. So I hope that when your colleagues or constituents ask you why you support this bill, you can confidently tell them that removing the criminal penalty for carrying tools encourages people who use drugs to go to syringe service programs. And that in turn helps them get help. Thank you so much.
Hi, my name is Jessie Dunleavy. Thank you for listening to me tonight. Thank you, Chair Smith and the committee. I appreciate it. I am an advocate for drug policy reform. I'm a retired educator and I'm a lifelong Marylander. It's really satisfying to witness the forward thinking with regard to understanding that harm reduction initiatives do indeed save lives. I've seen this unfold slowly over the 6 years since my son died of an overdose, a time when there were no services whatsoever available to support him, despite my joining his quest. It was an era of abstinence or die. Instead of health-centered care, he was consistently shamed, incarcerated at one point for a relapse, where he was physically abused, consistently hungry, and couldn't buy food in the commissary because the green dot money cards that I mailed him to enable him to do that were stolen from him the minute he opened the envelope because he had disabilities and was a target. That experience did him no good. Had he gotten the health care that he and I sought and some reassurance that he was worthy, which he was, he'd be here today and he'd be productive. I can't fight for him anymore, but I can fight for all of the sons and daughters out there who may encounter similar treatment. But here's the thing. We know that these harm reduction initiatives save lives, but we continue to build barriers instead of bridges. We complicate understanding and we shortchange outcomes. Every health organization in the world says two things: increased harm reduction is needed and reducing punitive policies is needed. This bill does both. The American Medical Association most recent annual report says legislators need to know, and this is an exact quote, "The nation's overdose death epidemic will not end without increasing low barrier access to safe supplies. Preventable deaths will continue because of multiple overlapping public health and public policy half measures." So I ask you to support this bill. Decriminalizing paraphernalia is about public health. It builds trust and it ends the shameful inequities that we have bestowed on people and ruined so many lives. Thank you again so much. Please support this bill.
Thank you very much. No questions. All right, we're gonna move to our virtual witnesses, Ms. Kristen DeFore, Nancy Rosen Cohen, and Jude Young Park.
Good evening. My name is Nancy Rosen-Cohn. I'm the Executive Director of the National Council on Alcoholism and Drug Dependence. We strongly support Senate Bill 762 for many of the reasons you've already heard. This bill would decriminalize the possession of items that can be used to inject, ingest, inhale, or otherwise consume a controlled dangerous substance. As Maryland does continue to implement programs and strategies that replace the harms caused by substance use, the decriminalization of paraphernalia will continue to help ensure that people are accessing services such as the services you heard Harriet speak about. And decriminalizing paraphernalia, we will reduce the need for people to reuse certain items that may contribute to the transmission of infectious disease. This will have a positive public health impact on the spread of HIV and hepatitis C and save money in the reduction of needed health services. Therefore, we urge a favorable report on House Bill 173. And I thank the sponsors so well and all of you for the time to do this. Thank you.
Thank you, Ms. DeFore. Do you need to unmute, Mr. Oh, all right. Mr. Ford, we're having an issue hearing you at the moment. We'll go to Ms. Park and we'll come right back to you.
Hi, can you hear me?
Yes, ma'am, we can hear you.
Great, thank you. Hi, good evening, Senator Smith and members of the Judicial Proceedings Committee. My name is Jude Park. I'm here in favor of Senate Bill 762. I'm an epidemiologist and assistant professor of medicine at Brown University, and I've lived in Baltimore for 12 years with my husband. I wanted to just highlight that these bills and this law has been on the books for many, many years. And unfortunately, entire generations of Marylanders and people in many states have been burdened with criminal records for possessing simple things like syringes, cotton balls, Ziploc bags, spoons. And these laws definitely hamper their recovery. So what this looks like in practice is that the same sterile syringes and cookers that are given out by health departments to reduce infections are confiscated by police and thrown away. But I'm hoping that Maryland will join 15 states like Massachusetts, Rhode Island, New York, and DC, where drug paraphernalia is no longer a crime. I've talked to thousands of people who use drugs across Maryland, and many people are afraid of carrying these life-saving preventative tools. And national surveys show that these laws specifically target people of color. And so many researchers agree that arresting people for possessing evidence of their addiction is very inefficient and inhumane. So let's move away from punishment and wasting taxpayer dollars. Please give this bill a favorable vote. Vote for science and against racism and fear. Thank you.
Thank you, Ms. DeFore. Nope, still can't hear you. And it seems to be on your end, but you look unmuted. You know, still. I'm sorry, Mr. Ford, we cannot hear you. I believe, have you submitted written testimony? No, okay. I'm sorry, we're gonna have to move on then, okay? Thank you very much. All right, any questions for anyone? No? All right, then that ends the bill hearing on oh, is there one more? Oh, I'm sorry. One more, Miss Dana Schultz.
Hello, my name is Dana Schultz and I live in Anne Arundel County. I hold a bachelor's degree and master's degree working with families and children and incarcerated juveniles, and I'm a combat veteran. And when I saw the lineup of the bills today, I knew I would be here, so I thought I would look at this one. And the verbiage manufacturing, distributing, or dispensing of a controlled substance sounds very dangerous for Marylanders. To me, it sounded more like drug dealers, not just the addicted individuals. And I just want you to look at crime rates and the suffering that is brought to Marylanders due to drugs. And the fact that decriminalization is not working. It's allowing destruction of our society. And the so-called safe drug use is killing our society. This is an extremely low bar for achievement for Marylanders. And decriminalization is not care for drug use. So I just thank you for my time to share my comments.
Thank you. Any questions? All right, if not, that will end the hearing on Senate Bill 762. Senator Meeks, are you ready? Yeah, I'm ready. All right, this is Senate Bill 504.
Thank you very much. What is it? Good evening or good night? Good evening. Mr. Chairman, Vice Chairman, members of the Senate Judicial Proceedings Committee. I want to invite my panel up. Matt Hill is with me today from Public Justice. I think Council Member Christina Rigby of Howard County, the Howard County Council, Erica Palmisano, who's a landlord, Vivian Tadabod from CASA, a tenant, and Anik, I said it right. And I'm sorry, Annika Debar Gronke from the Lawyers Committee. Let me get right to the point because we've been listening to a lot and we have a lot more in front of us. This is a statewide enabling. SB 504 is enabling. It is not a mandate. It tries to handle an issue that we've been talking about for many years. It's enabling legislation that would simply authorize counties, allow them to, including Baltimore City, to adopt what so many other states have done, to adopt a just cause or good cause limitations on lease non-renewals. Again, this bill would only allow law or ordinance provisions to stop a landlord of a residential property from failing to renew a lease during the lease period or from terminating a holdover tenant without just cause. Here's why this legislation is needed. Mr. Chairman and Vice Chairman, this legislation is needed because we all know that housing is a human basic need. And the urgency for housing security is a priority for all of us. Being displaced from one's home has a tremendous negative impact on vulnerable residents in our community, like those who are many who are in my county, from Oxon Hill to Tacoma Park. It makes it very difficult in finding and maintaining a job, student residency, homelessness, not to mention a number of other negative impacts. Our current system creates an imbalance of power when a landlord can remove a tenant from their home with just 60 days notice and no reason provided, which causes residents to avoid out of fear, reporting unsafe conditions, requesting necessary repairs out of fear of retaliation. So this bill will protect our residents and vulnerable neighbors from unjust eviction, but it will also give local jurisdictions an option to enact this legislation in accordance with the state law. Enabling legislation would allow it, them to do this. Now, I know I've listened to and I've read a lot of letters from the opposition, and I've also been on both sides with them and sometimes not with them. And as I've read it, I've heard them say, well, this will prevent us from being able to get rid of a nuisance tenant. It will not. Nothing in the statutes as they are now, that would allow a landlord to evict a person or to bring a lease to termination because they're nuisance or not safe or they're violent. All of those things remain the same. It simply says, and it's they will explain it. So I'll stop here. It simply says that you have to give some notice. I am a landlord. I've been a landlord about both residential and commercial. I understand that. I understand that there are some persons that you may get upset with and you don't really, but you have to go through a process, especially with the residential. And we've practiced that. And I hope that you'll give us a favorable report on this very small bill, but a very positive impact. So I'll stop now and thank you for hearing. Okay.
Thank you, Senator Muse. Again, Matt Hill, Public Justice Center. Members of the committee, did you know that today in the state of Maryland, there are over 75,000 units of high quality, privately owned and privately operated housing where all tenants have just cause evictions in their leases? 75,000 units, privately owned, privately operated. And the sky is still there. These are units that have low income housing tax credit funding, right? But they're still privately owned and privately operated. They have just cause eviction in their leases, and they are still able to evict tenants who should be evicted because of some sort of just a good cause that the landlord has for that eviction. This is not complicated. We've seen these cases in our practice. At the end of the lease term, the landlord tells the tenant, okay, here's why I'm evicting you. Maybe you paid late all the time and you owe me $5,000. Okay, that's in the notice. Tenant has 60 days to move out. Now, done, and the tenant has to move. Sometimes, though, the non-renewal is retaliatory. So the landlord claims that maybe the tenant was being verbally abusive to the staff. Tenant comes to us and says, I've never verbally abused the staff. I just haven't had hot water in 3 months. And so they're just trying to evict me. They're trying to non-renew my lease because I've been complaining and trying to maintain my right to habitable housing. If that's the case and the landlord brings the tenant holding over, then I have to go to court and we argue about whether or not there was just cause. That's all this bill does. And again, that happens in over 70,000 units of housing across the state of Maryland already. This is not a new concept. And some of my other colleagues will talk about that. This is not much different in some ways from fair housing law, in the sense that the landlord cannot refuse to renew a lease right now in the state of Maryland because of someone's race or gender or family size. This simply says, okay, and the landlord, you have to have just cause to non-renew that lease. And so again, I just want to emphasize what Senator Muse said, which is that this is local enabling legislation. This is not requiring it throughout the state. Thank you.
Acting Chair, Vice Chair, Vice Chair Walt Stryker, excuse me. Remaining members of the committee, my name is Annika Dunbar-Gronke. I am an attorney for the Fair Housing and Community Development Project at the Lawyers Committee for Civil Rights Under Law. The Lawyers Committee is one of the nation's leading racial justice organizations. We were formed in 1963 at the request of President Kennedy, and the Lawyers Committee uses legal advocacy to achieve racial justice, fighting inside and outside the courts to ensure that Black people and other people of color have the voice, opportunity, and power to make the promises of our democracy real. Our Fair Housing and Community Development Project exists to fight discrimination in housing through enforcement of the Fair Housing Act and to promote greater opportunity for low-income people and people of color to access housing. Because of this work, we urge this committee to issue a favorable report on Senate Bill 504 for the following reasons. First, the bill would not establish just cause laws anywhere in the state of Maryland, as Senator Muse kindly outlined, but would instead allow county governments, which are best situated to determine how to address housing issues for their communities, to pass just cause protection laws if and how they are appropriate in the local context. Second, academic literature is extremely clear that just cause laws lower the number of evictions in a locality and ensure low-income tenants have housing stability. Moreover, there's no evidence to suggest that just cause protections harm development. New Jersey has had a just cause law in place since the mid-1970s and is one of the most booming real estate markets in the country. Seattle's occupied rental unit count increased uninterrupted after just cause was passed in 1980. Washington, D.C. has had just cause since 1985. Philadelphia has had them since 2018. And both of those housing markets have had increases in renter occupied housing units by 8.5% and 12% respectively between 2018 and 2021, while the national increase for rental occupied housing was just 0.7%. Finally, just cause can protect all tenants against retaliation, for organizing for better conditions, for expressing political viewpoints that a landlord may not like, for joining the military, and et cetera. All tenants deserve to have their tenancy protected against bogus non-renewals. They're good for communities, they're not bad for business, and for those reasons and many others, we urge a favorable report on Senate Bill 504.
Good evening, and my thanks to the chair and Senator Muse for the opportunity to speak with you today. My name is Erica Palmisano, and I'm a resident of District 12A. I am a member of Showing Up for Racial Justice Baltimore, a group of individuals working to move white people for equity and racial justice as part of a multiracial movement in Baltimore City, Baltimore County, and Howard County. Surge Baltimore is working in collaboration with Casa de Maryland and Renters United. I and my partner are also the landlords of a single property in Howard County. I support Senate Bill 504, along with many today who are speaking to the racial and social inequities of eviction, but I'm a mom and pop landlord, and so I speak from that experience. I am not worried about how a just cause eviction statute might impact me. Were such a statute proposed in Howard County, I would be able to manage my property as I have always done, because most of the reasons landlords have to evict or not renew a lease could remain in place. What would improve in that case is the social fabric of the community in which my tenants live and from which my property derives much of its value. Good tenants would be better empowered to remain in their communities if we prioritize their staying over the heedless pursuit of profit above all. I'm not alone in wanting the community that surrounds my property to grow healthier and more robust through stable tenancy, and I anticipate working with like-minded folks to enact just cause legislation in my community. I look forward to the bill's passage, and thank you for your consideration.
Yeah, we can turn the mic on. Okay, all right, let me move the chair.
Good afternoon, Chairman Smith and members of the committee. My name is Vivian Tatabod. I've lived in Tacoma Towers and District 47B. I'm a nurse and I have always put in my best for our nation during the pandemic. I was always at work, making sure I attended to all the patients who needed help. Because of this, I also fell sick. I have been sick for months. Look at me now, I can't go to work anymore. I have been in a wheelchair for 3 months and counting. My landlord, Schweb Partners, refused to renew my lease without any justification. I don't know why they are not renewing it, and they gave me until the 31st of this month, that's March 2022, to leave my apartment. I don't know what to do. I don't have anywhere to go. My landlord's from New Jersey. They are trying to price out Black and brown people in my building. They are greedy. They refuse to renew our leases because they want to hike the prices of rent. I therefore plead with you, delegates, to support the Senate Bill 504, just cause eviction legislation, so that people like me can be saved from unjust evictions, especially when, the county is offering rental assistance. I'm hoping, you guys can look into this and pass this bill. Thank you for your time.
All right, excellent. Thank you very much for your testimony, ma'am. Thank you. Questions from the committee for this panel? All right, seeing none, thank you all very much. Thank you for hanging in there with us. All right, we'll bring up the next panel. Shauna Fulcher, Mr. Losak, Matt Losak. Is Chris Perry here? Mr. Perry? Hey. Patricia Beckham. It's whomever wants to go first. Before you all start, Mr. Losak, you can come on up to the podium, but I want to acknowledge we have Delegate Wilkins in the House. She's the chief sponsor of this bill in the House of Delegates and has been the champion of this initiative for several years. And she's also my district mate, so everyone in the Senate has to be nice. All right. All right, Mr. Losak, you're up.
Good afternoon, Senator Smith and Chairman Smith, members of the committee. My name is Matt Losak. I'm the co-founder and executive director of the Montgomery County Renters Alliance, and I will be mercifully brief. This bill has gotten more and more attention each year. We have had scores of renters speaking in favor of it. Dozens of senior leaders from across the state, from the mayor of Baltimore to the county executive of Montgomery County, whom you'll hear from shortly, from members of Prince George's County, MACO. There is support for this bill across the state. We also believe that it has general support in the Senate, and we believe that it has general support in the House of Delegates. And for the first time in over 8 years, we have heard favorable comments. And quote, I will quote him, the governor said, just cause is important. So we believe we have an environment where this sensible bill that, as Senator Muse points out, all it does is allow a local municipality to choose to enact it or not. If anybody thinks it's a mistake, then let the localities make that mistake. Most of them think it's not going to be a mistake, but they can enact it in any form that they want or not enact it at all. It is very basic legislation. Housing is far too important. If you're going to kick somebody out of your home, you need to have a good reason. We urge, the Renters Alliance urges that you have a favorable report and let it pass. Thank you.
Thank you, Mr. Losak. Before we bring up the next in-person witness, I've just been told that we have our county executive who is here remotely. So I want to make sure we give him an opportunity to testify so we can get about the business of running the county. So Mr. Executive, when you're ready to go, we are ready to receive your testimony. Our apologies for keeping you waiting.
It's not a problem. We all have lots of work to do. Can you hear me?
We can hear you, and I think you're here. You are. Welcome.
Okay. Welcome. Thank you very much, Mr. Chair, and thank the Vice Chair as well, members of the committee. For the record, my name is Mark Elrich. I'm the Montgomery County executive, and I'm very excited to be here today to testify in support of the Just Cause bill. And I want to thank Senator Muse for sponsoring this legislation. As you know, this bill does not require that any jurisdiction pass Just Cause legislation. It simply enables jurisdictions to do this. But I can promise you, if this county has the authority to do this, we will pass legislation that requires just cause in the case of eviction. As you know, the legislation does not interfere with the landlord's ability to get rid of tenants who are disruptive, destructive, or who are simply not paying rent. The landlord still has the right to decide to do what they need with their party. However, the bill, if passed by you and your colleagues, would prevent landlords from silencing tenants who are facing serious problems, particularly code-related problems that should and need to be addressed. I saw this happen in Tacoma Park when I was a council member back there 20 years ago, and the city began the initial efforts to convince the state to pass just cause protections almost 20 years ago. So this has been a long road we're on. Right now, tenants can be evicted if they're seen as difficult because they're reporting code violations like rodent infestation or mold or other life safety failures. Other tenants are scared to speak up when they're worried because they're worried about retaliation. The only change from today to today, from when this all started, was that landlords actually used to tell tenants, I'm going to evict you when your lease is over. They'd send letters saying what they were going to do to the tenants. And because the state had the sense to pass anti-retaliation legislation, the landlord's lawyers told them you can't say this anymore. So the big change is landlords don't ever say, I'm going to evict you. They're never going to write a letter saying, I'm going to evict you because you called the housing department, yet these things continue. They're worried that the tenants are worried that their leases won't be renewed. And when they see other tenants who've complained and are evicted only because they've complained, not because they're bad tenants or not because they failed to pay rent, it sends a very clear message to keep your mouth closed and deal with what you have to deal with. They worry that if they speak out on important and straightforward issues, they're not going to have the home that they have. It's a real problem. It's still happening today. Having stable, safe housing is essential to allow tenants to be part of the community. It strengthens our schools and the greater community. Anything we can do to reduce mobility, particularly in the low-income families in our communities, is really important, both for the stability of the community and for the well-being of the students. This bill is an important part of the efforts to make sure the tenants are able to be more fully part of the community. I hope you'll support this bill, and I really thank you for your consideration today.
Thank you very much, Mr. County Executive. We have one question just from Senator Muse, and then we'll move on to the panel. Senator Muse.
If I may, Mr. Chairman, just want to say thank you, Mr. County Executive, for endorsing this and for helping us to get this passed. It will help a number of people. I know you've been busy today, but thank you, my friend, for that.
Thank you.
Excellent. Thank you for hanging in there with us. All right. Now, Mr. Perry, if you're ready to go, we're ready to receive your testimony. Welcome. Another District 20 resident, military veteran, good friend, all around good guy.
Good evening, Chairman Smith. Thank you very much. Vice Chair Walt Stryker and Senator Muse, thank you for your leadership in this matter. My name is Chris Perry, and I'm a senior citizen and Air Force veteran, as the chairman has pointed out. My wife Kathy and I are long-term renters. I've spoken to the committees of the General Assembly during past sessions regarding just cause. My wife and I rented our home for over a dozen years and hope to continue to do so for as long as we can provide our rents do not increase unreasonably beyond our fixed income, and provided our landlord does not decide to order us to vacate our home for no justifiable reason with just 60 days notice. Now, seniors like us increasingly depend on our homes to be stable. The idea that those of us who rent our homes should be seen as temporary residents who at any time should expect to move is not only unreasonable, but hazardous to our health and damaging to the overall welfare and prosperity of the community we belong to. Kathy and I are renter activists. We believe in speaking up when building conditions need improvement, but we are constantly anxious, like all renters, that to do so might mean eviction. We ask you to move this legislation on to an up-down vote on the Senate floor. You don't have to agree with just cause protections, but you should agree that the people of each jurisdiction should have a right through their elected representatives to enact just cause protections to the degree they see fit. As you can see today, the request for this authorization is statewide. We are not college students living in a dormitory or tourists staying in an Airbnb. We're permanent voting residents who have a stake in our communities and our homes. In past years, I have appeared before the General Assembly with a similar request that you favorably report this bill supporting just cause protection and make the common sense that many renters feel is about time to be the law of the land of the state of Maryland. Thank you.
Good evening. My name is Shana Fulcher. I'm the city councilwoman for Ward 1 in Tacoma Park. I'm here today because Tacoma Park strongly supports this legislation, and we wanted to show someone in person supporting it. The stability that long-term residence offers to families and children is very important. Even a small move can move a child from one school to a different school, and that can be extremely disruptive to their education. Home ownership is not going to be possible for everybody, but this is one of those possibilities where we can provide something that homeowners enjoy, which is the stability of knowing that they're going to live in the same place for a long period of time, to renters. Please allow the policymakers that work closest with their communities to make the decisions as to whether or not just cause eviction is provided. As an elected official, I'm constantly trying to find ways to better interact with renters in my community. And I get the feeling that they don't feel like I care about what they have to say. And I think part of that is that they don't know how long that they're going to get to live in Tacoma Park. And so in order to make them feel like they're being heard, let's allow them to know that their stay is not going to be cut short by the whim of a landlord. I'm fortunate to have set roots in Tacoma Park. I've been a longtime Girl Scout leader, and I invest my time in my community because I know I'm going to be here for a long time. And that is a privilege that I have as a homeowner. And that led me to become an elected official. So let's empower renters to be in the same positions that we are by having by having the stability to invest in their community, so that they can be here. Thank you.
Good evening, everyone, Mr. Chairman, Senators. My name is Pat Beckham. I am a retired registered nurse. I have worked in several arenas in healthcare, from emergency nursing to nursing education on a college level. I recently sold my home in Prince George's County and moved to Montgomery County in an effort to be close to my 4 sisters. 2 sisters residing in Montgomery County and 2 sisters residing in Tacoma Park, DC. That is when I learned that there was a law that I could be evicted from my home for no justifiable reason. Not only that, I think it's awfully unfair. When I retired, I moved to try to be in a much smoother environment to live out the rest of my time. I did not understand that I could, if I do all the things I should do, that I can still be asked to leave my home. Not only is it disrupted for me and other families, it's not good for the community as a whole. I would urge you, senators, to pass this legislation. It's important legislation. People and families, when they are worried about whether or not they're going to be asked to leave their homes for no just cause, it makes their quality of life less. Again, please pass this legislation and allow every jurisdiction to pass the legislation. Thank you.
Ms. Beckham, thank you so much for being here. It's nice to meet you, and thanks for coming up to testify. And Councilwoman Fulcher, thank you. Good to see you. And we'll turn to the committee for questions. Seeing none, thank you all very much. Good to see you all.
Thank you, Mr. Chairman.
Thank you for hanging in there with us. All right, we'll now move on to the next panel. We'll hear from, is Miss Bowie here? Lindsay Bowie. Sambul Alam. Christina Rigby. And is Nicole Sanchez here? And actually, let me.
Good afternoon, good evening, actually. Hello. Thank you for hearing my testimony. My name is Lindsay Bowie. My husband and I and our 2 small children are renters and we live in Gaithersburg. I'd like to start by thanking Senator Muse for introducing this important legislation that can make a real difference in the lives of many renters. The stability of our home for us and our neighbors is extremely important. We have formed deep roots in our community. Our son is a first grader at Thurgood Marshall Elementary School, where I serve on the PTA. We have family close by and we see ourselves not just as temporary visitors, but as permanent long-term residents. But if this legislation fails to permit our county to enact just cause eviction protections, families like ours, along with senior citizens and veterans, are all in constant threat of being told to leave our homes with just 60 days notice. Our son's elementary school boundaries are drawn such that no other multifamily properties feed into that school. So for us and our neighbors with children, a non-renewal notice means a change in schools for our kids. And with 40% of the student body residing in our apartment complex alone, the stress that comes with unstable housing inevitably spreads to teachers and staff and the community as a whole. We are good neighbors and good renters. We pay our rent on time. We deserve to live our life free of anxiety that our son or any of his friends will have to change elementary schools, not by choice, but for no good reason. That is why I encourage the members of this committee to support, to make a favorable report for this bill. Thank you so much for your time.
Good afternoon, Chairman Smith, and members of the committee. My name is Nicole Sanchez. I'm a paralegal at Casa de Maryland. Today, Casa is pleased to offer our support for SB 504. Casa is the largest immigrant rights organization in the Mid-Atlantic region with more than 120,000 members. Today, I speak on behalf of our members, most of whom are working class Black and Latina immigrants. In today's eviction landscape, a landlord can evict a tenant for virtually any reason through a tenant holding over eviction. Landlords do not have to offer lease renewals or give grounds for termination. They simply tell the tenant to get out. Though the arbitrariness is bad enough, these actions almost always have an ulterior motive: tenants' complaints about poor conditions or disputed fees. There are laws against retaliation, but these offenses are extremely difficult to prove. They provide only 6 months of protection maximum, and they require the tenant to be current on rent, which is problematic if the basis of your complaint is about the rent. It is easier for the landlord to avoid confronting these complaints and simply say, get out. Our members simply cannot get out. I'd like to tell you about a Casa member, Alberto. Alberto had pest infestation, broken appliances, and structural problems in his unit. He complained to his unlicensed landlord several times. Alberto did not want to leave because his child needed to finish high school nearby. Finally, he called the county. An inspector issued the landlord 13 violations. Within days, his landlord had to start the process of eviction. Alberto won his court case, but the next day, his landlord started the eviction process again. Working class communities should not be ripped apart just because a landlord decides for no good reason to evict them. Our members' schools and businesses are nearby. They don't have months of savings for moving costs and a new deposit. They are already intimidated by a landlord's power, and when they hear stories like the one I've just described, they keep quiet for fear of being evicted without cause. This law would allow local jurisdictions to combat such inequities, keeping families and communities together. For these and other reasons, we urge your favorable support on SB 504. Thank you.
So, thank you very much. Seeing no questions from the committee, thank you all very much for your testimony. All right, we'll move on. So, Sambul Alam, one going last time. All right, all right. I think we both have virtual for the last. So now we'll move on to the virtual proponents, which we can't pipe in because our TV screen is down. So with that, we'll move on to the opponents of the bill. We're going to try to accommodate the folks that are waiting to testify virtually, but we'll go on to the opponents. We'll hear first from Mr. Enton. Is Ryan Washington here? Catherine Howard, Bill Castelli, William Castelli, and Sasha Flores.
Hey,
Whenever you're ready.
thank you very much, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Multi-Housing Association. We are one of the largest residential landlord rental associations in the state of Maryland. You know, it's interesting. This bill, in some fashion, was in front of the Montgomery County delegation in the House of Delegates off and on probably for the last 4 or 5 years. It never moved out of the House. I know that the chairman, sits through the Montgomery County delegation hearings. While the bill hasn't moved over to the Senate, is familiar with the bill. It's had hearings in front of the delegation. So what this principle does, the underlying principle here, is that when you enter into a lease, a contract with someone, and that contract is over, notwithstanding the fact that you signed a contract that said this contract was going to expire on a date certain, that unless you meet certain criteria, the term of the contract is meaningless. You can ignore the term of the contract. And unless the other party meets certain statutory provisions, the lease can continue. It's not just a question of stating a reason. It's a question of whether or not the other party to the lease has met these certain requirements. And that's totally, completely contrary to all contract law that exists both at statute and under Maryland law. I can't think of another single statute anywhere in the state of Maryland that has ever said that, notwithstanding the terms of the contract as to the term, that we're going to ignore that, and you have the right to ignore the term, and unless certain conditions are met, you get to continue the term of the contract. We have consumer protection laws that protect consumers. But I'm not familiar with any law that's ever said that you can basically allow one party to extend the term of a contract. The other issue, I think, is that the bill has been in front of the General Assembly for all of these years. And now what this piece of legislation does is says, you know what? Rather than have the General Assembly decide this,
Mr. Enton.
we're going to let local governments decide it. So, we have lots of concerns about this bill. We've stated them over and over again in the House. We don't think it's an appropriate piece of legislation. And with all due respect to my good friend, the Senate sponsor, we'd urge the committee to give the bill an unfavorable report. Thank you.
Excellent. Thank you very much.
Good evening. My name is Sasha Flores, and I'm the Regional Operations Project Manager at Morgan Properties, a multifamily housing provider here in Maryland. I'm opposed to this bill for a few reasons, and the first one I'm going to discuss is the severe inconvenience that it poses to future residents. Not having the ability to have a firm, solid date when you'll be able to move into your future home creates some of those same issues that you heard others testify in opposition. I also would like to mention that not being able to address any lease violations in a timely manner, which prevent us as landlords from truly dealing with our tenant violations in a way that allows us to properly manage our communities, manage those living with us, manage those not just within the communities, but those affected outside of the community, as well as deal with concerns such as lease violations, maintenance issues, safety, and destruction of property. This bill creates a hardship by adding additional hurdles towards how we as landlords communicate with our residents and enforce the lease or perform basic functions of our jobs, such as repairing, servicing, and maintaining those homes and communities. This bill does not allow for us as landlords to take back possession if a tenant refuses to vacate for reasons that they deem appropriate, even if it's a direct violation of the lease that they signed and agreed to. And with that, I would like to ask this committee for an unfavorable report on Senate Bill 504. Thank you.
Thank you, Mr. Chair and members of the committee. Bill Castelli on behalf of the Maryland Realtors. And our members oftentimes are property managers representing kind of smaller properties, maybe single family homes oftentimes. They are also opposed to this legislation really for three reasons. The lease is really grants possession of a property for a specified period of time. That's what the lease is. So they believe that it makes sense that the parties agree to whatever that period of time is going to be, whether it's a month, a year, or whatever that time is, that the parties have understanding of it. And as the previous person said, have an idea of when that term comes to an end. But the other points I would like to raise about this bill is that one, although it may seem like there's this impression of the fact that landlords just want to kick tenants out, I mean, it really isn't the fact. It is very expensive to turn over a unit. You have loss of at least a month's worth of rent, which in many cases is going to be at least $1,000. Oftentimes it could be 2 months worth of rent. You have to oftentimes paint it. If you're dealing with a single family property, you're talking about potentially hundreds of dollars plus, $2,000 worth of rent. So it's very costly, and tenants and landlords oftentimes work together, but a landlord who's working well with a tenant is going to keep that tenant in the property for as long as they can because it is expensive. They lose out on a substantial amount of money. And secondly, this bill really defines that a tenant who only commits a substantial breach of the lease or substantial damage to the property. So it does contemplate that tenant could breach the lease. That tenant could create damage on the property. It's just as long as that tenant doesn't do a substantial damage or a substantial breach. So for those reasons, we recommend an unfavorable report.
Good evening, members of the committee. My name is Ryan Washington. For the record, I represent the Apartment Office Building Association of Metropolitan Washington. I'd like to offer some comments regarding how the concept of just cause evictions differ from the current eviction process. Currently in state laws, it provides that a landlord may only take possession of a dwelling unit from a tenant in accordance with the warrant of restitution issued by a court and executed by a sheriff under failure to pay rent, which is the most common, a breach of lease, a unlawful holding over after the expiration of the lease, and wrongful detainer. I say that all to say the phrase just cause eviction is a misnomer, as it has nothing to do with the formal eviction process in Maryland that I just described. Instead, it is a concept which would bestow on a tenant the legal right to reside in a rental dwelling unit forever unless the owner would prove in court that the tenant had violated one of the listed items considered prohibited under conduct of this bill. We've heard numerous testimony from proponents of this bill of retaliatory evictions. Virtually all testimony in recent years by witnesses advocating for this legislation has cited justification for fear of intimidation. If that is the primary concern, it's important to focus on existing state and local laws that protect tenants from retaliation. Specifically in state of Maryland, Montgomery County laws currently prohibit eviction or retaliatory action against a tenant as a result of a tenant filing a complaint with the landlord or filing a complaint against the landlord with the public agency. A landlord may not, as a retaliatory action, impose an unreasonable rent increase, threaten, coerce, or harass, violate privacy, or reduce the quality of or level of services to a tenant. If this law is violated, a court may award a tenant damages up to 3 months of rent, reasonable attorney fees, and court costs. I also like to highlight what my colleague from Realtors expressed. This is the cost of evictions. It costs thousands of dollars roughly to evict tenants. It's in best practice for rental housing providers to keep long-term residents, as the cost of renovating, advertising, and putting the rental unit back on the market is expensive. And with that, we urge a unfavorable vote on this bill. Thank you.
Yeah, thank you, Mr. Chairman. I am a landlord of 5 or 6 houses on my farm. And when I read the way this bill would work, I'll give you a couple of examples. One, sometimes I take a property, one of the 6, sort of out of rental, so I can fix it up. I'm not permanently taking it out, but I have to use my own discretion as to what I can afford and what I can't afford, when I can do it or when I can't. I assume that this bill passed, that I couldn't do that.
If I could, Senator.
Couldn't do it because it wouldn't, I was be taking it off temporarily to do maintenance that I think's appropriate, or I want to do because I want to fix it up, whatever I want to do. I don't think this bill would allow me to do that. I don't think I could evict the tenant.
What's interesting about this bill is in its former form as it was introduced, you would be absolutely right. Now, it's going to be up to every local jurisdiction to say to you as a landlord, even if you want to renovate it, even if you no longer want to rent it out, you're tired of renting it out. Even if you want to, move to Florida, I mean, whatever you want to do, if you don't, they're going to be able to say, if you don't meet X, Y, and Z, you can't terminate.
Well, let me just keep going. If I've had if I have a situation where I want to rent to a dear friend, they're not a spouse, child, parent, or grandparent, but they're a dear friend. And maybe they've lost housing and I need to help them. And that's my priority.
Yeah.
Under this bill, I can't do that.
Well,
Isn't that correct?
Under this bill, local government could say you can't do that.
That's what I
Hartford
understand.
County, Hartford County could say, Senator, you can't do that.
Right. I understand it's May.
Yeah.
And I'll give you a couple of other examples. My concern is even giving this to the local governments, this authority, unless they too think all this through. I've had tenants and I love my tenants. I try to keep them as long as I can because it's much easier for me. I totally agree with you. A good tenant is so valuable. You want them to stay. But I've had tenants that do things that are unsafe, but not illegal or not substantial breaches of the lease, like burning material too close to a house, which could jeopardize my insurance coverage. I've had tenants do things, my property's under an MET lease, which means I have to keep it fairly clean. And unfortunately, some of my tenants are not clean. And I had the MET come in and complain to me. I give you these examples as a few of hundreds I can think of that can't be anticipated, no matter how much people try to think this bill through. Even if we give it to the local governments, unless they think this all through, they'll never be able to legislate all the hundreds and hundreds of ways this bill would not work in an individual set of circumstances. I am so sympathetic to tenants who are good tenants that should not have their lives constantly disrupted. But I also think that there's might be a better way to do it. Isn't that so?
Yes, ma'am.
That's all I wanted to say. Thanks.
Yes, ma'am.
Thank you.
Thank you, Senator. Senator McKay.
Thank you. Mr. Hinton, Bob, so if I was going to rent from you, we have a beginning date, we have an ending date. Would anything preclude me to ask for some kind of a provision between you and I as a contract to have this holdover tenant added? That would be in the negotiations between you and I, wouldn't it be?
Obviously, you can negotiate, an option to renew. That's what you're,
That's, yeah, right. That's what I'm
and
trying.
there are options to renew and, all the time out there. I mean, the heart of this really is, I think that no landlord can say to the tenant, unless you can justify that I've done this, that, and the other, you have to stay on the lease. But what the bill does is the bill says, flips it around, and it says to the landlord, even though I agree that this lease would terminate on a date certain, period, unless you can meet these specific statutory criteria, I can stay there as long as I want. And I would tell you what is interesting about Maryland law is that we have in all jurisdictions except for Baltimore City, we have what we call a 3 bites of the apple rule. And that is the tenant, in Baltimore City, it's 4 bites. The landlord, we don't pay your rent, right? So now the landlord has to file an eviction proceeding. And you have the ability to pay the rent current before the sheriff shows up to move your stuff out. you can pay the rent current. And around the state, including every county except Baltimore City, you can do that 3 times. Now, most jurisdictions, an eviction proceeding takes 90 days to go through, maybe longer, 120 days. So basically, you can be a tenant who didn't pay your rent. You paid your rent 3 times a year. 3 times a year, and force the landlord to go to court to try to evict you, and then you pay a current. Now, and under that scenario, if I was a landlord, I'd say, you know what, this lease expires on June the 1st. You know, I'm not going to evict this tenant. I'm just going to terminate the lease. It's, you know, I'm going to say, you know, the lease is over. And so I don't have to deal with this tenant anymore. Under this bill, I don't think, you know, the local jurisdiction could say that's not a just cause. You can't terminate. That's the problem with the bill. It's just totally unbalanced, in my opinion.
Thank you.
All right, thank you, Senator McKay. Seeing no further questions from the committee, thank you all very much.
Thank you.
Thank you. We have one more witness who is joining us virtually. And Kira, I see you're here. Welcome, you're up.
Thank you. Thank you. Good evening, Mr. Chairman, members of the committee. My name is Kira Wolpone-Wellborn. I'm an Assistant Attorney General with the Consumer Protection Division of the Maryland Office of the Attorney General. I'm here today to express the division's support of Senate Bill 504. Landlord-tenant complaints, including complaints about lease non-renewals, rank among the top complaints the division's mediation unit receives each year. And as you've heard today, lease non-renewals cause unnecessary stress and displacement, not only for tenants, but also for communities. The examples you've heard today, children being forced into new schools, adults having to move away from lucrative jobs, and communities losing connections and relationships. As a result of the individual and community disruption created by no-cause lease non-renewal policies that Maryland currently has, the American Bar Association in its eviction policy guidelines has promoted the importance of just cause legislation and recommended jurisdictions adopt just cause eviction policies. Maryland can align itself with the ABA's recommendations with the passage of Senate Bill 504 today. As expressed in our written testimony, Senate Bill 504 is a tailored bill to permit local jurisdictions the flexibility to adopt housing policies that are beneficial to their residents and their communities. And for these reasons, the division encourages the committee to issue a favorable report. Thank you so much.
Excellent. Thank you very much. Thanks for joining us and hanging in there with us. Seeing no questions from the committee, that will end the testimony and the hearing for Senate Bill 504. We'll now move on to Senate Bill 845 with Senator Waldstreicher. We'll take a quick pause while he comes up to the podium.
Thank you, Mr. Chairman. If we could bring up my first panel, if you're amenable to that. While we're doing that, let me thank the committee for their patience this evening, as well as everyone behind me who have been waiting to testify, many of whom came from out of town. And so if we could have the first panel, I think, Sandy, you have that in front of you, and yes, please.
All right, so we've got Miss Smith, Diane Kraus, Alexander Frazier, and Dr. Strauss. Welcome.
Thank you again, Mr. Chair. Mr. Chairman, members of the committee, you know, every year we deal with cases that come down from the federal or state courts that we need to act upon. And the cases can seem important in the moment, but we pass a bill and session ends, and both the case and the legislation slowly fade from memory. And so it's easy to think that the Dobbs case may be one of those cases, but it is not. Agree with the court or disagree, it will be remembered with the same one name imprint as Marbury or McCulloch or Plessy or Brown or Roe. Dobbs fundamentally alters the question of who decides. And the answer is as simple as it is unnerving. We decide. The 11 of us in this room, the 47 of us in the chamber, the 188 of us who are part of this institution, we are called upon to decide. And I get it. It feels strange. Here we are senators, but most of our lives are lived outside of here as mothers and fathers and lawyers and police officers and preachers and businessmen. Who are we to decide core questions of life and death, of human dignity and bodily autonomy? And yet, that's exactly what Dobbs demands. And now that's what our constituents are demanding as well. When it comes to options at the end of life, when it comes to providing dignity and bodily autonomy in the face of a terminal illness, 71% of our constituents support the ability to choose medical aid in dying. That's 75% of Democrats, 66% of Republicans, 67% of independents, 73% of whites, 70% of African Americans, 66% of women, 76% of men, 82% of those who are pro-choice, a 49% plurality of those who are pro-life, 72% of Protestants, and 58% of Catholics. When it comes to bodily autonomy, Dobbs changed everything, and it changed the minds of Marylanders in favor of this bill. So what does this bill do, and how does it work? So let's lay out the named individuals in the bill. Number one, the patient. The patient must be 18 years old, must be a Maryland resident, must have the capacity to make a medical decision, and must be certified to have a terminal illness, meaning the patient has less than 6 months to live. Number two, the attending physician. This is the patient's doctor. Number three, the consulting physician. This is the physician who must confirm the terminal diagnosis and the patient's eligibility to use the act before you. Number four is witness number one. That's the family witness. This witness is usually a family member or loved one and is allowed to have a relationship to the patient. Number five is witness number two, the independent witness. This witness is the opposite of witness number one. They must be unrelated to the patient and have no interest in the person's will or estate. And finally, number six, the mental health professional. This is an optional, independent, licensed professional who may be required to sign off if either the attending physician or the consulting physician have any doubts about the patient's capacity. So now you know the named individuals. Here's how the process works. The patient must make 3 separate independent requests for a life-ending prescription. Request number one is to the attending physician and can be made orally. Request number two must be in writing to the attending physician. This request must be witnessed by at least 2 people. As I just stated, at least one of the 2 witnesses must be fully independent of the patient. Request number 3 can be done orally. It must be at least 15 days after request number 1 and 48 hours after request number 2. Of the 3 requests, at least 1 must be done alone with the attending physician. Both the attending physician and the consulting physician must independently certify 2 things: that the patient has the capacity to make a decision, medical decision, and that the patient's prognosis is terminal. In other words, that the death is likely within 6 months. At any time in the process, either the attending physician or the consulting physician may refer the patient to a mental health professional. During this time, no prescription is allowed. The mental health professional must determine in writing if the patient has the capacity to make medical decisions. Once the requests have been made and signed according to protocol and all required certifications of the attending physician, consulting physician, and if necessary, mental health professional, then the attending physician may write a life-ending prescription. The prescriptions may only be self-administered by the patient. The patient may withdraw the request at any time and does not have to use the prescribed medicine. Unused medicine must be disposed of lawfully. So you've already heard the speed bumps, the reasonable restrictions, the guardrails provided in the bill. Here are a few more of some guardrails that are important. Aid in dying by any healthcare provider is completely voluntary. Healthcare facilities and employers may prohibit a provider from participating in this process, using the facility or in the course of the provider's employment. For insurance purposes, death from self-administered medication will be considered death from this certified terminal illness. There are harsh criminal penalties for anyone who falsifies a request or coerces any individual to participate in this process. The bill specifically disallows lethal injection by anyone other than the patient. It disallows mercy killing or doctor-assisted euthanasia. And there is a reporting requirement that will allow the public to closely monitor the use of medical aid in dying. And not just the public, of course, us as well. That's it. That's the process. Let me end by circling back to the 71% of Marylanders who support this bill in the face of Dobbs and are asking us to provide this legislation to return dignity and bodily autonomy to the hands of our residents. You don't get to 71% because 71% of Marylanders want to take advantage of medical aid in dying. You only get to 71% because even those who would never take advantage of this legislation support the ability of others to do so. I am one of those people. So was the hero for whom this bill is named. And I'd like to conclude by reading a portion of a letter from the widow of Congressman Elijah Cummings, Ms. Maya Cummings. These are her words. One of the hardest things my late husband Elijah Cummings ever said to me was, "I'm ready to die." Suffering from medical complications related to kidney disease, cancer, and a heart valve transplant, Elijah and I had a number of extended hospital stays over the previous 2.5 years prior to his death. This time was different. After the doctor informed us that they had run out of treatment options for him, Elijah asked me to find a hospice where he could spend his last days on earth. A deeply religious man, the son of 2 preachers who practiced the Christian faith his entire life, Elijah took the path of accepting a natural end to his life, no matter how painful and dispiriting it was. But as a trained lawyer and a long-serving legislator, Elijah was nothing if not practical. He understood that the personal faith beliefs guiding his end-of-life choice may not be right for others who make different choices, perhaps because they follow other faith traditions or none at all. Elijah believed it was his duty to ensure that the law provided people of different backgrounds and beliefs with end-of-life options. Indeed, he felt the protection of the law was critical regarding this matter, given the complex and delicate nature of the factors shaping end-of-life decisions. For this reason, Elijah firmly supported the End-of-Life Options Act. I don't think there's a more powerful way to end. So with that, Mr. Chairman, I'll ask for a favorable report and turn it over to my panel for further testimony. Thank you.
Excellent. Thank you very much, Mr. Vice Chair, and whomever would like to come up first.
Hi, I'm Diane Kraus. I support medical aid in dying because I have seen how the end of life can be for both the patient and the families, even when they're on hospice and have medication. If you've ever sat with a dying person, and I mean sat with them for hours, then you know how difficult it can be for both the patient and the family. I come with a vast knowledge about the dying patient. I took end of day and night care of my mother, who also had metastatic breast cancer. I worked for 35 years as an occupational therapist, and for 23 of those years in home care and hospice. I have metastatic breast cancer, stage 4, and I am dying. Not today, not tomorrow, but that day is soon approaching. Tests showed innumerable tumors in my lungs and liver, all my lymph nodes, multiple bones, my skull, and my brain. I had to have whole brain radiation. Now on chemo number 3, I have a better potential for being alive in 6 months. I should be dead by now, but the new drug does give me hope that I'll be able to stay alive long enough to spend time with my son. My mother was mentally competent until the last 6 days of her life, when she slipped into a coma-like state from her cancer. Over the last 2 months, she would say she had no quality of life and a great deal of pain, and she was on hospice. The pain medicine was helping her, but even when upped or changed, did not cover the pain she had when we had to roll her side to side, move her any limb, and she would moan. I can still hear that moan today in my head. Even on hospice, she, like many of my patients, did not have a peaceful or gentle death. Please don't allow the minority to determine my bodily autonomy. The choice should be mine. Support this bill for people like me, families, and for the right of bodily autonomy. The time is now. Thank you.
Senators, thank you for letting me speak today. I am Reverend Alexa Fraser. I first spoke to you in 2015 to tell you about my father ending his life with a gun as he refused the pain, suffering, and loss of autonomy his advancing Parkinson's was causing. I would not have chosen this end for him, but he spoke through his actions. Then in 2016, I testified again because I had been diagnosed with cancer. I am delighted to say that my cancer is in remission, but I still support this option for those who want it. Most recently, I testified here in 2019 after I had become a Unitarian Universalist minister. I follow the dictates of my faith, which treasures bodily autonomy and personal agency. But some people don't want to let me or others speak for themselves. That's why I was shocked when I read in a Baltimore Sun article about a pro-life rally here in Annapolis 8 days ago. An anti-abortion speaker and podcaster, Gloria Purvis, was quoted as saying, in part, "We have to speak for those who cannot. That includes the person at the end of their life. We are their voices." No, Ms. Purvis, people at the end of their life are speaking for themselves, but you are choosing not to listen to them. In fact, and we've gone through this a little bit already, there have been a poll by Gonzalez Research and Media Service shows that 7 out of 10 Maryland voters age 60 and older support medical aid in dying, and more than 6 out of 10 of them personally want the option for themselves. Ms. Purvis, you don't even speak for the plurality of pro-life voters because, again, we've seen what this survey shows. I've worked with hospitals as a chaplain. I've been with people when they were at their deathbeds. All of them know how to speak for themselves and will be able to do so with passage of this bill.
I am Dr. Michael Strauss and support this bill. You already heard reasons why you should support the bill, but I want to caution you about unrealistic hypothetical issues that the opposition will raise. Aid in Dying now has 84 years of experience in 10 states plus the District of Columbia. And you need to understand what has not happened in those states. There have been no unused drugs being abused because patients only fill their prescriptions right before they need to take them, and because the drug powders are now mixed together and really cannot be abused. There are no documented cases of patients being coerced. There are no slippery slopes in which a state has amended its law to be like Canada or Europe with expanded indications. There are no problems of attending physicians evaluating capacity. You should know that University of California, San Francisco has always required all their patients to undergo a psychiatrist's exam. But I have a report now stating that now they're eliminating that policy because over 5 years, I've not found any cases in which a patient lacked capacity due to a psychiatric condition. There's been no failure of patients to notify family. 95% of patients notify their family, and all these patients have capacity, so they get to choose whom they notify. There's no problem of a failure to require end of life in a specific location. 95% of deaths are in the home, 5% in nursing homes. That's all reasonable. It's misleading to say that physicians don't support aid in dying. MedChi is neutral. 58% of its physicians support this. And a recent Maryland Psychiatric Society poll showed that 57% support this compared to 38% who oppose. There's been no increase in state suicide rates beyond increases across all states. And there's no credible cases of insurers denying coverage because the patient has access to aid in dying. So finally, please, later as you hear opposition, just ask, has this ever occurred in the 84 years of experience with aid in dying? Thank you.
Good evening, Vice Chair Walt Stryker and members of the committee. My name is Donna Smith, and I have led this effort to pass this End-of-Life Option Act for the last 8 years in Maryland. Senator Walt Stryker has already gone over the provisions of the will, so I will bypass all of that. What I'd like to tell you today is there are 10 other states in Washington, D.C. that have authorized this option. Each are required to do so yearly, except for Montana, which authorized medical aid in dying via a state Supreme Court ruling. Medical aid in dying is not suicide. It is similar to palliative sedation, which can result in death. Palliative sedation is a practice that most organizations support. Polls indicate a number of Marylanders across the political spectrum, regardless of race, party, religion, want this option. Even 49% of people who consider themselves pro-lifers support it. We have 24 years of data starting in Oregon, and we have an Oregon expert that can speak to that, that suggests these laws have not increased suicide, that there is no coercion, and the protections have worked. Maryland Governor Wes Moore has endorsed medical aid in dying. Maryland Attorney General Anthony Brown does not think this option conflicts with current law and supports this legislation. A society does not protect its people by limiting their healthcare options. Indeed, people are protected when they know their options and can make their own healthcare decisions regarding their own bodily autonomy. I'll be quick. Congressman Elijah Cummings said in his last letter to this body, as a just and compassionate society, we cannot value life in the abstract and deny to those who are about to die the self-determination that they deserve. For these reasons, I commend and support those who would enact this reform in our laws. Please pass this End-of-Life Option Act now. Thank you.
All right, thank you very much, Ms. Smith. Are questions from the committee for this panel? Senator West.
Thank you, Mr. Chair. Could I talk to the gentleman on the end over here? I'm sorry, I wasn't here when you were introduced. Could you take up to the no, up to the podium. I'm sorry, because you need to be on camera and you're not on camera if you're not at the podium. Okay.
Okay,
So,
Strauss. Michael
so
Strauss.
aid in dying was passed in Oregon in 1997.
Yes,
It's over 25 years ago. So you've talked about things that have not happened. Let me first ask you about suicide rate, because one of the arguments of the opponents is that this will make suicide more conventional, more palatable, and will lead to an increased suicide rate in society. Has that happened in Oregon over 25 years?
it has not. And the one study out in the literature which looked at it did not find statistically significant changes in the suicide rate across all the three states originally who had it. So the answer is no, it has not increased the suicide rate. You look at curves, and it's in my testimony, all the rates have gone up over about the past 10, 15 years, but they've pretty much gone up in parallel. So the answer is no.
Okay, the suicide rate in the states that have enacted aid in dying have not gone up any more rapidly or absolutely than the suicide rates in the states that have not enacted
Correct.
aid in dying. Okay. Secondly, one of the big arguments of the opponents has always been that people are going to be coerced into doing this. Family members will coerce them, other people will coerce them. Has there been a single case in Oregon in 25 years in which allegations of coercion have been made and sustained or found to be accurate in that state?
My understanding is no, and we have had in the past, I believe it may be available in some packets that have been distributed, a letter from Disability Rights Oregon, who wrote that they've never had a case. And can I just make one other comment? Because I look at the way things happen sometimes in medicine as patients are really near the end of death in states that don't have this law. Family members and physicians sometimes end up appropriately, moving things along in a sense that making the patient very comfortable. But to the extent that there could be coercion, I think this law is better than the existing case for those patients, because with this law, the physician and the patient have to go through so many hoops that it is a controlled process and it's safer actually. So,
okay, yet another argument made by the opponents is that vulnerable populations will be in effect frog walked to their early deaths because of this bill. Again, to your knowledge, in Oregon, has that occurred?
no, to my knowledge.
Okay. Thanks very much for your testimony.
All right, seeing no further questions from the committee, thank you all very much, and thank you for hanging in there with us tonight. Excellent. So, Mr. Vice Chair, I'm going to call up your second panel. Is Peg Sandine here? Sean Crowley, Martin Mitchell, Lynn Cave, and Dr. Elizabeth Morrison.
Chair Smith and committee members, my name is Dr. Peg Sandine, and I am pleased to be here today in support of SB 845. I am the CEO of Death with Dignity. I have a PhD in social work and social research, and for over 20 years, I have worked across the country and bedside with terminally ill patients who seek the option of a dignified and peaceful death when they are in the final stages of their disease. I am also a proud Oregonian. In Oregon and the 9 other jurisdictions where Death with Dignity is codified, the procedures we put in place have worked exactly as intended to give dying patients an option to end their suffering and maintain bodily autonomy. This legislation before you tonight establishes clear procedures to ensure patient control over end-of-life decisions and includes 4 key cornerstones of medical aid in dying. The patient is diagnosed by 2 physicians to be within 6 months of death, the same standard used for hospice care. And only patients with a terminal disease may qualify for the law. The patient must initiate the process with an oral request, followed by a written request and a waiting period, and may stop the process at any time. The patient must be deemed capable of making their own healthcare decisions, and the patient must self-administer the medication. No other person may do it for them. There are also a number of misuses specifically prohibited in the law. Coercion, fraud, euthanasia, lethal injection, and mercy killings are all specifically outlawed, as it is in every state where death with dignity is legal. Additionally, any healthcare professional or institution may choose not to participate. Opponents of this legislation allege a lot of things about the bill. And for nearly 3 decades, we have heard these same arguments. Statements that this law will target individuals who are poor or who are living with disabilities or over 65, and statements suggesting those without access to medical care will be forced to end their lives using medical aid in dying. And the data demonstrates that all of these arguments are entirely based on myths and falsehoods. I urge your support of SB 845 tonight. Thank you.
Good evening. I'm Lynn Cave. When I first heard of medical aid in dying as an option years ago when I was a young, healthy 20-something, I thought, hey, why should people who are facing imminent death have to suffer for any prolonged period of time? It made perfect sense to me. Now I'm a 60-something in poor health, and having the option of medical aid in dying could provide a pivotal role as I face my own death. Here's my story. I worked at the National Institutes of Health for 38 years, mainly in public affairs where I wrote press releases and pamphlets and ran public education campaigns. But I also spent a few years in the part of the National Cancer Institute that ran cancer clinical trials. Ironically, I'm now in a cancer clinical trial. It's to help stabilize my stage 4 eye cancer. My cancer has metastasized to my liver. It will never be cured, and I probably have less than 2 years to live. Once my cancer has destroyed my liver, most likely I will have about 2 weeks before my whole body shuts down, and I will pass away. Would you want to wait 2 weeks knowing you're just going to die? I don't want to perpetuate my own suffering for 2 long weeks, nor do I want my family to endure the agony caused by watching me die for a prolonged period of time. Believe me, I'm doing everything I can to live. I make the 2.25 trip to and from Philadelphia for my treatment because there is a world-renowned team who are trying to tame this cancer. And if this trial stops working, I know of at least 2 others I can try. But once I've been through everything my doctors know how to try, I don't want to extend my life if it gets to the point that I will suffer and die no matter what. So I plead with all of you to follow the will of the governor and the people of Maryland, 71% of whom support medical aid in dying. Please make this bill a reality for Marylanders now, so they, so you, so I don't have to suffer needlessly when a prolonged death is what we face. Thank you.
Good evening. I am Dr. Elizabeth Morrison, a psychiatrist, and I support this bill. I have 3 points to make. From a psychiatric perspective, aid in dying and suicidal patients are fundamentally different. Suicide in the context of mental illness occurs because of intolerable suffering, distorted, irrational thinking, and impaired judgment. In contrast, Individuals eligible for aid in dying have terminal treatment refractive illnesses. These are people who you've just heard who, if not for their illnesses, want to live. Second, most patients with psychiatric conditions do maintain capacity and can continue to make medical and other end-of-life decisions. Patients nearing death may be sad and grieving, but still have capacity. They should be allowed to participate in medical aid in dying. Supporting this position is a recent report I have from UC San Francisco, which Dr. Michael Strauss referred to, which has required all patients requesting aid in dying to undergo a psychiatric evaluation. A study of 100 randomly selected patients found none who lacked capacity due to a psychiatric condition. So I believe only patients with significant depressive or other concerning symptoms should be referred for a mental health evaluation. Last, the positions of national medical organizations do accommodate aid in dying. The AMA modified its position in 2019. It remains opposed, but simultaneously concluded that physicians who participate in aid in dying are not violating their code of medical ethics, and that morally admirable physicians can hold divergent views. Thus, any attempt to say that the AMA opposes physician-assisted suicide is telling only half the story. The American Psychiatric Association has no position. Nevertheless, it has developed a comprehensive resource document to assist psychiatrists in states where it is legal. I urge you to support SB 845. Thank you.
Chairman Smith, Vice Chairman Waldstreicher, and other committee members, thank you for allowing me to testify today. My name is Sean Crowley. I've been the Media Relations Director for Compassion, Choice, and Action Network's campaign to pass the Maryland End-of-Life Option Act since the bill's original introduction 8 years ago in 2015. But today I want to describe the recent agonizing death of my 92-year-old mother, Carol Crowley. She lived in Connecticut, another state without a medical aid in dying law. Last Christmas, she got the flu. Feeling increasingly weak 3 days later, she fell down trying to walk. She was hospitalized for 12 days, during which she developed AFib and internal bleeding. Then she spent 5 days in home hospice care, 24/7, until she died with needless suffering. After her first night in home hospice care, she begged me, "Sean, please help me die." Tearfully, I told her, "Mom, I'm sorry, but I can't help you die because it's illegal." In the end, she could not drink, eat, swallow medication, or speak. I don't want anyone's loved one to die with needless suffering. As a former legislative press secretary, I understand why lawmakers worry about inflaming voters if they make a politically risky vote. But this issue is not politically risky. You've already heard about the Gonzalez poll. Now, while that poll didn't measure support among voters with disabilities, a new national poll released today shows 4 out of 5 voters with disabilities, 79%, support medical aid in dying. Finally, a 2021 poll shows Maryland and other Northeastern state voters are 5 times more likely than less likely to support a legislative candidate who supports medical aid in dying legislation. Clearly, the time is now to pass this long overdue law in Maryland. Thank you.
Greetings, Chairman and distinguished members of this committee. My name is Councilmember Martin Mitchell. I'm the at-large councilman for the city of Laurel, Maryland. I'm also the political action chair for the NAACP Maryland State Conference. And also, I'm the former president of the Prince George's County Young Democrats. I'm proud to say that I'm still supporting this issue and was supporting this issue along with my young Democrats. I'm sure every member has been briefed about the new poll conducted by Gonzalez Incorporated. That poll shows overwhelming support for medical aid in dying in this great state of Maryland. over 2/3 of Maryland residents support the End of Life Options Act. I had a long conversation with my 80-year-old grandma, and after understanding all of the inherent protections in this bill, she then also agreed that she might never utilize this, but she would like to have this option because she believes in her free will and her bodily autonomy over everything. And, you know, I just wanted to share a quote from an article today in the Washington Post. I think it is something that we as a society, we as a state, have to make sure that we are protecting the ability for people to make those clear mind, clear heart, and independent decisions about suffering that they are enduring and the suffering that their family members are watching them go through. And that was said by, you know, our great Governor Wes Moore. And so I wanted to echo the sentiments and say that, you know, the time is now for this compassionate piece of legislation. And thank you for your time.
All right, thank you very much. Questions from the committee? We have Senator West has a question.
Yes, for Dr. Morrison, if you would, could you go back up to the podium? So just as before, I'm interested in discussing the nature of the opposition. The opposition is, I've sat through this bill. This is my fourth time.
Okay.
Starting back in 2015. So I've heard all the arguments on both sides. So when we first started to hear these bills back in 2015, the argument was that for a doctor to assist in aid in dying would violate the Hippocratic Oath. And back in that era, the position of the American Medical Association was opposed. They've changed their minds since then, correct?
Yes, correct.
So what is the position of the American Medical Association today?
So the AMA continues to oppose aid in dying, but simultaneously, they conclude that ethically admirable physicians can come to divergent views, and that physicians who participate in aid in dying are not violating the medical code of ethics of the AMA.
Thank you very much.
Thank you, Senator. All right, seeing no further questions from the committee, thank you all very much for being here tonight. All right, we'll now move on to the next panel. We'll hear from David Marker, Linda Lemkin, Reverend Ken Phelps, Robert Brookland, and Victor Thorioni. Victor, good to see you. How you been?
Okay, I won't be shy. My name is Victor Thorioni. I have an incurable and fatal blood cancer, myeloma. I strongly support passage of the End of Life Option Act. In the not too distant future, my treatment options will likely run out. At a point when I just might have a few days to live, I would like to have as many options as possible. Myeloma used to have a life expectancy of 3 years. I've now lived over 10, and I hope to continue living as long as possible. I'm not atypical for cancer patients. Most want to live longer, not die. While I would likely ask for aid in dying once I qualify, I would want to decide whether to use the prescription. I would wait to use the prescription until my doctor advises me first, further therapy is futile, and 2, I am likely to die soon. Who knows whether I will get there? Many myeloma patients die of an infection like pneumonia or from another side effect of therapy. The debate about this bill often involves the motivation of patients. Is it to avoid pain, to achieve control of the manner of death, or what? Relatedly, some ask why patients need this if pain relief can be obtained through hospice care. These questions seem to me to be misguided. Medical care often does not go as planned. My motivation for wanting the end of life option is simple. If things don't go with plan A, I want a plan B. it may be an issue of pain. I experienced level 9 pain just below what causes you to black out when first diagnosed, as well as during bone marrow biopsies. I'd want to avoid that. Specifically, why I might want to end my life using this legislation is something I can't predict at the moment and might not know until shortly before. I do know that I do not wish to die while comatose or drugged. I just want an option. Thank you.
Good evening. My name is Linda Lampkin. My late husband, Ron Dickey, would have liked to have been here tonight to support this position, to support his position on this bill. Luckily, he left behind an op-ed in the Baltimore Sun in October of this year. And he said, as someone who is already dying, I want to say when I'm ready to go, not when the cancer is ready to take me. Unfortunately, he passed away on November 7th. Ron didn't have a choice to avoid more suffering when he was out of options, a choice that he would have had if we'd lived in one of the 10 states plus DC that allow an end-of-life option. 1 in 5 Americans lives in a jurisdiction where there is a choice. Maryland is not one of them. And again, remember, this is a choice. You've heard about the safeguards built in, and there's a long history, a very long history of no problems with implementation. If you personally don't think this choice is for you, don't use it. However, do think of others who want to end their suffering and pain. And that is clearly what my husband wanted. Ron was diagnosed with prostate cancer 4 years ago. And when there was only palliative care left, he said, I urge Maryland lawmakers to pass this bill, whether or not I'm still around. There is someone right behind me that can still benefit. I want lawmakers to enact this for those that follow. So please do that.
Chairman Smith and committee members, good evening. I'm Dr. Robert Brookland, and I chair the Department of Radiation Oncology at Greater Baltimore Medical Center. I'd like to make 2 comments in support of this bill. The first is that you should pass this bill for the minority of patients whose pain and suffering cannot adequately be addressed. Now, I've cared for tens of thousands of cancer patients in my career. In most of those situations, my colleagues and I have been successful in either achieving cure or at least relief of symptoms, but there is a small proportion of patients for whom our actions have been inadequate, and the patients have experienced profoundly debilitating pain, suffering, and are begging for a peaceful end. I could provide specifics of countless individuals, but we don't have the time. So I'll simply say that I believe it's patronizing and wrong for opponents of this bill to believe that they're justified in stopping this small minority of patients from ending their lives with peace and dignity. They need and deserve this law. The second comment that I'd like to make is that I believe it's reasonable and ethical for physicians to participate in such programs, and their participation does not violate the Hippocratic or other oaths that we take. I cringe when opponents state that the process of dignified death violates the Hippocratic oath, and I believe that there's a misunderstanding about that oath. There's actually two Hippocratic oaths. There's the one that was written 2,400 years ago and the one that most of us take today. And there are parts of the original oath which are relevant to today's practice of medicine that focus on not harming patients and following ethical moral principles and protecting confidentiality. But opposing witnesses tend to cherry pick some small portions of the ancient oath which reference the swearing to the god Apollo, acknowledge only male physicians, and others just cherry picking this oath. The fact is 116 out of 122 medical schools now administer oaths that accommodate death and dying. So I ask for your support for this bill. Thank you.
Thank you all very much. I remember, well, Victor, I remember in 2014, I climbed up Chestnut, took a right, and I ended up on your front door. You still have that screened-in porch? Yeah, I hung out in the screened-in porch, and this is the first thing you talked to me about. So I remember that. And then some years later, I guess, was it your couch or someone else's couch? We had a little meeting about this, but thank you for your tenacity and for being here tonight. Thank you all for hanging in there till 8:30 essentially to just to speak. So thank you all very much. Questions from the committee? All right, seeing none. Thank you. Victor, good to see you. All right, we'll now move on to the next panel. This one here. Okay. Let's go through here. Is Julie Riley? Donna Smith already spoke. Ken Phelps still here? Susan Lyon? And Dave Marker? Not here. Oh, that's all right. It's down. All right. Whomever would like to go first.
My name is Susan Lyon. I was raised in a staunchly Catholic family. I'm here because I witnessed firsthand what's possible for us in Maryland once we pass the End of Options Act. I was with my friend Leah Ray in Washington, D.C. when she raised her hand and sipped the legal medicine that ended her suffering. Leah was brilliant and kind. She embraced all of life. She was joyously married to her husband, Daniel. She'd been a reporter in Japan. She created art, tutored Latin, rode horses, loved silent movies, and binge-watched TV Westerns. Then, for 6 years, cancer ravaged Leah's body. She participated both in traditional and experimental protocols, but each eventually failed. In her last 3 months, her body sat in a chair from which she couldn't move, and for the last 3 weeks, she couldn't eat. But on November 15, 2019, Leah had a say. She wrested power away from the cancer that had ruled her life. That day, she determined the where and the when, not the cancer, not anyone else. Leah died quickly and peacefully, not among machines or lost in the din of a sterile hospital, but at home with those she treasured and who cherished her. She lived how she lived, with agency, dignity, and resolve. No one is forced to avail themselves of medical aid in dying, but for those who need it and for those who love them, it is a godsend. Please pass this bill and pass it now. Thank you.
Good evening. My name is Julie Riley, and I'm testifying today in support of the End of Option Act for 2 reasons, because I believe in it and because I may need it. In 2021, I was diagnosed with cancer. Treatment was hard. First, over several months, I was infused with 3 different chemo drugs. One I tolerated well enough, for chemo. The other 2 were hard. Worse pain, a heart problem, exhaustion, hair loss, and much more. I'll spare more details. However, one infusion was absolutely unbearable. I was sent to the ER, hospitalized with an infection, an extremely compromised immune system, and horrible pain. Because of this, my oncologist had to cut down on my chemo to lessen a very risky side effect. After chemo, I had surgery in 2 sites and then 20 rounds of radiation. Finally, I made 2 tries at post-treatment meds to prevent my cancer from coming back, attempts that failed due to intolerable side effects. My overall prognosis is good, but it's not great. There's a 1 out of 5 chance my cancer will return, and if it does, I anticipate a terminal situation. In that case, I'm entitled as an independent adult to end my own life and my needless suffering. Perhaps just as important as ending my needless suffering, the bill protects my family from legal liability, such as assisted suicide. That's extremely important to me. If my cancer returns, I want to die with my husband holding my hand. He's right back there with me, as he's been this entire time, and not be terrified that he's going to be punished for it. If my cancer returns and I'm 6 months from death, I and my family will have suffered enough. Thus, I respectfully request a favorable report for this bill. Thank you.
Thank you very much for staying to testify. Thank you. Seeing no questions on the committee. Have a good night. Thank you. All right. We do have one more in person. Is Dr. Seth Morgan here? Okay. Who's in the Zoom room?
Excuse me.
Doctor, if you could hold up for 1 second, just to make sure. If you're in the Zoom, okay, there you go. She's been muted. All right. Doctor, you're up.
Thank you very much. My name is Seth Morgan. I'm a physician, a person with disabilities because of cancer and multiple sclerosis, and an advocate for people with disabilities. I strongly support this legislation. Like most Americans with or without disabilities, I value my right to make independent choices. It is condescending and offensive when organizations attempt to speak on behalf of all of us with disabilities. Some individuals with disabilities might consider aid in dying as an option if the situation arose. Others might not. The data indicates that the large majority of all Americans with disabilities capable of independent decision-making support aid in dying, with individuals with self-identified disabilities support end of dying at a rate of 62 to 75%. Regardless, each of us should have the permission and the allowance to make our own choices. In more than 80 years of combined experience in states authorizing medical aid in dying, there's been no evidence of abuse, coercion of individuals to use medical aid in dying, and no expansion of the medical conditions for which it is allowed. Experience has proven that there simply is no slippery slope caused by this law. Also, patients who have access to life-ending medication do not always use it and often will continue to fight on, knowing that they have the ability to use the medication should their suffering become intolerable. Lastly, 2 current Maryland laws permitting actions which hasten death through either palliative sedation or voluntary stopping of eating and drinking provide none of the protections built into this act. In fact, use of palliative sedation is usually initiated without the permission of the affected individual. Requirements of the proposed legislation include evaluation by a second physician, a 15-day cooling off period, and are unique to this legislation. The act provides more protection and a better process in which an individual can comfortably die at home. Please support this bill. Thank you.
Excellent. Thank you very much. All right. So have I missed anyone that would like to testify in favor of this bill who is in person? I think I've called everyone. All right. So that'll conclude the testimony for the proponents of the bill in person. And we'll switch over to the virtual panel for the proponents. And we'll hear from Erica McDonald, Dan Diaz. All right, so Erica, you're up. Go ahead.
Okay,
welcome.
Thank you. Good evening, Chair Smith and Judicial Proceedings Committee members. My name is Erica McDonald, and I'm testifying in support of the End of Life Option Act on behalf of the League of Women Voters of Maryland. The League believes state laws should grant the option for a terminally ill person to request medical assistance from a relevant licensed physician to end one's life. It also believes that such legislation should include safeguards against abuse and for the dying and for the medical personnel, as we've heard. In patient-centered care, an individual's specific health needs and desired health outcomes are the driving force behind all healthcare decisions. It's a true collaboration between patient and medical provider. When seen through a patient-centered lens, relief of suffering, whether physical, mental, or emotional, can be seen as a crucial treatment goal. When death is inevitable, some patients view the loss of autonomy and the ability to decide how to spend their final days as more frightening than the prospect of worsening physical pain. Compassionate care designed to meet their needs can seem out of reach. This legislation is designed to enable patients and providers, if they choose, to help extend compassionate care to the patient's final days. The option of maintaining some self-determination and control at the end of one's life is a great comfort, even if the patient winds up not taking the medication. At present, 10 states have passed legislation legalizing medical aid in dying, and Maryland has a long history of considering but not passing death with dignity legislation. After multiple attempts over 28 years and with broad popular support, it is time now to pass this important bill. The League of Women Voters of Maryland and its members throughout the state urge the committee to give a favorable report to Senate Bill 845. Thank you for your time.
Thank you, Ms. McDonald. All right, we'll now hear from Diana Bernard.
Hello. My name is Dr. Diana Barnard. Thank you for the opportunity to share my thoughts regarding this bill and why I strongly urge you to support SB 845. I'm board certified in both family medicine as well as hospice and palliative medicine. I've been a practicing physician for 28 years, and the last 14 of those years have been spent exclusively caring for people who live with serious illness. I work in Vermont, where medical aid in dying has been legal for nearly 10 years, and I'm here to share my experience. I regularly prescribe under the law, and I also educate and support other physicians who do this work. The most recent legislative support in our state, which came out in January of 2022, shows that our law is working exactly as intended. It's working well. There's no abuse. 116 Vermonters have qualified for the law, and every Vermonter has benefited by knowing it's there if they need it. Our growing experience in Vermont closely mirrors that of the 9 other states and the District of Columbia, where medical aid in dying is legal. Medical aid in dying offers vital comfort and a measure of control for patients who are desperate to live, but must accept that they are dying. Very importantly, the laws also protect the rights of patients and physicians who do not believe in its concepts or don't want to participate. I think it's so important for the committee to understand the deeply personal nature of suffering and the challenges that people living with terminal illness face. Everybody is unique. The people that I care for are desperate to live, and yet when they're dying, they also want to say in how they die. It feels like a simple request. Suffering is deeply individual, and we need many tools in our toolbox to address the different kinds of suffering. I'm aware that the polls in Maryland show broad and strong support amongst your population, and I urge you to support this bill, and thank you so much for listening.
Hey, thank you very much. Thanks for being here with us tonight. Is Dr. Jeffrey Gardier here?
Yes, I am.
Hey, welcome.
Thank you so very much. All right, thank you for having me. I am in support of SB 0845. I'm a board certified clinical psychologist and ordained minister, professor at a New York medical school where I teach students about the sanctity and quality of patients' lives and mental health. Though I understand the concerns of the opposition, scientifically and factually, it is incorrect to equate terminally ill adults who want the end-of-life care option of medical aid in dying with people who unfortunately take their life prematurely. And according to the American Psychological Association, they are fundamentally different. As well, the American Association of Suicidology also argues medically and legally, medical aid in dying and suicide are conceptually different phenomena. In suicide, a life that could have continued indefinitely is cut short. In medical aid in dying, death is foreseeable and in some cases imminent. Most people who take their life prematurely have the choice to live, but under the influence of psychological illness choose not to. Terminal patients who may use medical aid in dying do not have the option to live. The illness has taken that decision away from them. The question then becomes how they die, not if they will die. I have talked to and counseled countless people who do not want to die, and they know, though, that this will be their fate, and for the terminally ill, it will come sooner rather than later. Medical aid in dying provides that courage and spirit, and therefore they are less afraid of having to end their lives and what that will look like. They seek a respectable quality of life, peace, comfort, and most importantly, dignity. I have my faith, beliefs, and integrity that are firmly aligned with medical aid in dying. There are too many terminally ill dying Marylanders who are necessarily suffering the end of life. The time to pass this bill is now. Thank you.
Excellent. Thank you very much, Doctor. Thank you for being here with us. And I'll say you win the room raider competition for the evening. You've got a great, I like the picture, the paintings on the back wall. I've got it. Got a 4.5-year-old, so I have much appreciation for the artwork.
Same here. Thank you.
I was hoping it wasn't yours. So as soon as the words crossed my lips, I was like, oh, whoops. All right. It was good to see you. Thank you for being here.
Thank you.
Thank you for your testimony. Questions from the committee? Okay, seeing none. Thank you very much. Have a good night.
Thank you.
All right. Does anyone else? Okay, so that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. And we'll start off with Dr. Joe Marine, Dr. Mary Alberte, Dr. Holly Dahlman, and Shirley Rodich.
Good evening. My name is Joseph Marine, speaking in opposition. I'm a cardiologist practicing with Johns Hopkins Medicine in Baltimore with over 20 years of experience caring for thousands of patients. I'm also a member of the American Medical Association, the American College of Physicians, and the Baltimore City Medical Society, all of which oppose the legalization of assisted suicide. The End-of-Life Option Act represents dangerous and misguided public policy, which violates basic principles of patient safety and which has nothing to address the real needs of Maryland patients with advanced illnesses and disabilities. Assisted suicide is not medical care. It has no basis in medical science, practice, or tradition. In states that have passed assisted suicide laws, few physicians are willing to participate. The lethal drug combinations used in assisted suicide have never been scientifically tested, and the FDA has never approved any drugs for this purpose. The drug recipes used have been invented by the euthanasia movement, not the health professions. Furthermore, we know that doctors practicing assisted suicide in other states have been performing unregulated and unethical experiments on human beings using combinations of cheaper drugs. This is because almost any drug given in a high enough dose can serve as a poison. Tragically, these experiments have caused some patients to scream in pain and to take over 2 days to die. Experimentation such as this violates basic principles of medical ethics, including the Declaration of Helsinki. The End-of-Life Option Act would provide a new license for doctors to violate basic principles of medical ethics and kill vulnerable patients with broad legal immunity and no real oversight or accountability. It does not give patients any new rights, and it takes away many basic legal protections. This committee heard today about the terrible explosion of poisoning deaths from fentanyl, a controlled sedative drug. Why would we want to legalize and normalize this form of poisoning with other controlled prescription drugs? What Maryland patients with advanced illnesses need is more support and greater access to excellent palliative and hospice care programs. We have some of the best healthcare in the world right here in Maryland. We should use it and not undermine our healthcare system with assisted suicide. I ask for an unfavorable report. Thank you.
Good evening, dear honored Senate committee members. My name is Marie Albert Borsico. I am a board certified internist and have been licensed to practice medicine in the state of Maryland for over 25 years. In that time, I have managed thousands of adult patients. Today, I wish to express my personal opposition to the End-of-Life Option Act. Medicine is a noble profession. Physicians are trained to be healers and not the agent of harm to patients. Suicide is not medical care. It is a public health crisis. It's the 10th leading cause of death in this country, and its rates are rising. In a civilized society, suicide should not be promoted. There are a number of flaws in this bill which time does not allow me to address tonight. Under this bill, a suffering patient essentially asks a physician to assist them in committing suicide. The physician writes a prescription for a cocktail of drugs with the intention that the patient commits suicide by self-administering or ingestion of the cocktail. Drugs are developed for their therapeutic value, not to be misused or abused to harm patients. In the event that the patient succeeds in committing suicide, the physician is then selectively protected by law to falsify the death certificate by listing an underlying medical condition as the cause of death instead of the true cause, physician-assisted suicide. This is absolutely appalling in a day and age when transparency is expected of anyone in a position of authority. This act is a corruption of the integrity of the medical profession and of the privilege of being licensed to practice medicine. There are already end-of-life options available to suffering patients. Palliative care, which is life-affirming. It properly regards dying as a normal and natural process. We can already manage depression and anxiety. And even when all modalities of management have been exhausted, hospice care is available. So in closing, I just wish to quote as is so eloquently expressed in the American Medical Association Code of Ethics, physician-assisted suicide is fundamentally incompatible with a physician's role as healer. Thank you.
Good evening, and thank you, Senators. I appreciate the endurance of all of you. This is a very long day for all of us, and you guys do this every day, so thank you. My name is Dr. Holly Dahlman, and I'm an internal medicine doctor. I'm owner and CEO and lead physician at Green Spring Internal Medicine in Lutherville, Maryland. I oppose Senate Bill 845, and I just want to say that in history, the majority is not always right. Health insurance companies have profited handsomely by not spending money on healthcare. Significant obstacles to patient care already exist in the form of prior authorizations and denials. And here in Maryland, since 2019, we've had the total cost of care model, which incentivizes hospitals to not spend money to lower the cost of healthcare. Accountable care organizations also incentivize practices like mine to achieve shared savings, which comes in the form of a bonus in the years that practices are able to reduce the cost of healthcare. Life-saving care can be expensive, but this is no time for low-cost death option. To permit medically prescribed death would be to open the way to an entirely unmanageable set of financial conflicts of interests for insurance companies, hospitals, and medical practices. So what will be the priority in Maryland healthcare? Profitability or people? Personal autonomy is a privileged argument, and this should not come at the expense of another person or a group of people. And the following individuals would be at the greatest risk of harm if physician-assisted suicide were to be legalized in Maryland. People unable to afford healthcare or medication, elders believing that they are a burden to their families, those wanting to avoid health costs in order to leave an inheritance, the lonely, chronically ill, patients with weary caregivers, and people living with disability. Because of the financial conflicts of interest in healthcare, we must not allow the low-cost death option to be legalized in the state of Maryland.
I am Shirley Reddick, Columbia, Maryland, and like other members of this panel, I am also a physician. I'm a clinician, educator affiliated with Johns Hopkins, and a pediatrician and pediatric hematologist oncologist of some 40 years. This bill is antithetical to the mission of medicine and works against the health and safety promoting efforts of the Maryland Assembly members, including some of you. What does this bill look like in practice? Consider a young couple, 24 years of age, celebrating their marriage. The young man is a survivor of childhood leukemia. They have fulfilling jobs and the young woman is pregnant. One day he notes a lump near his neck. He has a different cancer, a lymphoma. Prognosis is good with treatment, but he feels he can't go through it again, nor have his young pregnant wife bear the burden of his illness. He pursues end-of-life option without involving any of his family. He knows his spouse will also get life insurance death benefits. Flip the script. The young pregnant woman of this couple has recurrent cancer. She makes the same decision. Consider this young man or woman is your son or daughter, brother or sister, best friend. Consider your adolescent daughter has a psychiatric eating disorder you likely know as anorexia nervosa that's stabilized on treatment. She's 18 now and enters college close to home. Academically, she is doing well, but struggles more with body image and regresses. She fears the future and doesn't want to continue burdening her family. She also pursues end-of-life option without involving her family. By the way, she has read that others with anorexia nervosa have been approved for MAID in another state. The consulting physician was also available via telehealth from yet another state, Colorado. Consider your 15-year-old, a standout athlete who set their sights on a professional sports career, has just been in a car accident. Paraplegic and with chronic lung issues, they are deeply depressed. They have no siblings and a fading peer social network. They have already lost a classmate to suicide. They ask why they can't just get the medication to end their life like their grandfather did. I'm a spouse, a mother, a grandmother, and a veteran. I've been with friends and relatives, most recently my mother, on their end-of-life journeys and know that accompaniment has the power to allay existential suffering and that good hospice and palliative care can address physical suffering. I know the extended effects of suicide. I lost a brother to suicide no one saw coming. We kid ourselves if we don't see that the end-of-life option is state-sanctioned, socially sanitized, and normalized suicide. Thank you.
Thank you, Dr. Reddick. Questions for this panel? Seeing no questions, we'll move on to the second panel. Christine Seibert, Nancy Weissman, Dr. James Kelly, Vicki Hoffman.
I'm sorry. There should be bullets. I'm Christine.
Did they not last? I'm Dr. James Kelly. Yes, sir.
Sorry.
Right, sir. Good evening. I'm Dr. James Kelly. I'm a physician and a psychiatrist, over 35 years experience. I'm here to speak for the Association of the American Physicians and Surgeons. We actively oppose this bill. Clearly, this is against the Hippocratic Oath, and clearly this will change the doctor-patient relationship because this will institutionalize and approve killing. There's an axiom in medicine that says, first, do no harm. I cannot imagine anything more harmful than aiding someone in death or causing the death of someone else. Every day, for decades, I see patients who are suicidal. Every day, my staff and I help people no longer want to be suicidal. People with terminal illnesses generally want to live. It's not until they reach the point of despair and depression or feel like they are a burden to others that they give up hope, and then they want to die. We should be helping people. We have many treatments that are very effective. We should not be killing people. This bill technically will be licensing people to kill.
or to help others kill themselves. This sets up an entire new industry in Maryland based on death, not based on helping people. This is absolutely the wrong direction. And like so many of these situations where there may be good intentions, the most vulnerable are the ones that are going to be targeted. Minorities, those marginalized, and those that have the least resources will be targeted. And this often will lead to other serious unintended or at least unstated consequences, like the slippery slope to euthanasia. Once a society says that suicide is helpful, in those words, it legitimizes it, and it does increase rates of suicide. Once a family suffers suicide, the rates do increase. I've heard different stories of different statistics. One study says this, another study says that, much like polls. So I urge you to vote against this. Killing for any reason, killing by any other name kills the same. Please do not vote for a law that justifies killing others. Thank you very much.
Thank you very much, Doctor. Thank you.
Good evening. I'm Christine Seibert. I'm a pharmacist and a resident of Maryland. While the goal to reduce human suffering is a noble one, assisted suicide is not the option Marylanders need. There are many flaws in this bill that the public is not asked about in polls. And I outline these in my written testimony, but here are 4 key points. Number 1, there are no clear conscience protections for pharmacists. Number 2, drug diversion can occur on multiple levels. The common drug regimens used are DDMA, DDMA-PH. Now those come in a powder combination, but they're the equivalent of 500 tablets of morphine, 100 tablets of diazepam, 80 tablets of amitriptyline, 400 tablets of digoxin, and when used, 50 tablets of phenobarbital. 38% of the scripts are not used in Oregon, and there's no tracking mechanism for preventing diversion. So what happens with the unclaimed script? No ID is required to pick up the lethal concoction from the pharmacy either. Number 3, illegal human experiments. I coordinate drug studies at my hospital, and I sit on the review board for these 4 studies, which is a group that assures that all experimental treatments, including new combinations of drugs for new indications of which these cocktails would apply, are carried out, and we make sure they follow FDA's good clinical practices. If we tried to treat patients this way with ever-changing drug regimens and so little informed consent or follow-up after prescribing, the FDA would shut us down. Finally, autonomy is misleading. Proponents say they have a right to die, and that's true, and that exists now. No one needs to accept medical care that they do not want, but they want to control the day and time that they die, and without the stigma of suicide. So falsify the death certificate, change the definition of suicide, and that makes it okay? No. Government sanctions plus doctor and pharmacist participation don't change the truth. This option rates some lives as less valuable than others and therefore devalues the life of every single one of us here. It's offensive to all humanity, and preventing that universal offense supersedes an individual's autonomy. Please reject this Pandora's box masquerading as compassionate medicine and vote unfavorable. Thank you.
Thank you, Mr. Chairman. This question is for you, Ms. Seibert, please. You said you're a pharmacist?
I am.
Okay. So do you have any concerns with any of the increasing in drug-related overdose deaths if this law is passed?
Yes, I do. While the drugs don't come in the tablets, obviously, they're usually from a compounding pharmacy. So patients are getting a powder, but these high doses are all mixed together. And if you look at the information that about these concoctions, you have to protect yourself. You have to throw everything out that you mix these things with. So they're dangerous. They say, please don't spill it. If a cat licks it up, the cat's going to be dead before you are. So it's like, this is big stuff, right? This is big time stuff. So what happens if you have a family member who has access to this? They know grandma has a script sitting at the pharmacy waiting to be picked up. They don't have to show an ID. They could be picking it up for grandma, but they take it themselves because they have terminal anorexia, or they have some other thing that they feel like they've diagnosed themselves, and they say, well, it's okay for grandma to do this. Why can't I? I'll just take a little bit of it. You know, it opens a door that I know proponents say will never happen. But the problem is there's no evidence of coercion because the patient's already dead. And who's following up? We don't have follow-up on this. This is not a clinical trial where there's anyone following up. The script is written. In fact, in some locations, a prescribing doctor never has to see the patient. They can do telemedicine. And that same state wants to open it up for tourism assisted suicide. So anyway, sorry.
One more, thank you. So in states where they have this, is there any data that shows that opioids are more commonly prescribed? Like, is there an increase in those in these other states that you know of?
I am not aware of that. I know that across the country, opioid related deaths are rising, and even not counting street opiates that people get off the street, but prescription opiates, along with benzodiazepines and tricyclic antidepressants, which that's part of this. The amitriptyline is part of it. Those are on the rise. So again, these are dangerous drugs, and there's nothing built in to track it. And again, proponents say, well, we've never had evidence of it, but no one's looking. The script is written and poof, off you go.
Okay. Thank you. I think it's interesting being a pharmacist perspective. Thank you.
Thank you, Senator McKay. Are additional questions from the committee? Seeing none, thank you both very much. Thank you. All right, we'll now move on to the next panel, and that we'll hear from Dr. Annette Hansen, Dr. Russell Margolis, Dr. Angela Garda, and Sandy Natina. Whomever would like to go first.
Hello, Chairman Smith, Vice Chairman Waldstreicher, members of the committee. Thank you for letting us testify today. My name is Dr. Annette Hansen. I'm the chair of the Legislative Committee for the Maryland Psychiatric Society. I'm here speaking on behalf of both the Maryland and the Washington Psychiatric Societies in opposition to this bill. And I want to start first with a disclaimer that this is obviously a controversial issue. There are members of both organizations who both favor and oppose this legislation. We had a vigorous debate over this. And I want to emphasize that our position in opposition is based on how the bill is currently drafted, not based on any particular ethical or ideologic position. I'm going to hit 2 points. You've got our written testimony. I want to highlight 3 particular aspects. Our concern is that as this bill is presently drafted, it could seriously complicate the practice of psychiatry within the state. I'm going to start with the most serious issue first, which is that this would have to be applied to patients in our state institutions, both our psychiatric hospital system and in our prison system. I'm personally aware of 3 cases where patients in our psychiatric hospital have requested this. One of those patients has since been transferred to the Division of Correction, where they also have a palliative care unit. If you grant this as a legitimate medical intervention under US v. Gamble, it has to be provided. You can't deny it to someone just because they're institutionalized. Conversely, the Civil Rights of Institutionalized Persons Act creates an affirmative obligation to prevent suicide. So your state employed physicians are going to literally be caught between a rock and a hard place, whether they provide it, whether they don't provide it. So it's good to be first in some areas. You don't want to be the first state to litigate this conflict between state and federal law. That's something you got to leave to the other states to figure out. Could also seriously complicate our involuntary treatment laws by creating an equal protection issue. If you say that someone has this medicine legally, does this mean they're categorically exempt from involuntary treatment? That would make them different from other people with mental illnesses. And because my time is limited, I will stop now and be available for questions.
Good evening. My name is Angela Guarda. I'm a professor of psychiatry at Johns Hopkins and the director of their eating disorders program, and I oppose this bill. Although we can't predict who will recover and who will die of anorexia, Nearly every case improves with expert care. This is a treatable, not a terminal illness. Most doctors, psychiatrists included, can diagnose anorexia but have no training to treat it. Faced with a patient weighing 50 pounds in organ failure who refuses treatment, they may well judge the patient terminal because they don't know how to get her the treatment she needs. Anorexia is challenging to treat because ambivalence towards treatment is a symptom of the disorder. Choice is impaired. Patients with anorexia nervosa may appear rational, yet often lack capacity to accept the care that they need, food. How then can they have capacity to consent to a lethal medicine? Yet in Colorado, despite safeguards against misuse, physician-assisted suicide for anorexia is taking place under ill-defined proposed criteria for, quote, terminal anorexia. The physician involved in these cases retains an active license in Colorado and is also licensed in Maryland, where she can practice by telemedicine. Her charge for a consultant to join her practice, $7,000. An ex-patient of this doctor's contacted me. She too was prescribed assisted suicide medication while in hospice. She's since in recovery working and said, quote, it didn't feel like my choice. I felt coerced. Treatment for anorexia is expensive and recovery can take years. The starved patient could easily be influenced to view, quote, aid in dying as the best way out of an intolerable situation, or believe their family would be better off without them emotionally and financially. Fostering hope is crucial to my job as a doctor. How do I hold this view while considering assisted dieting as an option when I don't know which, if any, of my patients is incurable? This bill appears reasonable in principle, but there's too much room for error, and it risks endangering the most vulnerable, the 1 in 5 and the 1 in 5 Americans with a treatable mental illness. Thank you.
Good evening, chairs and members of the committee. My name is Dr. Russell Margolis, professor of psychiatry and neurology at Johns Hopkins. I'm here in strong opposition to Senate Bill 845. I will highlight 3 reasons why this bill should be rejected, with details in my written testimony. The views expressed are my own and do not necessarily reflect those of Johns Hopkins. First, many terminally ill individuals have treatable but unrecognized psychiatric conditions causing the distress that leads them to seek assisted suicide. Based on the experience of other jurisdictions, the provision in the Act for optional mental health evaluations is insufficient to mitigate this risk. Testimony to the contrary is incorrect and naive. Second, the fears leading the terminally ill to seek assisted suicide are largely based on societal misperception and misinformation. These fears can be alleviated by high-quality palliative care, psychological support, and pain management. The role of physicians should be to instill hope and meaning, to optimize palliative care, not to give up on those most in need. Third, assisted suicide dangerously alters societal values as it gains momentum. In jurisdictions with assisted suicide laws, the number of lethal prescriptions dramatically increases over time, while eligibility for assisted suicide broadens to include non-terminal illness and psychiatric conditions. As assisted suicide becomes a societal norm, the solution for the challenges and injustice facing the most ill or troubled shifts away from addressing the challenges and towards eliminating the people who face the challenges. Those who claim there is no slippery slope are simply incorrect. Assisted suicide is an obsolete and aggressive policy, a remnant of the last century. Maryland should be seeking progressive 21st century solutions that provide hope, care, and quality of life, not discrimination, marginalization, and death. Thank you.
I am Sandy Natina, and I am a nurse practitioner. I have worked as a nurse practitioner for well over 30 years, mostly in primary care, but also in as my own business now, making house calls for people who are homebound with various illnesses and the elderly. I have found that offering individualized palliative plans to people is extremely effective. I can prescribe comfort medications, pain medications, other symptom controlling medications, bring in resources, emotional support, and just a lot of education to the family and to the patient to really increase their quality of life right through natural death. When I do bring in the home hospice team, we have a whole professional team of people that do come in and are available to the patients and their families. And this is during their illness, their death, and after their death as well. The grieving component of the family after death is very important to offer them some services as well, which Senate Bill 845 would not cover. I have found that despite what people say are the main reasons for needing this policy of Senate Bill 845, being that people don't want to be a burden, or they feel like they would be losing their their autonomy, their self-control, their individualism, all of these things, their dignity. I have not found that to be true in my wide experience with the dying. I find that the family and the loved ones cherish their time with them. They do not feel that the dying person is a burden. And I find that the dying person maintains their dignity and their sense of self and their control until natural death. During my career, I've walked with many people on this journey, and I feel like we have a little work to do. We need to expand hospice and palliative care focused treatments. We need to increase, our medical advancements for medications without side effects. And we need to increase socioeconomic support systems as well. Do we want to be the state that just gives out the lethal prescription, or do we want to be the state that teaches the next generation how to care, human caring? Thank you.
Thank you very much. Questions from the committee? Seeing none, thank you all very much for sticking it out with us tonight. Thank you. All right, we'll now hear from Laura Jones, Tom Jones, Becky Ford, and George Gayano. Welcome.
Thank you for this opportunity to speak with you tonight. My name is Laura Jones, and I live here in Maryland. And tonight I'm going to tell you a little bit about another member of our family. In past, I've always talked about our daughter and my mother-in-law. But I want to tell you tonight that dying early before your time may be the worst type of death. My father-in-law died that way. He was diagnosed with pancreatic cancer and was given 6 months to live. But we had a second opinion from another doctor and found out his cancer did not spread, and he qualified for a Whipple procedure. He lived another 10 years cancer-free before he got another form of pancreatic cancer. After he had lived 10 years, then he lived another year and a half before he became short of breath and went to the ER room. That's when he came face to face with a doctor who had plans to help him die early. The doctor said he should have a pacemaker put in. He said it was a simple procedure, no problem, maybe really quick. But my father-in-law ended up in the intensive care. For 2 days, we waited for that doctor to come back, and he never came back to answer any of our questions. I saw him in the cafeteria and I said, "Hey, you're the doctor who put the pacemaker in my father-in-law, and he's not doing well. And we have some questions for you." And he said, "Your father-in-law was a sick man. He was going to die anyway." I said, "Why did you put a pacemaker in him then?" And he just walked away without answering my question. He never did come back and talk to us. My father-in-law died the next day. It was a day we were scheduled to take him home to be on hospice. It was a day before his birthday. Our children never got to say goodbye. And this callous doctor robbed us of the last family birthday we had together. That was the day I stopped trusting doctors. Some doctors have preconceived notions about their patients' quality of life. This law would empower them to help them to their death. Thank you.
Mr. Chairman, Mr. Vice Chair, and committee members, thank you very much.
just following up on my wife Laura's thought there. No, obviously the problem here is that the doctor and his outlook can have a significant impact on which way they would steer their patient in terms of the options they want to go. You have my written testimony. I'd like to focus on 4 key points. First of all, as Laura mentioned, when we first became involved with this in 2016, it was really out of concern for our daughter, who suffers from mental illness, who was suicidal. We were worried about 2 things. Passing this law, 1, would lead to an increase in suicide rates. Secondly, that this bill or law would be broadened in terms of access over time. It would eventually include the mentally ill. Both of those concerns, as we look nationally, have come true. So first of all, I would like to address Senator West, your question about increases in suicide rates. So there are a lot of statistics out there. There was a very good paper that was done in 2015 by Dr. Jones and Dr. Patton. There's a lot of math in it, and frequently it is misstated that that paper shows there's a statistically insignificant increase in suicide rates. I've actually corresponded directly with the author. In my written testimony, pages 3 through 5, you have the email chain where I bring up some of the mathematical issues with it. I'll point out that he says in his email, he says, I agree that it would not be accurate to claim on the basis of our paper that there's no correlation between physician-assisted suicide laws and non-assisted suicide rates. Indeed, I believe it would be misleading. So 6.4 is the number. Secondly, the extension of this law to anorexia is going directly down the route that Laura and I were originally concerned about. It's only happened in a couple places, and I'll point out Compassionate Choices has come out on their website and said this is not what the law was meant for. But to your point about where do we hear these cases, Senator West, we don't, because it's not enforceable. There's been no repercussions for the psychiatrist, as you heard, that misused this law on someone with anorexia nervosa. In terms of coercion, similarly, I would just reference you to the case of Thomas Middleton in Oregon. We know that he suffered real estate fraud after his death through the Death with Dignity Act. It can never be proven that his caretaker forced him to do that because there's not the transparency in the law to allow that. Thank you very much.
Thank you very much, Mr. Jones.
Thank you, Mr. Chairman, members of the committee. My name is Becky Ford, and I strongly oppose Senate Bill 845. I know what it is like to have a chronic diagnosis. No, it's not fair. And I can't always do everything that everyone else can. But I know how hard it is. And I, like so many others with any chronic diagnosis, and even those with terminal diagnoses, am a pioneer. Maybe life is harder for certain people, but it's those people that help advances in healthcare. It's those who take on that suffering, whose strength is relentless, that will help save lives or make things better for those who get the same diagnosis in the future. But I too know what it is like to want to give up. Physician-assisted suicide is not the answer. It's permanent and it cannot be changed. I know this because I have chronic major depression, anxiety, and PTSD, and I am a multiple suicide survivor. In April 2011, police were called to my home by my psychiatrist. I thought they were there to see my dad, a natural resource police officer. I had taken a bunch of pills and I drank a lot. My psychiatrist told them to look at my phone and the long list of texts that I had sent him. And the very last text apparently said, I'm dead, so very dead. My father was called by headquarters and he rushed home to find officers he taught in the police academy. And I never felt ashamed for doing such a thing to embarrass him. It's called a Section 29, and you're forced to go to the hospital. And that's how I ended up in Dorchester General. My medication was increased and things got better. I did it once again in May of 2013. And there have been times that I have been suicidal or had suicidal ideation more recently, including when my best friend who fought long and hard from stage 4 pancreatic cancer. Suicide is not the way out. It leaves people behind wondering why. If I had succeeded, I'd missed out on so much. I'd have left a family behind and a boatload of things on my bucket list. For those who think this is death with dignity or compassion care, no. It's death that's fast and permanent, and there is regret. I absolutely regret the choices I made giving up. I'm worth something, even when I don't always feel that way. And I'm thankful that I'm still here to advocate and pester on the issues that matter most. We are allowed to feel messed up inside and out, but it doesn't mean we're defective. It just means we're human. Thank you.
Thank you, Mr. Chairman and members of the committee. My name is George Gano, and I am in opposition to Senate Bill 845. I have a family member who suffers from mental health issues. With help, she leads a relatively normal life. If this bill becomes law, people with mental health issues will be at greater risk of suicide. I have 4 concerns about this bill. The first, there are no real safeguards against coercion. No witnesses are required at the time of suicide. My family member is easily influenced by toxic people. What is to stop someone from coercing her into taking her own life? There are no safeguards for the poison. My family member has had roommates in the past. Suppose the roommate brings home a prescription for this bottle of poison. My family member gets depressed, she could find it in the medicine cabinet, ingest it, and kill herself. In other countries, these laws expand quickly. You can't give a right to only a certain class of people. Depression and other mental health conditions are treatable. Suicide is not a solution. And finally, insurance companies will use suicide to save money. My family member will require medical care for the rest of her life. This care costs money. Our healthcare systems are already strained. Suicide will always be the cheapest option. In conclusion, Maryland should work to alleviate suffering, not to eliminate the sufferer. I urge an unfavorable report. Thank you.
All right, thank you very much. Questions from the committee? Seeing none, thank you all. Thank you all for staying here the other night, and thank you for sharing your story. Thank you. All right, next we'll go on to the next panel, Robert Nelson, Ian McIntosh, Deborah Ricardo, and Debbie Ryan.
My name is Robert Nelson, a trustee at the Maryland Family Institute. I believe that every life is precious and is a gift from God. Dr. Peter Saunders, CEO of the Christian Medical and Dental Association, covering over 60 countries, states the Bible tells us that human beings are unique among God's creatures and being made in the image of God. And it is on this basis that God introduces to all humankind the death penalty for murder. The prohibition against killing legally innocent people is later formalized in the 6th commandment. You shall not murder. Euthanasia clearly falls within this biblical definition. There's no provision for compassionate killing, even at the person's request. And there's no recognition of a right to die, as all human life belongs to God. Suicide and assisted suicide is therefore equally wrong. Dr. Paul McHugh, former psychiatrist and chief at Johns Hopkins Hospital, said, scientific publications from oncologists who study patients with painful cancers reveal that most cancer patients want help with the pain so they can continue to live. Suicide is mentioned only by those patients with serious but treatable depressive illness, or by those who are overwhelmed by confusion about matters such as their burden on loved ones and therapeutic options. These patients are relieved when their doctors attend to the source of their psychological distress and correct them. My own personal experience is that estimates of length of life with a terminal disease are inexact. My mother was given 2 to 6 months to live. She died at home 3 years later, being lovingly attended to by my dad. In 2013, my wife of 42 years was diagnosed with an aggressive cancer, and I was present when she died very peacefully with palliative care in the hospital. All life is precious from the moment of conception until the last breath of natural death. Now, I've seen hundreds of times the Lord does miraculously heal. And there have even been reports of people being raised from the dead. Let's not get in the way of divine intervention and healing. Please vote in opposition to SB 845. Thank you.
Good evening, remaining senators on this committee. My name is Deborah Bricado. I'm a lifelong resident of Maryland. My father suffered emotionally, psychologically, and physically at the hands of his father. As a result, he suffered from depression and alcoholism. When I was 22, my father took an industrial strength electrical cord and hung himself. My father needed appropriate treatment, which he sought but did not receive. His suicide was not the solution for his depression or his alcoholism, and certainly it did not help our family. We were devastated. Killing yourself is a result of despair, not the decision of a healthy mind. Unfortunately, people can and do choose suicide every day. According to the CDC, there were over 48,000 suicides in 2021. That's 132 suicides every single day. In other words, people can and do kill themselves without a law to do it. And there are many ways to do it, including taking medications that are easily found around the home in high dosages. Do not normalize suicide by passing this bill. Do not turn killing into some kind of healthcare choice. In contrast, with 2 toddlers and being pregnant, I cared for my mother during her cancer battle. She was total care for the last 3 months of her life. Her pain was well controlled, but she refused pain meds so she could live, not sleep until she died. My mother was not a burden. I cherished that time I had with her. There are millions of people in healthcare dedicated to helping those who are suffering, whether it's emotional, psychological, or physical. Do not turn these professionals into executioners. Promote compassionate and appropriate treatment for those who are suffering. Turn away from the callous act of assisted suicide. Please give Senate Bill 845 an unfavorable report. Thank you.
Good evening. My name is Ian McIntosh, and I work for the Patients' Rights Action Fund. I'm a Canadian immigrant and a person with a non-terminal disability, and I speak with firsthand perspective to the dangers of legalizing assisted suicide in the U.S. Proponents will advocate to expand safeguards they promise to keep because they always do. Far from exaggeration, it's protocol. As J.M. Sorrell, Executive Director of Massachusetts Death with Dignity, recently said, once you get something passed, you can always work on amendments later. Proponents also claim that Canada has no bearing on the American statutory map, but in 2015, Barbara Coombsley, former president of Compassion and Choices, cited Canada's entry into euthanasia laws as the example to follow. And interestingly, Dr. Thaddeus Pope, a Fulbright scholar at the University of Ottawa in recent years, currently sits on Compassion and Choices Dementia Advisory Board. Interesting in that this past January, 1 week after a subcommittee in the Virginia Senate voted across party lines to reject the proposed bill and join the other 40 states without assisted suicide laws, the Alzheimer's Association terminated its brief 2-month educational relationship with Compassion and Choices, citing reasons such as due diligence and noting that, quote, research supports a palliative care approach as the highest quality of end-of-life care for individuals with advanced dementia. If, as proponents claim, that assisted suicide laws will remain rare and for terminal cases only, and that the assisted suicide laws in other jurisdictions have nothing to do with their actions, why campaign the Alzheimer's Association? Why have an active dementia advisory board proximate to the Canadian government's advancement of mature minors and advanced directives as other categories of eligibility, if not with the express intention to expand from terminal disabilities into non-terminal disabilities and to make what was promised to be rare into something often and constant? If Dobbs is of concern as proponents occasion, please reconcile the premise of choice with campaigning a disability organization whose protected members lack the capacity to choose. Only people with disabilities die from assisted suicide laws, but not a single national disability rights organization supports assisted suicide. The most prominent example of the many in opposition is the National Council on Disability. Since the Clinton administration, this independent federal agency that first advised and drafted the Americans with Disabilities Act has strenuously advised state and federal policymakers against the legalization of assisted suicide because of its unique dangers to people with disabilities. Or as NCD concluded in its 2019 report on assisted suicide laws are premised on the notion of additional choice for people at the end of their lives. However, in practice, they often remove choices when the low-cost option is ending one's life versus providing treatments to lengthen it or services to improve it. The right to choose begins with access to clear and trustworthy information, but the language of assisted suicide and euthanasia always deviates from assurances sold. Safeguards become barriers, terminal becomes chronic, and eventually non-terminal. Rare graduates to accessible, and adults expands to include mature minors, as evidenced in the Canadian Parliament's most recent study for recommendations. I urge you to follow the Alzheimer's Association's responsible vetting process, to take the time needed to listen to the others in the disability civil rights community and focus first on policymaking for supports and services to help Marylanders with disabilities live, rather than ignite these dangerous discriminatory expansionary laws. Please find SB 845 the unfavorable bill that it is. Thank you.
Thank you very much.
Hi, my name is Debbie Ryan. I live in Garrett Park, Maryland. I am a nurse and a nurse practitioner. As a child in the 80s, my parents would take us to visit my grandfather in the hospital. He was dying of cancer. I remember witnessing the nurses and the compassion and love that they gave to him as he was dying of cancer. They kept him comfortable and until he died peacefully. It was then that I knew I wanted to be a nurse. Now, as a nurse with 30 years of experience, I can tell you what it means to be a nurse with compassion. It means having the courage to place an IV in a dying veteran's foot because he's out of sights to control his pain medication. It means comforting a dying veteran as he awaits his long-lost brother's arrival, and then witnessing his peaceful death, knowing he was able to reconcile with his brother. It means returning to work every day during the COVID pandemic, despite knowing the risks to oneself, and being reminded every hour by the overhead PA system of code blues going off that somebody was dying every hour. It means wearing a mask in public and being an early vaccine adopter during the pandemic, because there's a chance those two things would protect our patients. And it means attending to the mental health needs of these vulnerable patients, because we know that 95% will change their mind against assisted suicide when their depression is addressed. That information comes from Sloan Kettering in New York. And it means taking a stand against assisted suicide so those same vulnerable patients that we cared for during the pandemic so painstakingly and meticulously won't be goaded into taking this lethal prescription. And it's to remind people of the true meaning of compassion, to suffer with, rather than the hijacked term that the lobbying group Compassion and Choices uses to make you believe that assisted suicide is the compassionate choice. It is not. And I tell you what a compassionate nurse is not. Pulling from this medical aid in dying guidebook, a compassionate nurse is not what it tells me to do on pages 54 and 64, which mean that on page 54, a nurse can insert a tube for the use of this medication so that the person can self-ingest. 64, a hospice staff member, that would be a nurse, can mix the drugs for the patient so the patient can ingest them. And while I'm talking about this book on page 69,
Ms.
it
Bryant.
goes ahead to say that the patient should have somewhat of a cheerleading squad at their deathbed. I ask you, how is having a cheerleading squad on your deathbed to take this medication in the required amount of time not coercion?
Thank you very much, Ms. Ryan. Thank you.
I would say assisted suicide is
Ryan.
not compassionate
Thank you
care,
very
nor
much.
is it nursing care.
More important, thank you very much for your service as a nurse during the pandemic and for being pro-vaccine. So thank you very much for that. Questions from the committee? Excellent. Thank you for being here. And thank you. Look, I'm being a little elastic on the time, but the time is important just because I don't want to afford another one set of witnesses more time than the other. So just in the interest of being fair to everybody that's waited all day, we try to stay to 2 minutes. I wish we could stay here all night. Say with 80 of our closest friends, but seriously, you've waited a long time, and so I want to make sure you get your testimony in. But just out of respect for everyone else, we try to keep everyone to the same amount of time. Okay, we'll go to the next panel. Martha Shear, Meg Quickle, Frank Arlinghas, and Mary Hand.
In the interest of time, I'll go first. My name is Dr. Frank Arlinghouse. I'm here to ask for an unfavorable report on Senate Bill 845. My written testimony is more extensive and makes a case for both opposing the bill and for amending the bill to provide protections for certain groups. Anything that you see in there, anything I refer to, I encourage you to make me justify and send you references. I'm happy to do so. A couple of main points. Vulnerable populations are at risk. There's an economic incentive for insurance companies to pay for someone to end their life and not cover life extending treatment. This leaves poor and disabled populations at risk. And we're seeing a push toward this in Canada. I also can provide references to a case in Oregon, Michael Freeland, I can provide cases, but that's not the right one. National Council of Disabilities document that was previously referred to, November 2019, gives a 70-page extensive layout of examples of many of the things I talk about. Quality of life that's used for many of these decisions is designed to be biased against those vulnerable populations. Those with physical or mental challenges will be at greater risk for coercion. The mental health protections are inadequate. In 2017 in Oregon, over 200 people killed themselves by these means. Only 5 were referred for counseling. In 2021, it was only 2, even though the number of people had increased by almost 50%. A British Medical Journal study of Oregonians showed that Oregonians with depression were receiving lethal drugs. Their study of 58 people showed 26% were indicative for depressive disorder, 22% for anxiety disorder. The bill sends an ambiguous message on suicide to our youth and the rest of society at a time when suicide is increasing across the country and at greater levels in PAS state. Oregon has increased between 1999 and 2010, 41% above the national average when it used to be average. And since then, it's increased between 2011 and 2019 by over 200 suicides, not counting the increase of 200 people who kill themselves in that state. Thank you.
My name is Martha Scher, and I would like to highlight 2 reasons to oppose SB 845. First one's we don't know the value of our own lives. and I apologize if you've heard my story before, but I don't know who's new on the committee. About 25 years ago, I helped provide some adult daycare for Dave, a member of our church community, so his wife Winnie could work long enough to qualify for full retirement. Dave had muscular dystrophy and couldn't take care of his personal needs any longer. So for about 2 years, we took turns for an hour a day, feeding him lunch, emptying his catheter bag, changing his diaper sometimes, and reading inspirational articles aloud. Although certainly humiliating for Dave, he didn't complain, but I'm sure it was. It was a powerful, positive experience for the rest of us. We learned unselfishness as we watched Dave sacrifice his dignity so that his wife could have a better retirement. We learned how spouses help each other in taking on a few of Winnie's tasks. And we taught these lessons to our children, our grandchildren, and Dave had no idea how much his life changed ours and our grandchildren. So we don't know how much what we do matters to others. And as difficult as it was for Dave, it would have been even harder had he had the option of ending his life deliberately early, I believe. 20 years ago, when I was diagnosed with multiple sclerosis, I worried about the prospect of a dependent and unproductive life, and worried that the strain would ruin my husband's health or my family's health. You wouldn't have had to make me feel guilty for ending my life early. I saw the consequences and would have a hard time, taking them. I'm not there 20 years later. It's a great blessing, but I think calling what I call suicide or the deliberate ending of someone's life an end of life option grants a legitimacy that will increase suicide rates and make it harder to accept the kind of difficult support that family and friends are willing to give and learn valuable lessons from. Thank you.
Thank you very much. Questions from the committee? All right, seeing none, thank you all very much for hanging in there with us. All right, who do I have left? Is Nancy Peltel? Yep. And Laura Jones, did they get Laura Jones? Okay, got it. Laura Bogley. Nancy Weissman. Dana Schultz. Nancy Weissman. Shoanna Faith. Is Miss Faith here? Okay, got it. All right.
Thank you, Mr. Chairman, members of the committee. I'm Dr. Nancy Paltel, here in opposition to Senate Bill 845. In opposition because this bill is dangerous and unnecessary. First, it's unnecessary. 15 years ago in Maryland, my brother-in-law committed suicide in just the way described in this bill. He went to a doctor, he got a bottle of pain pills, he took them home, he ingested the entire bottle all at once and committed suicide by overdosing on pain pills. He did this in Maryland. He did not need Senate Bill 845 to help him. It's unnecessary because suicide is legal in Maryland and it's widespread. From 2000 to 2018, the number of suicides in Maryland has increased by 37%. And if a suicidal person wants to end their life by a method other than that described in this bill, you can see my written testimony for a link to a website that will explain to Marylanders a myriad of other ways that they could commit suicide, all of which are already legal in Maryland. This bill is dangerous. Every one of you who was on the Senate last year voted for Senate Bill 94, which was the Maryland Suicide Fatality Review Committee. It passed the House and the Senate unanimously. Okay, the purpose of the bill was to study ways to prevent suicide in Maryland. We all agree suicide is a tragedy. It is not healthcare. Many years of data from Oregon show, yes, there is data. once you start legitimizing suicide, once you treat suicide as acceptable, once you make it healthcare, and make no mistake, this bill treats suicide as healthcare. The suicide rates in the general population do increase. This is not a phantom fear. Okay, it's supported by data. I'm a PhD research scientist. I look at data, and you should look at data too. Look at the Oregon Health Authority. I spent some time on their website. Just 10 years after Oregon had legalized physician-assisted suicide, their conventional suicide rate was 35% above the national average. So in conclusion, I would say you don't want to increase suicide. That is exactly the opposite of what you said when you voted for Senate Bill 94. Suicide is a tragedy. It is not healthcare. Please give this bill an unfavorable report. Thank you.
Thank you, Chairman Smith, members of the committee. I'm Laura Bogley, Executive Director of Maryland Right to Life, and we oppose this bill that would give doctors in Maryland a license to kill their patients. Why would a doctor who has sworn an oath to heal need a license to kill? The answer is simple: for the money. According to Derek Humphrey, founder of the Hemlock Society, the precursor to Compassion and Choices, quote, economics, not the quest for broadened liberties or increased autonomy, will drive assisted suicide to the plateau of acceptable practice, end quote. The proponents themselves are telling you that assisted suicide is about profits, not patients or individual choice. Assisted suicide laws shield doctors and insurance companies at the expense of vulnerable patients and reduce the standard of medical care for all of us by redefining what is an acceptable medical practice, including rationing life supports, as we saw so profoundly during COVID, where people were denied care against their family wishes or even their medical directives. So just some stats you should be aware of about what's going on nationally and in other states. All 50 states prohibit euthanasia as homicide. 41 states, including neighboring states Virginia, Pennsylvania, and Delaware, consider assisted suicide illegal. In Maryland, assisted suicide is a felony under the criminal law article. And there already is direct precedent in the Supreme Court of the United States, who ruled unanimously that there is no constitutional right to assist in suicide and there is no constitutional right to die. So this issue is too important to replace facts with divisive politics. Dobbs' majority decision is limited to an abortion right, period. It does not apply to euthanasia. Don't believe the death with dignity fairy tale? Assisted suicide is a nightmare from which this state may never wake up. We urge your unfavorable report. Please put patients before profits and keep assisted suicide in the criminal code where it belongs. Thank you.
Thank you for having me all day today. My name is Dana Schultz and I'm from Anne Arundel County. I'm a combat veteran and I fought and my friends died to protect our lives, not to kill each other. My dear mother passed into heaven March 4th, 1996, 27 years ago, almost to this day. She fought a difficult battle against cancer, including end-of-life care and hospice. She never gave up, and her family loved her to the very end. I am so thankful I had every second that I had with her. I understand families' desire to decrease and end suffering for their loved ones. Marylanders want to celebrate life and the value of each life at every single second of that life. Don't listen to the people that came in and testified from outside of Maryland. Marylanders don't want this. We don't want the assisted suicide pervasive culture of death, which unfortunately spreads and reaches in to steal life from unsuspecting, medically fragile members of society and their families. The Powell Center for Medical Studies, I submit many facts. A large number of non-terminally ill persons are given lethal prescriptions where assisting suicide is legal. Insurers have and continue to deny life-saving medical treatment. My mother was denied life-saving medical treatment because it was too expensive. But they will cover cheap, lethal drugs where assisting suicide is legal. There's numerous complications that can and will occur. Listen to the data from Oregon. A request for assisted suicide is typically a cry for help. Health officials are actively encouraging people with disabilities and other chronic medical issues to consider suicide. According to Associated Press, hospitals are raising the possibility of assisted suicide with patients who hadn't asked about it. These conversations are not motivated by quality of life, but health care costs. Alan Nichols had a history of depression and other medical issues. He committed euthanasia. His application said hearing loss. He died because he had hearing loss, and his brother said Alan was basically put to death. Please, I beg you, do not bring this culture of death any further into Maryland.
Excellent. Thank you very much. Questions from the committee? All right. Thank you all very much. Thanks for hanging in there with us. Thank you. All right. Is Deborah Yatzek here? Have I missed anyone here that would like to testify in person? All right, we have a couple of virtual participants that we'll call in now. Can we get the virtual participants in?
Yeah.
All right. Mary, are you there? Can you hear us?
Yes, I'm there. Can you hear me?
Yes, we can. Welcome. You're welcome to testify now. You're up.
Thank you, Mr. Chairman, committee members. In my career as a nurse, I've worked with physicians in hospitals, the military, and on government committees. The proposed end-of-life option bill threatens long-held medical practice and standards of ethical care and has consequences that extend to other healthcare professionals. The bill distorts the role of physicians as healers who seek to do no harm and undermines the trust between doctor and patient. The American Medical Association has reaffirmed its opposition to doctor-assisted suicide. Medical aid and dying proponents want the terminally ill person to be able to make the decision about when and how to die, but it is far from an autonomous process. It involves it requires physicians, pharmacists, and nurses to operationalize the process irrespective of their beliefs. Rather, we should be advocating for equality of care that seeks to offer the same access to healthcare regardless of their health condition. There's an urgent need for greater awareness and use of palliative care and hospice care, especially among minority populations and the underserved. There are documented in the literature racial and ethnic disparities in use of palliative and hospice care that should be a clarion call for more inclusive policies. And finally, medical aid in dying does not ensure a smooth, predictable day of death. A guidebook I have the opportunity to review by a medical aid in dying doctor recommends that a skilled clinician, commonly a nurse, be present because of the complexities of mixing and handling the lethal potion. There's patient anxiety that needs to be dealt with, the need to support the patient with the potion's side effects, difficulty swallowing the bitter and intensely burning drink, and a range of times of death from 2 to 20 hours. And children and pets cannot even be around. So we encourage more awareness of palliative care and hospice care because they're sanctioned options that do not require doctors, pharmacists, and nurses to be accomplices in a patient's death. Thank you.
Thank you, Ms. Hand. All right, we'll hear from Ms. Ortiz next. Welcome.
Good evening, and thank you for this opportunity. My name is Melissa Ortiz, and I have the honor of serving as the Senior Advisor of Able Americans, a program of the National Center for Public Policy Research. I am here today as a resident of Chevy Chase, Maryland, to beg you for an unfavorable report for Senate Bill 845. I have read the legislation in its entirety. It is neither ethical nor moral, and it does not truly help people who are suffering with terminal illness, much less those with chronic illness or disability like me. The intended consequences are clear. asking those whose job it is to heal people to become killers as they quote unquote help people who are thought to be terminally ill to end their own lives. The unintended consequences are far-reaching applications that could be brought into play if the government decides to reinterpret the law or allow for exceptions of self-determination through medical proxies. The unintended consequences are something I have personally experienced. I am a cancer survivor, and I have spina bifida occulta with hydrocephalus. That combination is not a good one to have in the place I used to live until a few months ago, where end-of-life options are legal. Pressure is brought to bear, albeit subtly, to choose the less expensive option, to choose the option that takes the burden from family and friends. It was brought to bear on me more than once when I was lying in a bed in the hospital when my advocates were not around. Fortunately, I am a strong self-advocate with a great support system. I refused those options and I got the treatment I needed. I am here to tell the story. But what about the most vulnerable among us who are not as able to self-advocate or do not have a strong support system? Someone must speak for them. Fear of being coerced into making an unwanted choice could cause a person not to seek medical treatment or to put it off until there is no hope of recovery. While the advances in palliative care are amazing, there is no need for physician-assisted suicide. Agony does not have to be a part of dying. Having been with several relatives in palliative care hospice, I can safely state that their dying process was pain-free and calm. It was even serene. We have scientifically divorced ourselves from making necessary moral and ethical choices in the medical field. This is nowhere more evident than in the rise of so-called compassionate caring laws known as medical aid in dying. The patient argument for patient autonomy is hollow at best because it causes harm to the patient that the doctor is expected to participate in helping them die.
Mr. Ortiz, if you could briefly conclude, just run over time.
I'm sorry.
No worries.
Ultimately, through all of this, the relationship is sullied. The human life is a cost, a life that mattered and had something to offer from its conception to its natural death. Thank you, Mr. Chairman, committee members. Please offer an unfavorable report.
Thank you very much. All right, next we'll hear from Anita Cameron. You're up.
Thank you. Good evening. I'm Anita Cameron, Director of Minority Outreach for Not Dead Yet, a national disability rights organization opposed to medical discrimination, healthcare rationing, euthanasia, and assisted suicide. I'm writing and I'm speaking in opposition to SB 845. This bill is dangerous because though this law is supposed to be for people with 6 months or less to live, doctors are sometimes wrong about a terminal diagnosis. My mother, while living in Washington State, was determined to be at the end stage of chronic obstructive pulmonary disease and placed in hospice. Her doctor said that her body had begun a process of dying. Though she survived 6 months of hospice, my mom moved home to Colorado to die. My mom didn't die. She became active in her community and lived almost 12 years. SB 845 will put sick people, seniors, and disabled people, especially at risk due to the view of doctors that disabled people have a lower quality of life, therefore leading them to devalue our lives. Now add race and racial disparities in healthcare to this. Blacks in particular receive inferior healthcare compared to whites in the area of cardiac care, diabetes, cancer, and pain management. Proponents speak of pain as their number one reason why they want assisted suicide, yet according to the data, pain or the fear of pain was not among the top 5 reasons people seek assisted suicide. That can be addressed by effective pain control, palliative care, hospice services, and palliative sedation. Assisted suicide laws are deadly public policy. As long as disability discrimination and racial disparities in healthcare exist, assisted suicide has no place in Maryland. Please vote no on SB 845. Thank you.
Thank you very much. Mr. Pavola, you're up. So I think you're still on mute. If you could just unmute yourself, then we're ready to go.
Thank
There
you
you go.
for correcting. Can you hear me now,
We
Chairman?
can. Yes.
Thanks so much. Matt Pavel is my name. I'm a trial lawyer for over 40 years. I'm a member of the Maryland Association of Justice, in fact, on their legislative subcommittee. But I want to make clear, I am testifying today as an individual attorney against 845, SB 845, not in my capacity with MAJ. The reason I'm opposing this and would ask this for an unfavorable vote is that it unnecessarily immunizes. It relieves physicians of responsibility. On page 17 of SB 845, you'll see some extensive language there that doctors are not held accountable either criminally or civilly for errors that are called neglect. And that's just not necessary. Doctors are accustomed to being held to the standard of care of a reasonable and prudent physician under similar circumstances, just like lawyers. We're held to those standards. Professionals know that's part of where they go, the world they live in. Why protect them unnecessarily? It just doesn't make sense. It's not needed. I would urge this committee to look at that provision and refine that, if not kill this bill altogether. Quickly, I will mention at the very end, there's some confusing language that talks about a willingness to allow doctors to be held accountable, but it's very vague, one sentence language that under the rules of construction, statutory construction, the very specific information saying that they are relieved of responsibility on page 17 would override that vague sentence at the end. So for those reasons, I would ask for an unfavorable vote. Thank you very much for this opportunity.
So thank you very much. Thanks for hanging in there with us. All right, Ms. Christensen, you're up.
Hi, my name is actually Dr. Sandy Christensen. I'm a board certified physician licensed in Maryland and National Medical Director of CareNet and the Director of the Maryland chapter of the American Academy of Medical Ethics. I oppose SB 845 because it bankrupts the doctor-patient relationship and promotes a culture of death with a devastating ripple effect. Our duty is to eradicate pain, not the patient. To give the physicians power of this nature is an actual fundamental conflict of interest. If legalized, patients won't know if their doctor's ultimate motive is to heal them or to end their life. It makes the doctor's judge, jury, and executioner, violates the sacred covenant between the doctor and the patient to first do no harm. Physicians are healers, not killers, and patients' trust in physicians will be eroded, and it gives way too much power to physicians. Further, physicians' rights to practice in congruence with their moral construct and framework is jeopardized, and physicians are in fact not vending machines to dispense a requested product. Further, this has been mentioned, but it allows physicians' biases to enter into life and death decisions. Studies show that physicians perceive disabled people to have a lower quality of life compared to how the disabled actually view themselves, and this is a problem. Finally, it elevates and normalizes suicide as a viable solution in a society where teen suicide is rampant, and it promotes the demeaning attitude that human frailty and incapacity strip us of our dignity, which is not true. My mother had dementia and spent the last days of her life in the Klein Hospice House in Maryland, where she received exemplary care and pain management without hastening her death. She died peacefully and naturally, which was a tremendous comfort to our family. While it may be in the state's financial interest to allow people to kill themselves, it is the antithesis of the purpose and practice of medicine and should never be a part of healthcare. I do ask for an unfavorable vote on SB 845. Thank you for your attention.
Thank you, Dr. Christensen. You want to be called doctor? You got called doctor? You earned it. Thanks for being here. All right.
Okay.
All right. Questions from the committee. Seeing none, thank you all very much. That'll end the testimony for the opponents of the bill. We have one more guest, Mr. Diaz, who was here earlier but got kicked off. He is a proponent of the bill. Mr. Diaz, welcome.
Thank you. Thanks for this opportunity. My name is Dan Diaz, and I am Brittany Menard's husband. Brittany died on November 1st, 2014. She was only 29 years old. Brittany experienced a gentle dying process only because of the option of medical aid in dying. Yes, my wife utilized the very program that we are here discussing today. I am testifying in support of SB 845. Brittany's case received significant attention because we had to move from our home in California to Portland, Oregon, just so that she could use Oregon's law. Had we stayed in California at that time, the brain tumor would have essentially tortured her to death. So in contrast to the hypotheticals and sometimes the false narratives that the opponents try to attach to medical aid in dying, I've actually lived this experience. To be clear, a terminally ill individual that applies for this option, they are not giving up, they are not suicidal, and they are not deciding between living and dying. The option of living is no longer on the table. The opponents seem to ignore that. A terminally ill Marylander that is in Brittany's predicament, the only option they have is between two different methods of dying. One is gentle, the other could be filled with unrelenting suffering. Brittany felt incredibly protected throughout the entire process of applying for this option because getting through this process is not easy. These safeguards are real. I want to emphasize the importance of palliative and hospice care. Brittany's team played a huge role. They were so significant in helping to try to keep her comfortable. But modern medicine cannot control pain and suffering in all cases, period. Any assertion by anyone that they can control suffering in 100% of the cases, that is patently false. I can line up physicians, nurses, hospice care workers to refute such a misplaced and arrogant claim. The people of Maryland deserve better than what Brittany had to endure. No one in Maryland should ever have to leave their home and move to another state in order to ensure a gentle dying process. And if there's any questions, and I've heard certainly a lot of things attached to this, feel free to ask. As I mentioned, I've been through this process.
Thank you very much, Mr. Diaz, and it's a pleasure meeting you a few weeks ago. It's good to see you. Questions from the committee? Seeing none, thank you, Mr. Diaz. It's been a long night, and I really appreciate you hanging in there with us. With that, that'll conclude the testimony and the hearing for Senate Bill 845 and our hearings for the evening. Have a good night, everyone.